Sir, you're charged with especially aggravated kidnapping. You're also charged with aggravated assault, and you're charged with theft of a firearm worth less than $2,500.
You're talking about stuff that is not relevant.
Hello and welcome to the Court of Public Opinion. I am the recovery addict, and boy do I have a case for you today.
Why is the dog chewing on this guy?
I think they have got the wrong guy there.
Got the wrong guy, and the dog was biting him.
He roughened him up quite a bit. There's a lawsuit.
This is the next church on February 28, 2020, 7:44 p.m. How, does the FBI find people? The people's misspelled P-E-O-O-P-L-E.
I object.
Did the defendant find out how the FBI finds people in this case? Oh, she found out.
What more do you need to see?
Welcome back to the Court of Public Opinion. I am the recovery addict. Hope you had a fabulous lunch. Oops, there went my chat. Let's bring it back. Gotta give a big shout out to Greeners, who is first in chat today. Congratulations, Greeners. For the bunt kicks of it. They were so good. They were so good. Oh, yes. Wow, we already have 200 likes on the live stream, and we just started. Apparently you like something I'm not doing because you liked it already before I started doing it. So, thank you. Must be good people in chat. That's what you're liking. I had I opened a bag of those those Cheetos pickle fire. Yeah, I opened some of those. They're hot. They're hot. I had some. I was gonna have some salad, but the salad was probably better yesterday than it was today. So I decided we're gonna throw that out. It's seen its prime. So I had some leftover rice-a-roni with chicken and some Cheetos. So, all right, welcome. We are back. Just in a few minutes, we'll be back in court again in just a moment. Back waiting for the judge to come in. We've for those that have missed this morning, it was spicy, it was crazy, it was wild, and it was fast. The state's rested, the defense has rested. There is no rebuttal. When we come back, we are going right into closings. The closings are going to happen first, then jury instructions will be read. Excuse me, and then the jury starts deliberating. Those Cheetos are catching up with me. I think I've got one in my throat. Just a little bit of spice. Cashat, thank you very much for the gifted membership. Thank you. Wonderful to have you here. Hope you're doing fabulous. Baked chicken and roasted eggplant. Chip salsa and chicken quesadilla. Cashat is persuasive. That's why we have so many likes. Cashat has been persuading people. I see how it is. Thank you, Cashat. Pizza burger. Yum. Sounds delicious. Missed a bit this morning, says Sky Mama. Was the FBI the only witness for the defense? Yes, he's actually retired FBI, and now he has his own website, which is called Veracity IIR. He also has a YouTube channel, Veracity IIR. When I looked at it, it had 15 subscribers. It has now jumped to still 15 subscribers, but he has 11 videos up where he talks about various cases there. And he does have some excerpts from news appearances and things like that on there. He's on Twitter, doesn't tweet a lot, but interesting testimony. Paid $10,000, did about 2 years worth of investigation or digging into the investigation for the defense, but did a good enough job that once he was done testifying, defense said, "We don't need to call anyone else. We're good." And so now we're on to closings. Did the FBI guy redeem himself on redirect? No. The problem is the thing I think that the FBI guy did wrong. It was not necessarily his conclusions, because he's just speculating on his belief and what happened. I think what he did wrong was he did not have a firm understanding of pertinent facts of the case. And so when it came time to recount, say, like the timeline of what happened when and when the defendant was there and when she was not there, he had the dates all messed up. And that hurt him. And that was not something that they could really fix other than just give him chance after chance after chance to fix it. So he did what he could, though. He's not going to load his cross-examination to his channel, will he? Probably not. Probably not. Maybe at least not in the totality of it. Veracity. That's what the pirate with a stutter says. Yes. Not only glancing, he had feelings. Yes, he glanced at everything. Had feelings. Did you know a single spaghetti is called a spaghetto? What? Spaghetti is plural? I mean, I guess we use it as plural. No, I did not know that. All right. Kesha is on a mission. We are over 300 likes already. Thank you all. Thank you all who clicked the like button. I will tell you this. Once we get to 1,000, she'll probably ease up a little bit on you. So if you want her to ease up, just get us to 1,000. We'll be fine. Every day people learn new things. Every day. This is true, Jasmine. Thank you very much. What would a single grain of rice be called? Is this a joke? I don't know. Just rice. Okay. The whip will be put away at 1K. The whipping shall cease at that point. All right, we're going to get ready to go to court. It's going to start here in just a moment. Any moment now, we're expecting them to pop their head in and say we're back. Bring the jury. Bring in. We've got our counter set up. 67 is. Oh, that's not the cursive counter. I'm sorry. We're doing Hagar's hammer. There it is. Hagar's hammer of justice. It's the first trial that I don't like the prosecution or the defense. That usually doesn't happen. I like the judge at first, but I got iffy at the end. Virginia doesn't like anybody here. Nobody. This whole case just stinks, right, Virginia? Just giving me a hard time. They are interesting characters, all of them. Lots of personality on both sides. And I think the little snippy attitudes back and forth between prosecution and defense isn't helping anyone. I don't think that helps the jury. Amber Waves of Grain, welcome. Good to have you here. Let's see. Golly G says, I watched season 6, episode 18 of the TV show, and between that and watching this trial every day, my vote is guilty. Has there been a poll yet? There has. We did a poll, and we came up with 58, well, I think it was 59% of, let's see if I still have it. Where are the results? Are they right here? Yeah, here they are. With 687 votes, we had 58% say yes, the state has proven the case, and 41% said no. Or no, backwards. 58% said no, 41% said yes. So we are leaning to the not proven side, or not guilty, as that translates to in our system. Let's see. The defense serving a subpoena to the aunt right after her testimony and then not calling her proves that they did that out of spite and retaliation for her telling the truth and them not liking it. She was probably one of the worst witnesses for the defense because it is family. It is somebody who knew and was very close to the defendant and was testifying for the state against the defendant. A little earthquake in the courtroom. Maybe that means people are walking back into court. It'll be just a moment. We'll be back live again. I think she did it, but the state didn't prove it. I think the state proved that she could have done it. I don't know a better way to put that. The state has proved that she could have done it. I think the burden of proof is higher than that, though. They have to prove that she did it beyond reasonable doubt. Because just simply because they have not found any other suspects does not mean there are no other suspects, right? Because, it could have been, if you have like a row of golfers and all of them are, they've got their clubs and balls and they're ready to go. I don't know why I went with this analogy because I'm not a golfer, so I really suck at this. And you're watching the hole down range, down the course, and one of the balls goes in the hole. It's a hole in one apparently. They're at the driving range, and one of the balls goes in the hole. I guess driving ranges don't have the hole. This is a terrible example. Don't quote me on this. Any one of the golfers could have done it. They have the ball, they have the club, they have the knowledge of how to hit the ball with the club, and they're in the right location for it to be done. But just because one of them could have done it doesn't mean that all of them got a hole in one, or that any specific one got a hole in one. You would need more evidence to actually connect those two pieces together to say it was this golfer. We watched the ball. It was his ball. The ball that went in was the one that's unique. That's only special to him. Or everyone else only had putters. This is the only person who brought a driver that day. A putter can't hit that far. There's got to be something like that connects the defendant with the crime in some way, a little beyond this. Virginia, I love everyone here, she says. Selena K says, my husband left me outside in the wheelchair and went back in the house, kind of a little nervous. I guess I'll watch the trial on my phone. Selena, call him. Say, hey, did you forget something? I'm still outside. I hope you're feeling better. I know that you've been through the ringer recently. I hope that gets better soon. Like your confessions, says Lizzie. We do have some confessions. But I would have to say that not all confessions are equal. Something like I did it. Look at what they say Karen Reed said the morning of the John Keefe's body was found, where some people are saying I heard her say I did it, and some people said I heard her say did I do it. Now, there's a little bit more to this one because we've got the aunt who, along with her husband, testified that she gave them details of the crime, a lot of details. But I don't know. I don't know what to think. I'm not sure if it gets me beyond reasonable doubt, is the thing. All right. She confessed more than once at different times. Well, both of them were from, we've got the ex-boyfriend, Jesse Pinkman, and the girl that drove her home from that party, right? Both of them say that she said, I did it. And then we have her aunt that says she really didn't like her roommate and she deserved it. And then tells the story of speculating on how this happened. Because according to that, if you're believing the speculation as to how the crime happened, Nichole apparently told her aunt that whoever did it cut the screen, climbed into the window, hid in the closet, waited till she got out of the shower, and then attacked her there after she came back out of the shower into her room. But the police are saying nobody went through the screen. So her story is not adding up. Even though she has some of the details of the crime scene, I think some of those details could have come out other ways as people were talking about it. I mean, she still lived in that area after this crime. I understand that she still lived in the apartment. Is that somebody might need to verify that because that does seem weird to stay in the apartment when that happened. But is it possible that the apartment manager or Marty talked about this to other people there at the apartment where they worked, and the word got around? And she found out that she was found stabbed with a bathrobe, covered with a blanket in her bed. We've been wrong before. I might be wrong again. The aunt had the wrong time when she was told. I think we also watch these trials with a different perspective than the jury. We do. Although the jury's seen a lot in this trial, the judge does not excuse them very often. Did the judge ask her if she wanted to testify? Not that we saw, but it could have happened outside of our hearing. Speaking of judge, here he comes. And we're on.
Okay, you ready? All right. All right, we're back on the record. The time is 5 minutes after the hour of 1 o'clock. Today's date continues to be March 25th, 2025. Parties are present along with counsel, and the jury is not present. I'll start with you, Ms. Sorgan. Did you get your new instructions?
We did, Your Honor.
All right. Mr. Sand, did you get your new instructions?
We did, Your Honor.
All right. Anything before we bring in the jury for closing arguments? Ms. Sorgan?
No, Your Honor.
Mr. Sand?
Nothing from us, Your Honor.
Okay. Are both attorneys comfortable with what we're using for closing as far as the well, what they're going to use, the TV, et cetera? I just want to make sure nothing's going to go wacky.
I was just going to have Bill move. I'm sorry, I'll let them go first.
No, she says no. She's shaking her
Okay.
head.
I was going to have Bill move the podium when they're done and I'm up.
Okay. Are you going to try and pick it up like Mr. Nelson? Or just...
No, do you want me to move it now or?
Yes, please, because it'll just be in the way. It's not light, and we appreciate that, so I understand.
Felt light to me, but
yeah. I am going to ask, however, that you move
funny.
it out of the way until the jury. Just move it to the side till the jury. Yeah, yeah. Just move it to the. You're right there. Yeah, just so they can walk by. Sure. That'll be fine.
We want to
Felt
make a
light.
big thing where we move it the whole way when they come out.
Ms. Sorgan, are you going to be using it for your closing?
I don't like podiums, Your Honor.
Okay, then.
I think that sound bite.
I think that'll be fine, Mr. Nelson. Just put it there for now.
there's nothing like there's no cords or anything, so it slides real easy.
Okay.
I
All
don't
right,
like
then.
podiums.
Go ahead and bring in the jury.
What's with the podium hate, Ms. Sorgan?
I really got more carried away than I wanted. Sorry.
Wow, she's angry. I think she's still upset because defense was able to bring in that investigation into the officer, you know, that investigation that just broke right before the case came out. Talk about poor timing for the prosecution. That 116-page document and then the 67-page one afterwards that was it's crazy. I'm going to clip that. I don't like podiums, Your Honor.
Thank you very much. Please have a seat. Ms. Sorgan, do you waive roll call of the jury?
State waives roll call, Your Honor.
Mr. Sand, do you waive roll call of the jury?
We do as well, Your Honor.
Thank you very much. Ladies and gentlemen of the jury, both parties have rested. We are now going to do closing arguments. Ms. Sorgan, do you wish to make a closing argument?
Yes, Your Honor.
You may proceed.
Thank you, Your Honor. You got me, Colette? Okay.
TV on?
Make sure it will be. Little one. Good afternoon, ladies and gentlemen of the jury. Thank you very much for your patience. It's been a long 7 days that we've been here together. Make sure that television's on too. Or not.
This is why the judge asked if you were all good with it.
Now we're cooking.
Now we're cooking.
You've been here listening to testimony for about a week now. There's a lot of information in this case. As you heard from the witnesses, over 6,000 pages of documents, hundreds of hours of audio and video, photographs too numerous to count. So we've prepared a little bit of a PowerPoint here to help consolidate in putting together the state's closing argument. Mr. Nelson. Okay. You were told an investigation is like a puzzle. You heard that from a couple of different people. It's not solved by one person alone. Everyone's got a little piece. Every witness that we presented to you during the course of this past week has had a little piece of that puzzle. Some pieces are bigger than others. All the pieces are important, though.
Where did they source
Some
this,
of those pieces give more information than other pieces do. You're thinking about a jigsaw puzzle, and you're looking at that. Some of those edge pieces have to be laid out first before you start getting towards the center so that you can start seeing what that bigger picture is. Next. You heard from Sharon Knutson, Anita's mom. You heard that Anita was attending MSU to be an elementary teacher after she graduated from Velva High School. She worked 2 jobs, Vanity in the mall and the Fairfield Inn. Anita had a boyfriend in California that she spoke with on the phone. And Anita and Sharon used to go shopping together every weekend, and they spoke regularly on the phone. But that Anita didn't want Sharon to come to the apartment that she shared with the defendant because of the issues that the girls were having.
There's too much info on this page.
You heard Sharon tell you that Anita seemed afraid of Nichole. And that Anita had Sharon put a lock, or had Gordon put a lock on her bedroom door so that she could get away from Nichole when things were getting bad between them in that apartment. Sharon told you that she last spoke with Anita the Friday before she died. That Anita had been out with her friend Michelle. You heard Sharon say that she couldn't reach Anita. She couldn't reach her in person. She couldn't reach her through work. And she became very concerned. And so that when Gordon went to Minot on Monday, she wanted him to check on her. You also heard Sharon tell you about the devastating effect that Anita's death has had on this family, including the suicide of her brother Daniel a few years later. You heard Sharon herself tell you what her own mental state was like following Anita's death, and that she had a lot of blank moments in those instances. Next, please. You heard the testimony from Gordon, Anita's father, that he drove to Minot on June 4th, 2007. I'm getting a lot of feedback and echo. And that he checked in on Anita because Sharon asked him to, because Sharon hadn't been able to get a hold of him, get a hold of her. That he found Anita's apartment door locked. And so he went to go find the manager of the apartment building.
I think she's getting feedback.
Yes, we're getting a lot of feedback.
Can you just turn that one off?
Sorry, I'm playing the podium thing. I got it. It's my fault, Judge. I fixed it. Should be fine now.
Okay, let's see if that works a little bit better.
Thank you. Sorry, Ms. Sorgan.
That's not a problem, Your Honor. Technology. We've got gremlins. Okay. Gordon went to go find the manager of the apartment building because he couldn't get in because the door was locked. That manager was Laura Knapp, who unlocked the door to the apartment. Gordon told you that he found Anita dead, cold to the touch, in her bedroom. You next heard from Laura Knapp, the manager of the Northgate Apartments. Gordon came to her and locked that apartment, and she did. You also heard Laura tell you a lot of information about those locks. That these were specialty locks, had to go through Shook's, the locksmithing company, because these were specialty locks. Heavy duty specialty locks. And that the only people who were issued keys for these apartments were the tenants on the lease, the manager, which was Laura, and maintenance, Marty. And that in order to get a copy made of that key, you couldn't just go to a locksmith. There were no key kiosks. You had to go through management because you had to go to a special locksmith to get that key copied. And Laura told you that there was never a request received for a copy of apartment number 5. Laura told you that she distinctly remembers hearing the tumblers click in that lock, that she tried the door first to open it, and it was locked.
The tumblers?
And that she put a key in the lock, turned the key, and heard the tumblers click. And then the door opened. You also heard Laura tell you about Marty, the maintenance man, who was there when Gordon came to find Laura to get the key. And that Marty was there because he and Laura lived together. And they'd lived together for about 10 years. They were in a relationship. Marty was the maintenance man for the location. He lived in the apartment with Laura that she got as a perk of her being the manager at Northgate Apartments. Laura told you that Marty committed suicide New Year's Day 2009. She told you why. He'd had problems at work, hadn't gotten a job that he was looking for, possible diagnosis of Parkinson's, and that he had no health insurance. She told you about the death of his niece a few months prior to Marty's death. That Marty's family was not nearby. They'd all left Minot by that point. New Year's Day 2009. This was right after the holidays of 2008. Thanksgiving, Christmas. You heard Laura tell you that holidays were incredibly important to Marty, that he was usually always with his family. They were a big deal. Would it take much for you to imagine that with all of this coming down on Marty, with the holidays being a depressing time without your family, that there's a question on the timing on his suicide? You also heard Laura, who lived with Marty for 10 years, say that he did not have a knife or a knife collection, that occasionally there would be tools that he would work with. Next. We brought in a slew of officers for you. First officer on the scene. At that point in time, Patrol Officer Plessis, now Captain Plessis. He's been with Minot PD this entire time. He's familiar with the city of Minot. He's familiar with the locations throughout the city. He pointed out to you on the map where Northgate Apartments is. Clear in the northwest quadrant of town, near the airport. You heard the captain tell you that he's the acting chief of the Minot PD currently, and that he was involved in the decision to bring Cold Justice into the investigation, to allow them to assist the investigation. This is an important distinction here. Cold Justice provided resources and time that Minot PD could not allot to this cold case. After 15 years, you heard detective after detective and the captain himself tell you how busy Minot PD's caseload was, and that people just could not catch a break to be able to get the time to sit aside to go through this case. So this was a valuable resource that was available to be able to carve out that amount of time. You heard from retired Detective Strandberg. He was the one who was at the scene, taking photographs of the apartment. And through him, we received the exhibits of the exterior of the apartment building. It's exhibits 3A through 3F. And you're going to get all these exhibits. You can go through all of these at your leisure together while you're deliberating. We have photographs 4A through D which is the ground outside of Anita's window. We have photographs. We've only picked a few of Anita's body at the scene. States Exhibits 5A and 5B. And these are incredibly important. I'm sorry, 6A and 6B. 7A. No, 6A.
The jury doesn't care where the numbers are. They just want to know what's on the picture.
Yes, 6A, 6B. My typo there.
Good mistakes.
Of Anita's body at the scene. In a light pink robe, face down on a dark blanket. With the photographs of Anita's body after it was, or bedroom after her body was removed from the scene. And we have photographs of the screen as it was found located in Marty's shop with the cut that had been described as a backward L. And Lieutenant Strandberg also got the search warrant for Anita's phone bill to show us Anita's contact times. You heard from retired Sergeant Goodman, who was also very active in this investigation. And you learned some very important information from Sergeant Goodman. You learned there was no sign of a struggle or robbery. You learned that Anita's purse was sitting there in the bedroom with visible cash inside it, indicating no sign of a robbery. Because think about it, if someone is going to rob someplace, aren't you grabbing the visible cash out of the purse? He told you about the process of the removal of Anita's body from the scene. And again, this was highly important. He told you about the limited access of anybody to see the body, how Anita was positioned, and what she was wearing. That she was in that pink robe on that bed. Sergeant Goodman conducted a number of interviews. He also accompanied the defendant into that apartment after law enforcement processed the scene to see if anything was missing. And do you remember what he said about her reaction? Immediately, my iPod's missing. My pink iPod is missing. Without even really looking. And that this struck Sergeant Goodman as odd at the time. Sergeant Goodman also provided us with some very important information in the form of photographs that he took of Anita's cell phone. He photographed Anita's incoming and outgoing text messages, including her last outgoing text message and her last incoming text message that went unread. He also photographed the text messages between the defendant, from the defendant to Anita, complaining about that alarm clock and telling her what goes around comes around. Sergeant Goodman conducted an interview of the defendant on June 11th, 2007. And you'll have that transcript, State's Exhibit 13, to review. And he told you during his testimony that he caught the defendant in the lie during that interview about where she was at or around the time of the murder. Even though he had told her, I don't care if what you were doing was not legal. I don't care if you were smoking pot. I want to know. Don't hold anything back. And what did she do? She lied to him about her whereabouts. And she only came clean on it when he called her on it. Sergeant Goodman investigated the knife. He told you it was a cheaply made knife. It was sold in bulk. He also told you, as well as a number of other officers told you, that it was determined that the murder weapon was not the same knife that Devin Hall thought he had. You're going to hear a lot of information about that. Devin Hall thought he had that knife because the medallion was missing on one side. But remember, this was a cheap knife, a cheap folding knife. Would it come as any surprise to anybody, that something that's cheaply made might have more than one of those cheaply made knives, might have a medallion fallen off of it? I don't know if anybody's been keeping up with the news about panels falling off of Cybertrucks and that there's a mass recall with regards to that.
Elon Musk
That's
is like,
certainly not a
keep
cheaply
me out
made
of
item.
this.
But it's happening on more than one item that was produced.
Seriously.
Sergeant Goodman followed up on the Devin Hall lead and ruled him out. Went to Wolf Point, interviewed him. Interviewed a number of people who confirmed Devin Hall's statement that he was not in Minot on June 2nd, 2007. That he did not get there until the evening hours of June 3rd, 2007, by which point in time Anita was already dead. Next, please. You heard from Jordan Thompson, who's now with parole and probation after retiring from the Minot Police Department. You got to see the reenactment video, State's Exhibit 14. And again, you'll have access to that. What did we learn from this? That the window would not have been the point of exit. That it was extremely difficult for them to get in and out. You saw that yourselves. That it was difficult for Jordan Thompson, Dave Goodman, and Evelyn Jones, all three of them, getting in and out. The screen would have been ripped or damaged. The items below or in the windowsill would have been disturbed. You saw Evelyn sitting in the window to get in and out. You saw Jordan have to take great pains to hop around so as to try not to rip the screen out of the frame. But one other thing I want you to remember about that reenactment video. Whenever you saw somebody go into that window, they disappeared. You didn't see them. Remember that when there's a question about whether or not Anita could be seen by Marty as he's dealing with that screen, as he's just quickly plucking it out of the window and taking it back to his workshop. You heard from retired Detective Barnard, who went on to become sheriff of Ward County before he retired again, off to Arizona. He was the first detective at the scene. You heard him testify that he had to have Chuck LeBoy point the body out to him because even though he was standing right outside that window, looking in, actively looking for that body, he could not see it. He had to have it pointed out to him by another officer. He told you about the difficulty that law enforcement had in getting the defendant to come to the scene to meet with them. You heard Detective Barnard tell you what was conveyed. There's an emergency at your apartment. We need you to come home. And then you heard him tell you about her behavior when she finally did show up, after law enforcement had to threaten to come get her. She had a flat affect during the notification at the scene of Anita being killed. Didn't seem concerned. And most telling to Detective Barnard, she didn't ask any questions. And that normally, when someone is told, there's an emergency at my home, What? What is it? Why are the police at my house? Why do the police need me? What is going on? No questions. Didn't ask who, what, why, what's going on, nothing. Sergeant Barnard was present for the initial video of the apartment, which you, in conjunction with the photographs, you can see this is a tiny little apartment. Tiny little apartment. He took the first two statements, give the defendant any of the holdback information. And he told you why. We want to know what you know without influence from us. Next, please. You heard from Dale Meixner, the BCI agent, conducted an interview with the defendant on May 6, 2010. That's State's Exhibit 19. You'll have that transcript too. That also was analyzed by Sergeant Asham. Next, please. You heard from Dr. Marianne Sens, the pathologist who performed Anita's autopsy. And you'll get a copy of the autopsy report. You have it in evidence, the anatomical diagram, the photographs. And I will warn you that these are graphic photographs. And we've refrained from showing them to you thus far. But you will have them. Dr. Sens indicated that Anita had been face down shortly after her death, based on the livor mortis, the lividity, the darkening of the body, where the blood pools due to gravity. And that was how she was found. You heard Dr. Sens tell you there were no hesitation marks, and there were no defensive wounds found on Anita's hands. That Anita's cause of death was 2 stab wounds to the chest, and that one of the wounds was fatal within minutes. And she told you that that manner of death was homicide. And I also asked Dr. Sens how much force was needed in order to cause these stab wounds. And she told you not much force. It went through the cartilage, the soft part of the sternum. It didn't require somebody to be very strong or have a lot of upper body strength to do this. Next, please. You heard from Amy Gebhardt in the State Crime Lab, who analyzed the DNA. And she determined for you that the blood on the knife was Anita's blood. That gives us the murder weapon. And that the blood, or the DNA from the cut in the screen, was also Anita's. Now, Amy did mention that there was male DNA under one of Anita's fingernails. One fingernail. But that was a sample that was too small to compare. You have also heard testimony that there is no timestamp on DNA. DNA is everywhere. I could brush past you and my DNA would be on you.
Yuck.
Next, please.
Don't get your DNA on people, guys. Be considerate.
You heard from Mickey Talbot, McKaylee Talbot, now with St. Paul PD. She was part of the new investigation. She was partnered with Sergeant Asham. They interviewed numerous witnesses. They split this investigation up. Detective Talbot handled the part of the case involving Devon Hall. And she was able to rule out Devon Hall by establishing again that he did not arrive in Minot until after Anita was dead. And she did this by talking to collateral sources, by confirming with people who were with him at that time, he was not here in Minot. Not here in Minot. I would normally be saying here in Minot if I were back in Ward County. Next, please. You heard from Matt Hansen. Matt was the defendant's boss at eTelecare. And he told you about what happened the day that they were notified of Anita's death. They didn't even tell you there was notification about Anita's death. The police called saying they needed to get a hold of Nichole. There was an emergency at her apartment. She needed to come home. What was her response? Not, what's going on, why the police need me, what's happening, or, oh my goodness, I need to get there quick. It was, that's just my crackhead roommate, I'm not dealing with it. Matt didn't tell her anything about her roommate. Why'd she leap to that assumption?
Because they said there was an incident at her apartment.
Then Matt told her again. The police called back. He advised the police, I've already given her the message. And the police told him that if she didn't come, they were going to come get her. Then she finally went to the scene.
She's taken about 27 minutes
Matt
so
also
far.
told you that the defendant won a sales trip because she was a good salesperson at eTelecare. But she ended up not going to it because she quit shortly thereafter. Please. Then you heard from Donna Bieland. You probably remember sitting up on the stand, wearing her visor and her sunglasses because she's got issues that cause light sensitivity. She worked next to the defendant for several months at eTelecare. At that call center, open spaces, the defendant would constantly come. She'd park herself next to Donna. And Donna remembers crystal clear that first conversation with the defendant. What do you think of a roommate who leaves her alarm clock on and locks her door? First impression. And then from there, it was constant, according to Donna. Constant complaints from Nichole about her roommate. Donna told you about the fish tank incident, that there had been 3 separate occasions, and eventually the fish died. And that the defendant reacted like Anita had crossed a line, that she went from being a bad roommate to being an evil person. Donna also told you about the day after the defendant had an interview with law enforcement, and we know from the timeline when that would have been. We know that Sergeant Goodman interviewed her on June 11th. We know that the defendant had been interviewed on June 4th initially at the scene, but that she didn't go back to work on June 5th. So we know it wasn't the day after that interview. Interview with Goodman, June 11th. Which means that she spoke to Donna on June 12th, because the next interview with law enforcement wasn't until 2010, and she wasn't working at eTelecare at that time. Why would I need to cut a screen? I had a key. I wouldn't need to do that to get at her. Remember the holdbacks. Remember that the defendant never saw that screen on the window. Law enforcement never saw the screen on the window. They were led to it by Marty and Nell. And you will get the transcripts from June 4th and June 11th, her interviews with law enforcement. Not once is that screen mentioned in those interviews. Not once. But she tells Donna, they think I did it. I wouldn't need to cut a screen. I had a key. And she told Donna, I'll be okay as long as I keep my mouth shut. And you heard Donna's impression that she thinks at that point the defendant said too much. Because then she said, you do not want to make me mad. Donna didn't realize that she was even talking to her at that point. But the defendant was looking right at Donna. You do not want to make me mad. Next. You heard from April, one of the friends. She told you that following another one of the defendant's interviews with law enforcement, the only thing she seemed concerned about was her missing iPod. My pink iPod better not be missing. Next. You heard from Michelle, another friend. Michelle gave us a timeline. She was with Anita the Friday before she died. Michelle went and got a tattoo. Anita chickened out. She was supposed to get one too. And then the girls went to Schatz Crossroads, the truck stop, for a meal afterward. Why is that important? Because when the officers were interviewing and talking to Tyler, Tyler mentioned that Anita was going to a truck stop. She went with Michelle. Next. William May, the defendant's former boyfriend, was present at a party, a house party that he was having. And the defendant was drunk. She was intoxicated. But she said, I did it. I killed Anita. Mr. Whitmay told you about how he went to the police with this information. And we acknowledge there is no record of this interview. We acknowledge that. But he did tell you as well that the next day, he asked the defendant about that statement. She didn't deny killing Anita. She denied saying the statement. There's a big distinction there. Next, please. You heard from Christina Holler, formerly Christina Imhoff. House party, defendant drunk, being picked on about Anita's death. She gave the defendant a ride home, and then they talked in the defendant's apartment, where the defendant told her, I was fighting with my roommate over an stabbed my roommate. They had a falling out because the defendant was possessive and angry. Ms. Holler also said she went to the police before. Again, we acknowledge there's no record of that. But this was before the two had a falling out. Now, the defense is probably going to tell you that some of this information from some of these witnesses is largely influenced by cold justice and the airing of the documentary. You saw those pictures of Anita wearing a pink bathrobe. If Christina was trying to comport her information to what was learned through cold justice or to the evidence, wouldn't she have said that bathrobe was pink? She told you what she remembered the defendant telling her, that it was white. That was her memory of what was said to her. Fighting over an alarm clock. My roommate was in a white bathrobe. I stabbed her. Next, please. You heard from Connie Euland. And these were a little disjointed because we had to fly people in from out of town. We couldn't get Connie here until yesterday. Connie's Marty's sister. She also reiterated Marty had no family living nearby in Minot at around the time of his death. Mom had moved away. Connie was living in Minnesota. She confirmed the death of her niece, of Marty's niece, a few months before Marty's death, just like Laura told you about. She confirmed that holidays were very important to Marty, that he was the best gift giver. She told you about their family history of alcoholism and of suicide. But she also gave you some additional information. That Marty was having problems with Laura. That Laura showed up with another man at the funeral, after Marty's funeral. What was Marty losing by that? The love of his life that he'd been with for 10 years. The apartment that he lived in, because that was Laura's through Northgate Apartments. And his job, because Laura was his boss, because she was the manager and he was just the maintenance man. And when Connie was asked what losing Laura would do to Marty, she said it would crush him. It would crush him. Add that to what you already know from Laura of what was going on in Marty's life at around the time of Marty's suicide. All of this compounding itself. Is it any wonder that the man committed suicide? Next, please. You heard from Robin Thompson, another friend that we had to fly in. Friend of both Anita's and the defendants from high school. after Anita's death, she found that the defendant had one of Anita's stuffed toys in her closet and asked her about it. And she also told you that at the funeral, or after the funeral, the defendant told her that Money Mike was talking about that he had killed Anita at the funeral.
At the funeral. It's a bold place to brag.
You heard from Mark and Brenda Glynns. This is the defendant's aunt and uncle. Brenda was the defendant's other mama. You heard her tell that. And you could see how difficult this was for Brenda up on the stand, testifying as to this, talking against her own blood, against the girl that she was incredibly close to for a number of years. She told you about a trip that she took back from New Mexico after rodeo finals with Nichole, in Nichole's car to move her back from New Mexico to North Dakota. And they talked about this case because they were in the car together for a couple days. And they were very close. And that the defendant told Brenda that she would never get the image of Anita out of her head, laying there so peaceful in her robe covered up. She told her aunt about the bowl in the bathroom sink, and that the killer washed their hands and cleaned up the knife afterward. She told her aunt that the killer laid in wait in Nichole's bedroom for Anita to get out of the shower and then attacked her. And she also told her Aunt Brenda that she had gone back to Minot after she went to the 41 Club to get close. And we know from investigation that the defendant went to the 41 Club Saturday night and was there late. And you could tell that this was incredibly difficult for Brenda to express. The defendant would refer to Anita as a fucking bitch, a fucking cunt.
You don't have to say it.
You heard Mark corroborate that Brenda took that trip for rodeo, and that he was also present at a time when the murder was discussed. And one of the cousins asked Nichole if she was okay. And if the defendant's response was, she was fine. I never really liked Anita anyway. Next, please.
Someone
Last state's
advancing
witness,
the slides for her?
Sergeant Asham. She analyzed the phone records of Anita and of the defendant. Both of these are in evidence. She went through these photographs from Sergeant Goodman, determining when was the last message sent from Anita, when was the last message received that she never opened, confirming that Anita was most definitely still alive as of 2 a.m. on Sunday morning the 3rd, because she'd had a phone call with her boyfriend out in California, and he recognized her voice. She conducted another interview of the defendant on March 12th, 2022. You'll have that transcript as well. And she reviewed the defendant's prior statements to the other detectives over the years, as well as her statements to her Aunt Brenda. Yep. Mr. Nelson switching this over for me, because we have another PowerPoint for you on this one.
Part 2. We couldn't fit all the words in the first PowerPoint, so we made another one. This is not a PowerPoint, this is a script.
Of these statements. Timeline 1. The June 4th, 2007 statements to Detective Barnard, where the defendant says she was at that point in time. Timeline number 2. The June 11th, 2007 statements to Sergeant Goodman. Where was she then? Timeline 3. the May 6, 2010 statements to Agent Meixner. Where was she? And timeline number 4, the March 12, 2022 statement to Sergeant Asham. As you can see, there's a lot of gap here. We're looking at June 1st, 2007. Indicates at about 11:15 p.m. the defendant arrived back at the apartment. On June 4th, 2007, she said she got home, she heard Anita in her room, but didn't see her. June 11th, she returned home from work and heard Anita talking with someone. In 2010, she said she saw Anita at the fridge getting something to eat. And on the 4th, she didn't even remember if Anita was home. 1 a.m. on May 6th, the 2010 interview, she heard Anita open the front door. It's the only time she ever mentions this. Got up at 7 a.m., left for Velva without seeing Anita because her door was closed. Next one on that, please. Okay. We have varying timelines of when she arrived in Velva, when she was in Sykeston. The timeline number 4 from March 12th, the gray one. Unclear of the beginning time when she went to Sykeston. This is when we start getting things a little bit fuzzy here as to where she was and who she was with. We've got all sorts of different stories. As you can see from the May 6th timeline, arrived at the farm, fell asleep on the couch. No specified timeline at the Russo 41 Club. Watching movies with Alyssa, went back to sleep on the couch. Timeline number 4 here. Went to Russo until 11 p.m., never mentions going to Alyssa's house at all. Next, please. Inconsistent across the board of where she was on June 3rd and what she was doing until she went to work to be at work on time on June 4th. If you could back up one more, please, Chris. Oh, could you go back a slide? Sorry. Thank you. Appreciate that. All right. Now, as you heard the defense's own expert testify, no one had eyes on the defendant from about 11:30 p.m. until 8:30 the next morning. You heard officers testify how far of a drive it is from that farm in Velva to Minot, to the apartment. It's about 40 minutes. She had a window of opportunity of 9.5 hours. Go back to the right slide, please. Sorry, I'm making him do all sorts of technical stuff.
Like clicking a dance in the back.
Okay. Next slide, please. Okay. So we're bringing it all together for you. First step, we establish means, motive, and opportunity. Means is the ability to have committed the crime. Motive, the reason why a crime was committed. Now, we don't have to prove motive to you, but sometimes it's helpful in determining someone's intent. An opportunity, the time or availability to have committed the crime. Next. Step 2, review of the persons of interest in this case. We look at people's alibis. We look at their means, their motive, and their opportunity. And they are excluded by investigative tools. Please. So person of interest number 1, Tyler Schmaltz. The investigation showed you he hadn't spoken with Anita on the phone or texted with her in over a month. It also showed he moved into the apartment complex at Northgate before Anita did. He was living with his brother, who also alibied him, as well as people that he was playing online games with. He had no opportunity to do this. And he's been an active voice for justice for Anita for over the years. We've heard that testimony as well. Next, please. Next person we look to is Michael Van, Money Mike. He was interested in dating Anita. They were getting to know each other. He didn't have a motive to kill her. The last text message he sent at 4:53 a.m., you don't answer, went unread. It's the last message was sent to Anita that she hadn't opened.
If she was dead,
timeline.
she wouldn't open it.
Money Mike, through the investigation, was alibied by his friends. He was at a party. No opportunity to have committed this murder. And no means. He didn't know where Anita lived. The investigation concluded he didn't know where she lived. No means, no motive, no opportunity. Michael Van's out. Next, please. Next person of interest is Marty Annell. Marty led law enforcement to the cut screen. As we already established through defense's expert, if you're going to create a scene, if you're going to stage a crime scene, you're going to cut the screen and you're going to leave it to be found, aren't you? Marty didn't leave it in the window. Marty took it to his shop, where he showed it to Laura and then told law enforcement about it. If Marty were going to stage this scene to look like a break-in, don't you think he would have left that screen in that window
I thought on
for
Cross
law
the
enforcement
FBI
to
guy,
find, or somebody other than him?
they said they found it in the window.
No. Marty went about his rounds, doing his job, saw a cut screen, damaged screen, takes it, puts it in the shop. You heard about the issues in Marty's life. He committed suicide 18 months after Anita died. The death of his niece, right after the holidays, which were important to him and his family. No family support around. Losing the love of his life. Possibly losing his job too, and where he lived. And a family history of alcoholism and suicide. Wave after wave after wave crashing in on this man. But most importantly, Marty was alibied by Laura Knapp that entire weekend. She testified that they worked in tandem with each other. He'd be fixing something while she was cleaning an apartment. There was never any significant period of time he wasn't with her. And they lived together. Now, you heard the defense experts say that you wouldn't expect somebody to have an alibi witness during their sleeping hours. Do you think that that's true of your romantic partner who you share a bed with?
What?
Marty may have had means, no opportunity, no motive. Next, please.
Whoa.
The jogger, the running man, as we've heard talked about. This came about because of a description from Becky Ehrman based on a sketch that was released in the media in October of 2008. And shortly thereafter, Adam Raper came forward and said, I think that was me. I would run in that area. And you heard the testimony. He matches the sketch. Possible opportunity, no means, no motive. Next, please. And a lot's been done about Devon Hall. There's been a lot of talk about Devon Hall. Devon Hall breaks into people's apartments. Not going to sugarcoat it. It's what he does. But he is bad at it because he keeps getting caught. And including, notably caught, for a break-in on June 11th on Sioux Street. Clear on the other side of the city. Opposite quadrants. That he was highly intoxicated when he was arrested. His aunt lived in the apartment building that he was arrested at over on Sioux Street. But most importantly, he was not in Minot when Anita was killed. How do we know this? Because of the investigation that was done. He was in Wolf Point, Montana for a graduation. The investigation showed there had been police contact at that hotel that they were staying at because the boys were breaking into the kitchen on the evening of June 2nd. June 3rd, they took the train back from Wolf Point to Minot, corroborated by other people in that group who traveled with him, not all of whom were family, as it was acknowledged. Next, please. And Jerome Vivier. You alibied Jevin Hall, you alibied Jerome Vivier too, because they were together in Wolf Point on the day of Anita's murder. No opportunity, no means. Yeah, Jerome Vivier, he's been convicted of gross sexual imposition. So that's a possible motive. However, if you remember the testimony, and you'll also see this from the autopsy report as well that you have, Anita was not sexually assaulted. There was no sign of sexual assault. The victim in Jerome's GSI case was known to him. And when did that occur? On May 20th of 2007. You heard testimony, you heard some evidence that that Jerome was at the 101 Club on May 19th, 2007, the same date Anita was. But you also heard testimony that those two arrived over half an hour apart. There was no indication that they had any interaction whatsoever at the club, or that he wasn't paying attention to anyone in particular in the club. There's no indication that he could have found out where Anita lived, that he'd followed her when she left the club to see where she lived, that he'd interacted with her, that he'd looked at her driver's license to see her address, or anything like that. And then the next night, he's raping someone else in Minot. Not Anita. Next, please.
That is the weirdest statement.
So now our last
ever.
person of interest, Nichole Thomas Rice. Means she had access to the apartment with a key. The murder weapon was found on Anita's bed. Motive, an extremely toxic living arrangement between these two girls. The text messages from Nichole. I'm not going to live like this. What goes around comes around. An opportunity. Statements from her alibi witnesses and her leave large gaps of time unaccounted for. Even the defense's own expert acknowledges that. She can't be accounted for between 11:30 and 8:30. And that this murder occurred right around 5 a.m., right smack in the middle of that window. And that it is only a 40-minute drive from that apartment back to the farm. You heard the officers tell you she was the only person who could not be eliminated as a suspect. And the defense's own expert confirms that as well. She could not be ruled out. Next, please. So we bring it all together, the final pieces of this puzzle. Next.
Is that another copyright image?
Suspect, Nichole Thomas Rice. The only person who could not be ruled out. The only person elevated from the level of person of interest to suspect. The only person with means and motive and opportunity. Her rendition of events has changed significantly several times during interviews. No reaction. No questions. No concerns. The only thing that she was concerned about was that pink iPod. Declared it missing before even entering the room, according to Sergeant Goodman. And that struck him as odd. But he wasn't the only one that found her concern over this pink iPod, instead of Anita, distressing. You heard that from Goodman, you heard that from Barnard, and you heard that from April. And then we've got the statements to William May and Christina. I did it. I was arguing with my roommate. She was wearing a bathrobe. We were arguing about the alarm clock, and I stabbed her. Next, please. So we're summing up for you what the evidence shows. That the point of entrance and exit was the front door. The deadbolt was in place. A key was needed to make that entry. And more importantly, a key was needed to lock that door behind you. You could not pull that shut and have it lock behind you. It had to be locked with a key from the outside. Wouldn't that just be muscle memory to do that as you're leaving, if you're the person that lives there? Pull it shut, lock it, keep going. And we know it was locked because Laura Knapp distinctly remembers hearing those tumblers click when she unlocked it. And we know that the killer didn't have Anita's keys because Anita's keys were returned to Gordon by Detective Barnard at a later date. They were in her purse. We know the window was not the point of entry or exit. Anita's blood was in the cut on the screen and nowhere else on that screen.
But the knife was
Only
in the bed.
in the cut from the evidence that you heard, which means that it was made with the knife that was used to stab Anita, which means that screen wasn't cut before she was stabbed, which means that that screen was not the way into the room. You can't go through a cut that hasn't been made. You heard the testimony that there was dust and cobwebs in and around the window and the windowsill, and that this was not disturbed. That's another way you can tell that no one went in or out of that window. The reenactment video shows you that the items in and around the window would have been disturbed, that those dust and those cobwebs would have been disturbed, and also showed you that that screen would have been stretched and ripped in a manner that it was not. You heard tell about the stuff that was underneath Anita's window, that she had things kind of precariously stacked. And you heard the detectives tell you that when they entered the window through that reenactment, they stepped on the floor. Not on the bed, on the floor. Because that's where you go through where that cut would have been. That backward L would have stepped on the floor. All that stuff would have come cascading down if someone had done that, entering through that window. The evidence showed you there were no signs of a robbery or a sexual assault. Her money, her cash in her purse was still there. The photos show you her television was still there. Her phone. All these little items that could have been stolen and taken, nothing's missing. No sexual assault. The evidence showed you this toxic relationship between them, the fish tank that resulted in dead fish, the alarm clock, the nasty text messages, and the installation of a lock on Anita's door so that she could take herself away from Nichole when things got bad in that apartment and put a locked door between the two of them. Next, please. The evidence further showed the defendant had knowledge about that crime scene that she should not have had. The statements that she made to her Aunt Brenda before any information became public or was disclosed by law enforcement to anyone outside of law enforcement. That bowl of water in the bathroom sink. That had been removed when the crime scene was processed before she was allowed to come in. That wasn't there when she was let in by law enforcement. How'd she know it was even there? They never told her about it. Anita having been in the shower before her death. You heard the testimony. There was no physical evidence at the scene that she'd been in the shower. That was pieced together from the text messages that she had with Michael Vann. That she wasn't feeling well and that she was going to take a shower.
Money Mike.
Anita had been dead over a day by the time that she was found. There's no indication that her hair was wet. Would have been dry by that point. Anita being in a bathrobe and the position of her body. You heard from Goodman, from Strandberg, and from Barnard the process for removing this body. And that the defendant had not been in that apartment before that body was removed. You heard that they laid her in the body bag, a dark body bag. You can't see through it. You heard Barnard tell you in detail about those body bags. And that when the notification was done, the identification, they unzipped it just a little ways so that that person making the identification could see her face.
She's gone over an hour. There's no time
limit.
Wasn't
unzipped enough to see that she was wearing a bathrobe. And then you have the statement to Donna Bjelland about the cut screen. But before I get into that, the bathrobe again. She mentioned that to Christina. Remember, my roommate was wearing a bathrobe when I stabbed her. But on to Donna. Talking about the cut screen. Again, remember, we know when she talked to Donna, based on the fact that we know when she talked to Sergeant Goodman. Because it was the day after she talked to Goodman, and the Goodman interview was June 11th, 2007. And once again, law enforcement did not tell the defendant about the cut in the screen during those interviews. And that screen was not in the window for her to have seen it herself, even if she was just milling about. And law enforcement was adamant about what they held back in this case. The bowl of water in the bathroom, Anita's body and what she was wearing, her position on the bed, the cut in the screen. These are important holdbacks. And these are all pieces of information the defendant possessed and conveyed to people at times when she should not have had that information. And as you heard the defense's own expert say, the only logical conclusion is that she was there. Next, please. So again, these inconsistent statements to law enforcement and to others. Next. And the confessions. I did it. I was arguing with her about an alarm clock. She was wearing a white bathrobe, and I stabbed her. Ladies and gentlemen, taking the totality of all of this information, eliminating the other person's
Holy
of
big
interest
font.
through investigation, there's only one conclusion to be drawn. Most importantly, from the defendant's knowledge and her admissions. Admissions to friends, and what she told her Aunt Brenda, whose heart was breaking about this. There's only one conclusion to be drawn, and that is that in the early morning hours of June 3rd, 2007, Nichole Rice took this knife and plunged it into the chest of this girl and killed her. The state asks you to find her guilty once you conclude your deliberations. Thank you.
By process of elimination, please find the defendant guilty, because the other ones are
Sand,
not.
do you wish to make a closing argument?
Oh, yes, I do, sir.
Oh,
Right.
yes, I do. It's going to be fiery. I think prosecution did pretty well on that closing. His mic is terrible.
Can you hear me all right?
No.
Okay. Can you all hear me? Okay. There's been some issues with that, so thank you. First of all, thank you all for being here. I know this is probably the last thing anybody here wants to do. All the time and energy that you guys have expelled, taking a week out of your life, sitting on a case like this. It's a lot of stress, and I'm sure your family and your work lives have suffered for it, so thank you very much. It's important as citizens, it's important for Anita, and it's important for Nichole. Now, we just sat through over an hour of slides trying to go through every piece of this case, every piece of testimony, every witness. And I'll tell you, usually when you're a defense attorney, your job is to try to snake through a hole. You got to make things just work right. This case is totally flipped. They just took you through an hour of slides where they had to go through about 300 elements that have to work perfectly for them. All of them have to be true for their case to work. Devin Hall got on the train at the time some guy in Wolf Point said he got on the train. They don't have evidence for that. She's saying that. The investigation showed. The investigation didn't show that. Otherwise, the FBI wouldn't have said Devin Hall was the most likely suspect. But I'll get back to Devin Hall. They talked to you about Marty Anell. Never left Laura Knapp's side, but she's screwing around on him. They never leave each other's sides. That's not true, and that didn't happen. But it has to be true for their case to work. Their case doesn't work. Their own lead investigator, Detective Asham, told you guys she didn't review the whole file. That's not bad police work. That's insane to bring charges when you haven't reviewed a file. They're trying to say this is a puzzle with many pieces. No, it's a murder case. And everybody in here deserves justice. Anita and Nichole, and this isn't how you get it. And I don't mean to yell at you guys. I'm not yelling at you. I'm blown away by what I'm seeing here. I've been practicing law for quite a while. I've never seen anything like this. So we got a case agent. A case agent who didn't review the file. You heard from our expert. I'm going to call him Agent Coons, not our expert. We had to bring in our own expert. I've never done that before because I've never seen an investigation like this. We had to have the entire case reinvestigated at Nichole's expense to figure out what happened here because they don't know. All of their conclusions that they're bringing to you are just the conclusions that they needed to put her in that chair right now. Devin wasn't there. Devin told you, we read the report. I've been breaking into houses since I was here. Oh, it just perfectly lined up that he wasn't on the train. He was breaking in somewhere else at that point. This is crazy. I had Detective Asham on the stand. I said, you're aware he broke into that apartment? She goes, well, he actually broke into 2 that day. Unreal. A detective who didn't read the case file. I've never seen anything like that. It's insane. We discussed in jury selection and at opening that they're going to tell you that this is a murder case based on an alarm clock and nasty text messages between 2 18-year-old girls. I can walk around this town and find all of those people. 90% of the girls in this town are going to have those same issues that go to UND here. This sophisticated murderer sitting right here, Nichole, was able to scrub the DNA out of that place. They showed you the murder weapon. I'm not even going to dig around. You've seen it 20 times. Her DNA is not on it. In fact, the only DNA... I'm not even going to dig around. You've seen it 20 times.
We'll glitch there.
Her DNA is not on it. In fact, the only DNA they have is from a man. Nichole's not a man. This is 2025. This isn't Perry Mason in 1950. They're trying to use conjecture and hearsay to convince you guys that Nichole got out of bed in the middle of the night, drove to Minot, killed her roommate, scrubbed the scene of DNA. She's this mastermind, mob hit killer. Goes back home, has the intestinal fortitude to just go on with life like it never happened. We're talking about a daughter, a sister, a wife, and a mother. This doesn't happen. This is a load of crap. Now, I talked to you at jury selection. I talked to you on opening arguments. This TV show came to town. What a coincidence. The TV show comes to town, and we're getting charges. They came to town for 7 days. They're telling you in their closing that the Minot Police Department's so busy, they can't get things right. And there's a whole heck of a lot more we heard about the Minot Police Department that I'm not going to get into because we don't need to relive some of the accusations and the things that have gone on with the Minot Police Department. But they bring in a television show for a week, and they're going to blow this case wide open. You heard from Agent Coons, the show came in, it had an agenda. The agenda was to put Nichole in that chair right there. Because that's what gets people watching these things. And that's what they care about. They don't care who did this. They care who's watching that TV. You see all these cameras in here. And when this is over, you'll find out a lot more about what's going on here. This is a media circus. And it's a media circus because they can put her in that chair, and these people helped them do it. And it's garbage. And they should be ashamed of themselves, all three of them.
Objection.
Wow. Yeah, sustained.
Sustained.
I'll back off.
Thank you.
The show comes in, the charges come out. The week-long investigation commences with two people from Hollywood. We're trying to clear your brother Marty. How can we figure that out? We don't consider Devon Hall a suspect. Why? They don't even have the train records. The guy's breaking into houses all over Minot with knives, women's apartments, saying, I've been doing this since I was here. Not a suspect. Because these cameras wouldn't be in here if he was. If the dead guy was the suspect, these cameras wouldn't be in here. These cameras are in here because we can have a nice North Dakota mom sitting there. That sells. And it's disgusting. And it's not our system of justice. It's greed. And that greed's putting pressure on these people.
This is fiery.
Now, we sat up here for 6 days. And person after person, officer after officer, we heard inconsistent statements. Oh, I don't remember. It was so long ago. I don't remember. Can you show me the report that I never looked at, that I never read before we brought charges? Sure. I spent half my week up here. Yep, here it is. Here it is. This is what happened. You should have reviewed it before you put her sitting in that chair. But when that happens, oh, it's been a long time. It's an inconsistent statement. When Nichole, who comes in for every interview, talks to law enforcement every time they ask her, when she makes a mistake, when she can't remember something just right, she's guilty. We're putting her in that chair. And here come the cameras. She's the only one who's not allowed to have 10 minutes wrong or get interviewed 18 years after something happens and have one element wrong. She came in every time, no lawyer. Not all the other suspects you can say that about. 18 years. She was 18 years old when this happened. That was 18 years ago. They've been interviewing her over and over and over again. Of course they're going to get interviewed for 18 years. But when other people, for their case, for what they need to put her there, when those other people make inconsistent statements, it's forgiven. When the cops make inconsistent statements, when the cops tell you they didn't review the case, it's forgiven. It's madness. I have never sat through a case where I've had to sit here with 7,000 pages. You probably noticed how slow I was going. I'm going through 7,000 pages in my head to make sure they understand what happened because they didn't do the work. The investigation happened in here. The investigation happened with Agent Coons. They didn't review the file. They said that. That's insane. To put somebody sitting in a chair for murder without reviewing the file. On top of not reviewing the file, I'm going to take myself back up here. Detective Asham, did you have trouble gathering the evidence? No, we got all the evidence. Well, I thought you said you had trouble gathering it. I show her a report where Devin Hall says that he came to Minot on the 2nd. On the bottom of the report, it says, this has been recorded and will be put into evidence. Do you have that? No, we don't. You don't have that. That's bad police work at best. You know what it is at worst.
This is all theater. It may work.
The state brought in a bunch of witnesses. It was a cast of characters. The TV show comes out, the phone starts ringing. You have two people who all of a sudden have an admission, an alleged admission. I did it. Everybody's blackout drunk at a party. I did it. One guy's got drug problems. We're more than grateful for his service in the military, no doubt. He's admitted he was in St. Cloud for rehab. They get in touch with each other prior to talking to police after the show comes out. And they say, yeah, we reported this multiple times back in 2008. This is one of the biggest murder cases in North Dakota history. And the cops just ignored that? No, they didn't call in. This is another load of crap. Donna Bieland can't remember when she worked with Nichole. She can't remember where the office is. She says Nichole's parents forced her to clean up the murder scene and then made her sleep in a shed. I was laughing during the testimony. This is crazy. She's sitting up here with Coke bottle sunglasses on and a banker's hat. Like they went off and found her on the street. And they want to put her in prison with that crap? Are you kidding me? They sit here talking about holdbacks. Aunt Brenda, she proved the holdbacks about that trip. Aunt Brenda said the trip was in 2007, 4 to 5 weeks after Anita died. She was totally wrong. She was a year off. Those holdbacks had most likely been given to the press at that point. Michelle Grubb, when she testified, if you can keep all this straight, had said she knew Nichole was stabbed. This stuff comes out in these towns. They're basing all of these holdbacks on this testimony of Aunt Brenda, good old Aunt Brenda. She's not sitting in here right now, I'll tell you that. Aunt Brenda had it a year off, and she was so sure of it. We were going to my son's rodeo in Farmington. We took my husband's plane. You're a year off, Aunt Brenda, sorry. They're asking you to find this girl guilty on 20-year-old hearsay. It's baloney. Think about this for a second. She leaves her family house in the middle of the night, goes in, kills her roommate, who's got a lock on her door. Like Dexter cleans the scene. No DNA. Scrubbed. Nichole lives in this apartment. There's no DNA. Her DNA's not on the knife. Her DNA's not on Anita. And then she texts her after. Long after. The state expects you to believe that she did that and came home and went on with her life. You see her sitting here. That's not James Bond. This didn't happen. Then the state's got the gall to ask Agent Coons why we didn't do more work investigating this case. We did a heck of a lot of work. And we have no obligation. We have no obligation to hire investigators and to hire experts and everything else to do an investigation that they didn't do. They admittedly didn't do. They didn't review the files. It's Nichole's job. That's a terrifying thing. If you're an American citizen, you got to hire your own police because they're not doing it. You heard from a few witnesses that were were law enforcement from Minot back in the day. You heard from Agent Coons. The FBI fingered Devin Hall. He said, that's who we're going to look into. Who's the one suspect that they didn't look into when they reopened the case when cold justice showed up? Devin Hall. You know why? Because it would have been a problem for them. They wouldn't have been able to get Nichole in that seat. And these TVs wouldn't have been lit up and people wouldn't have been making millions of dollars. And I can't harp on this enough. It's 2025. And we're taking a cold case with no new physical evidence, no genetic evidence, no DNA. When you guys go back, look at that DNA report. Look who wasn't tested. They got male DNA under a fingernail. Read through those names, see who wasn't tested. You're going to be surprised. In their opening, the state's attorney said, crime loves silence. Nichole went in every time the police asked her to come in for an interview. She wasn't hiding from this. There were people that were. What you're seeing here is a totally unprepared police department and state's attorney's office. You're seeing baseless charges, and they're going after an innocent woman because they're pressured. You have no idea what these TV cameras do to these people. And I'm not blasting police. Police are good people. But what you're seeing in this case is garbage. It's absolute garbage. It's insanity. You heard it from Agent Coons. I can't state it enough. They didn't read the file before they charged her. We read the file before they did. They keep telling you that their big issue is this hunch on Nichole because of her behavior. And then you heard, and you'll see it in the transcripts, top of the transcript, Nichole was crying at the scene when she got there. I can't make these police testify to what they said. I've shown them a lot. But that doesn't sound like what they were saying. She's crying. She's not acting stoic. She's crying. They asked her, they brought her into the apartment. Is anything missing? Yeah, my iPod is. Now all of a sudden they're latching onto that. Cops are asking you a question. What's missing? It looks like my iPod's missing. She should have just said nothing and lawyered up. Instead, she tried to help them out. That was a bad idea with these people. People like Nichole don't kill people over alarm clocks. We know that. Toxic roommate. They're telling you, read the texts. Look at the alarm clock. The fish. We all went to college. I went to college. Everybody's been in plenty of disputes with their siblings and roommates. We talked about this at opening and during jury selection. People like Nichole don't kill people over that. I've told you that before. It's true. This is a case based on hearsay and speculation from 20 years ago. I don't think there's anybody in here that doesn't want justice for Anita. She deserves it. There's no doubt, but there isn't justice for Anita in here. Nichole didn't do this. And on jury selection, we talked about guilty go free or innocent go to prison. Nichole didn't do this. The killer's out there, and this needs to be solved. But it's not going to be solved in here today because the work wasn't done. The work had to be done by Nichole. She had to hire ex-FBI agents, a team of attorneys. She had to do that. That's not her job. That's not your jobs. That's the police's job. It's their job to look into the file, to read the file. Not to have a... I can't link anything more to the fact that cold justice came into town and they charged this case more than the fact that they said they didn't read the whole file. They didn't review the file. I'm showing them things they haven't seen before. I showed Detective Asham that train report. She was shocked. Wolf Point to Minot. End of May through June 10th. No Devin Hall on there. Our case is shot. All of a sudden, he slipped a guy at 20. That's what I'm telling you. They just went through all these slides, hundreds of elements that have to work perfectly for them for this case to work for them. It's crazy. If one of those falls out of place, this case doesn't work. Crime loves silence. Nichole participated all the way along. This is madness. State's Attorney Sorgan told you DNA is everywhere. DNA is in the air. If I touch this, my DNA is there. Not Nichole's. I don't know what, she's got special DNA, I guess. She lives in the apartment. They don't have her DNA. No DNA on the murder weapon. They're so sure of what went on with this screen. Their detectives never saw it. Their investigators never saw it. The only person here that testified it was Gordon. He said it was out in the yard. Marty's dead. We can't talk to him. And then a couple days later, you got Devin Hall saying, I'm coming in and out of the windows, in and out, twice in one day, with a knife. This is terrifying that this case was brought. It's absolutely terrifying. And I used the term abortion of justice, and I know that's a heavy term. I don't like to use that. But that's what this is. This is madness. This never should have happened. We shouldn't be sitting here today. Nichole didn't do this. Nichole Rice, the sister, the daughter, the mother, and the wife, who's sitting here with her whole family right now. It's a ranch family from Velva, North Dakota. She didn't sneak out of her farmhouse in the middle of the night, get Devin Hall's Indian head knife, and stab someone in the chest. She didn't do that. And go back home like nothing ever happened. Just take a step back. Let's walk away from the slides. Let's walk away from 8,000 things that have to go right for us to be sitting here today. All these other people. This is madness. It's a horror movie. I don't think after any of this there's any option to come back with a not guilty verdict. Nichole didn't do this. Thank you guys so much for your time. I know this has been a lot. I know this is a lot out of your lives. This is incredibly stressful. We appreciate you. Nichole appreciates you. Thank you all.
All right. Thank you, Mr. Sand.
Wow.
Ms. Sorgan, last word.
Thank you, Your Honor. Oops. Let's not trip over quotes here. Well, I'm glad that Mr. Sand told us that he's not bashing the police because he could have fooled me. I'd like to remind you all of an instruction that you're going to get. What counsel says isn't evidence. What I say is not evidence. Mr. Sand says isn't evidence. Evidence. It's what's on the table. It's what you heard out of that witness stand right there. So I'd like to go through Mr. Sand's points. You heard him say a lot during the course of this trial. This is important to Nichole. This is important. You know who else it's important to? Anita's family, who have been sitting here throughout this whole thing. This is important to the community of Minot. This is important to my office. This is important to MPD. It wasn't just important to Nichole. Now, I do not discount. It is absolutely important to her. I know it is. Mr. Sand told you about, it's got to be like 300 elements. It's got to all line up just for everything to work. That's life, folks. Think about using your common sense and experience. How do things have to line up in order for something else to happen? Every step we take in life leads to something else. He questioned about Laura saying that she was with Marty the entire weekend. The weekend of the first weekend of June of 2007. 18 months later, when Marty committed suicide and they had his funeral, she was with someone else. There's no indication that she was having an affair or that there was an issue the weekend that Anita died. That's a red herring. Mr. Sand wants to continue to harp on that Sergeant Asham didn't review the file. He kept saying, didn't review the file. He left a word out of there. Entire file. She didn't work the entire file because she had a partner, Detective Talbot. They split up the work. That much evidence to go through? One person can't do it alone. In fact, you even heard the defense's own expert, Mr. Counts. I glanced at some things. I glanced at it. He didn't do a deep dive on absolutely everything in this file. It was his own testimony. Now, nowhere did you hear that the state's theory of this case is that Nichole went to sleep at the farm, woke up in the middle of the night, made a mad dash to Minot, killed Anita. From the timeline that you saw, and from the statement that she gave to her Aunt Brenda, she left the 41 Club in Russo and went back to the apartment in Minot to get clothes, where she encounters Anita. Anita, who thought she had the apartment all to herself that weekend because Nichole went home every weekend. Anita was not expecting Nichole to show up at home. So her bedroom door was not locked. You heard the testimony from Gordon. Anita's bedroom door was open when they went into that apartment. It wasn't closed. And I'd also like to get back to another point about Gordon's testimony. Mr. Sand told you that Gordon told you the screen was in the yard. Gordon didn't know that because Marty had picked up the screen during his morning rounds and taken it to his shop before Gordon showed up. Gordon wouldn't have seen it in the yard. Now, there has been a lot mentioned about cold justice. That they came to town for 7 days. And in 7 days, cracked the case wide open. That's what we just heard. You heard Sergeant Asham tell you that they had the case file a couple of months ahead of time so that they could review everything. They came to town for 7 to 10 days for filming and for some interviews. But that this was a collaborative effort and that cold justice was not calling the shots. Cold justice does not make charging decisions in Ward County, North Dakota. Minot PD doesn't even make charging decisions in Ward County, North Dakota. Mr. Sand kept saying MPD can't get things right because the time couldn't be spared. Yeah, cold justice. Kelly Siegler and Steve Spingola came to town. And you heard the testimony from their own expert. Kelly Siegler, seasoned prosecutor. Steve Spingola was a lieutenant with Milwaukee Homicide. These are people with experience who assisted the MPD in this investigation. These weren't just two random people from Hollywood, not two Hollywood people or Hollywood personas that came in. These are people who actually have worked cases before. Mr. Sand tells you that greed is putting pressure on these people, that there's millions of dollars to be made. Not in my paycheck. Not in Mr. Nelson's paycheck, certainly not in Sergeant Asham's paycheck. The only person that you've heard has any financial benefit from this case so far is Mr. Counts. Got his $10,000 expert fee. It's the only person that you heard has made any money off of this. And you heard Mr. Sand saying, I spent half my week up here going through with witnesses. You're right. On cross-examination, when you were asking them about things that were extraneous to the case. It is not improper to prep witnesses. In fact, that's trial tactics 101. They teach you that in law school. You don't ever ask a question to which you don't already know the answer. So you prep your witnesses. You meet with them. This trial could have been a whole lot longer if we'd have had the witnesses testify to absolutely everything that was in this case file. But we didn't. We had to boil it down to what was relevant and what was important. You've already been here long enough without having to get through that. So he's refreshing witnesses' recollection for investigations that they did 18 years ago. Are you surprised? And then he asks you, oh, but they get forgiven for that, for not remembering something 18 years ago when they've worked how many other investigations since then? But Nichole, not remembering something is a bad thing. Okay, let's explore that. If you're the suspect in a murder and you know that your alibi is important, that your whereabouts are important, wouldn't you know that information cold, no matter how many times you're asked about it? And again, let's look at the timing of these interviews. June 4th, 2007, the date that Anita's body was discovered. June 11th, 2007, a week later. Not enough time for a loss of memory. And remember, in that interview, that's the one that Sergeant Goodman said she was not telling him the truth, and he had to confront her on it. May 6th, 2010. Not even 3 years later. And then the last interview, March 12th, 2022. 15 years after the original interview. So the relevant, the main interviews, when it was fresh and it was new and there was no time to forget. And you would expect her, wouldn't you, to know where she was if she knows that she's a suspect for a murder. Are you going to expect Detective Barnard to remember something 18 years later when he's retired twice and worked how many cases in the interim? Same thing for Sergeant Goodman. Detective Thompson. A cast of characters. I would like to correct something that Mr. Sand told you. 2 people coming in after, one of whom having drug problems. If you remember the testimony, William May went to St. Cloud for PTSD treatment, not for drug treatment. He tried to make Brenda Glynns out to be a drug addict. She went to a rehab facility to be weaned off of pain medication after she broke her back because she was having seizure activity. And nobody said that Christina or William they went in multiple times to report this. Nobody said that. They didn't testify to that. They went in once. Nothing came of it. What are they to think? Donna can't remember when she worked at eTelecare. I couldn't begin to tell you the start and end dates of a couple of my past jobs. But Donna remembered those conversations with Nichole because they stuck in her memory. Remember what she told you. The level of concern that she had is what ingrained this into her memory. That she was concerned about how this is escalating between these 2 girls. Brenda was wrong about the year on the trip. She thought it was 2007. It was 2008. What's important is that trip happened. And then Nichole confessed information to her during that. And also, Brenda didn't say that she flew to New Mexico. She said she rode with her ex-husband and then rode back with Nichole. So if we're going to nitpick testimony, let's remember it right. Mr. Sand told you this stuff comes out in these towns about the holdbacks, about the information. Yeah, because Nichole talked about it. She told people. That's how they knew. You heard people tell you that she told them these holdbacks. Mr. Sand is correct. The defense has absolutely no obligation to investigate. But they did. And their own expert didn't even really review the file particularly well, did he? He acknowledged several mistakes that he made in that, such as Devin Hall broke into the apartment complex that's the same building as Anita. You heard him admit, nope, I screwed up. I made a mistake on that. I was wrong. Wasn't the same building. You also heard him say he didn't hear the testimony of these witnesses. And he also didn't review prior deposition testimony from them. Mr. Sand told you, look at the DNA report and look who wasn't tested. You're going to have one heck of a time figuring out who wasn't tested. This lab report is 35 pages long. And you will see that Devin Hall's name is in it. He was tested. They got in a sample from him to review against. You also heard that Nichole was crying at the scene in that very first statement. Yep, she was crying. After she'd been told that if she didn't get there, they were going to come get her. After, that's just my crackhead roommate. I'm not dealing with it. Without any information of what was going on at that apartment, not why are the police trying to get a hold of me, not what is happening at my apartment. Was there a break-in? Is something missing? No questions whatsoever. And that struck investigators as odd. No concern over Anita whatsoever. You've been told this is a nice North Dakota woman who referred to her roommate as a fucking bitch, fucking cunt. Told her family, I'm fine because I didn't really like Anita anyway. And was more concerned about what happened to that pink iPod of hers than about her deceased roommate, who at one point in an interview, she said, she was my best friend. I looked up to her. I wanted to be like her. Mr. Sand told you that Sergeant Asham was shocked by the train report. No, she wasn't. But in any event, you can judge for yourself what Sergeant Asham's reaction to that was. But I would like to remind you, she had a partner. That would be Detective Talbot. She worked the Devin Hall angle. She's the one who reviewed the train reports. She's the one who reviewed that video, spoke with those witnesses who confirmed that Devin Hall was in Montana and didn't leave Montana until that train departed to head to Minot, which did not arrive until 9:20 p.m. on June 3rd, 2007, at which point in time Anita had been dead since 5 a.m. that morning. And again, this was not Devin Hall's knife. Lastly, that was one of the last points that Mr. Sand brought up. Devin Hall, in an interview, said it looked like a knife that he had taken from Jerome Vivier's, but that he had returned to Jerome's house after having it about a day. And Nova Wetsit brought that knife to the police. You heard testimony that that knife, Jerome's knife that Devin supposedly had, was turned into MPD and placed into their evidence. So it could not possibly be the murder arrest weapon that had been left on Anita's bed, because it was in Nova Wetsit's possession to turn into Minot PD later. So once again, ladies and gentlemen, after reviewing the totality of everything, once again, we urge you to find the defendant guilty. Thank you.
All right, thank you, Ms. Sorgan.
Jury instructions.
Members of the jury, Mr. Nelson, can I have you move the podium for me, please?
Yes, sir.
Just slide it underneath the pole there.
Sure.
Thank you. Perfect. Thank you very much. You will recall at the beginning of this trial, several instructions were read to you on trial procedure, on your duties, and on some of the law to be applied to this case. Those instructions should be considered by you as part of the remaining instructions that I now give. Officer, please don't let anybody in that door while I'm reading these. Thank you. While you are the sole judges of questions of fact in this case, it is your duty to accept the law as is given to you by the court in these instructions, and to apply the law to the facts as you find them to have been proved. You have no right to disregard the law and look for any theory unsupported by credible evidence upon which to build a verdict based upon your notions of what the law is or ought to be. A person who knowingly or intentionally causes the death of another human being, or who willfully causes the death of another human being under circumstances manifesting extreme indifference to the value of human life, is guilty of murder. The state's burden of proof is satisfied if the evidence shows beyond a reasonable doubt the following essential elements. On or about June 3, 2007 in Ward County, North Dakota, the defendant, Nichole Rice, intentionally or knowingly caused the death of Anita Knutson, a human being. Or the defendant, Nichole Rice, willfully caused the death of Anita Knutson, and the death of Anita Knutson was caused under circumstances manifesting extreme indifference to the value of human life. A person engages in conduct intentionally if, when he engages in the conduct, it is purpose to do so. Knowingly, if, when he engages in the conduct, he knows or has a firm belief, unaccompanied by substantial doubt, that he is doing so whether or not it is his purpose to do so. Recklessly, if they engage in conduct in conscious and clearly unjustifiable disregard of a substantial likelihood of the existence of the relevant facts or risks, such disregard involving a gross deviation from acceptable standards of conduct, except that awareness of risk is not required when its absence is due to self-induced intoxication. Willfully, if he engages in the conduct intentionally, knowingly, or recklessly. When a person is charged with having been present and with having committed or aided in committing a crime, absence from the scene of the crime is a complete defense called an alibi. Intent may be proved by circumstantial evidence. Indeed, it can rarely be established by any other means. We simply cannot look into the head or mind of another person, but you may infer the defendant's intent from all of the surrounding circumstances. You may consider any statement made or act done or omitted by the defendant and all the facts and circumstances in evidence which indicate the defendant's state of mind. In this case, you have observed video evidence. When considering video evidence, you should evaluate it like any other piece of evidence. And you may consider any facts or circumstances in the case which tend to strengthen, weaken, or contradict the video evidence. You should consider the video evidence using your common sense and experience. The opinion of an expert is based upon certain underlying facts or data. While you need not accept that opinion, you should consider it and give it such weight and credibility as you think it deserves in the light of all the circumstances. If you conclude that the opinion is not based on sufficient education or experience, or the reasons given in support of the opinion are unsound, or the opinion is outweighed by other evidence, you may disregard the opinion. Witnesses who were not testifying as experts gave testimony in the form of an opinion or inference based on having perceived a matter. In deciding the weight and credibility, if any, to be given a witness's opinion or inference based on having perceived a matter, you may consider the witness's opportunity to have perceived the matter, the witness's reasons for the opinion or inference, and all other evidence related to the issue. The weight of the evidence is not determined by the number of witnesses testifying on either side. You should consider all the facts and circumstances in evidence to determine which of the witnesses, if any, are worthy of belief. You may find that the testimony of a smaller number of witnesses on one side is more believable than the testimony of a greater number of witnesses on the other side. Any fact in dispute may be proved by the credible testimony of a single witness. However, before finding any fact to have been proved solely by the testimony of a single witness, you should carefully consider all of that witness's testimony upon which proof of fact depends. A witness, including a party, may be impeached, meaning that the witness's testimony is discredited by contradictory evidence you find to be true, or by evidence that on a former occasion the witness made a statement or acted in a manner inconsistent with the present testimony, or by evidence of conviction of a crime, or by evidence of character for untruthfulness. If you conclude that a witness has been impeached, you may give the testimony of that witness such weight and credibility, if any, as you think it deserves. If you conclude that a witness has been impeached by an earlier contradictory statement, the statement may be considered by you as evidence only if the statement was given under oath, in which event you may determine which is the truth, the present testimony or the earlier statement. If you conclude that a witness has willfully, knowingly, or intentionally testified falsely concerning a material fact in this case, you may wholly disregard the witness's testimony unless it is corroborated by other credible evidence. A defendant has a constitutional right not to testify. You must not draw any inference of guilt from a defendant's silence. The prosecutor cannot mention a defendant's silence, and you must not discuss or consider it. If you find from all the evidence in this case, beyond a reasonable doubt, that all of the foregoing essential elements of the crime charged in the information, viewed in the light of the law, have been proven, then it is your duty to find the defendant guilty. If the state has failed to establish any of those essential elements beyond a reasonable doubt, it is your duty to find the defendant not guilty. In reaching your verdict, you must not discuss or consider any possible penalty or punishment, as that matter lies with the court and other government agencies. When you go to the jury room, you will select a jury leader. The jury leader will lead your deliberations, communicate with the bailiffs for you, and speak for you in court. The jury leader does not have more authority than the other jurors, and the jury leader's opinion does not carry more weight than the opinions of the other jurors. In order to return verdict, each juror must agree to the verdict. Your verdict must be unanimous. It is your duty to work with each other in an effort to reach an agreement, if you are able to do so without giving up your individual judgment. Each of you must decide the case for yourself, but you should consider the evidence impartially with the other jurors. You should not hesitate to change your opinion if you are convinced it was wrong. But you should not change your opinion about the weight or effect of the evidence just because of the opinion of other jurors or in order to return the verdict. If it becomes necessary for you to communicate with me during your deliberations, the jury leader should send a note to the bailiffs. All questions to the judge must be reviewed by the attorneys. This may take a period of time, and some questions may not be answered. After you have agreed on your verdict, the jury leader should fill in, date, and sign the formal verdict using the appropriate form which accompanies these instructions. The jury leader should then notify the bailiffs that you have reached your verdict. You will be brought to the courtroom for reception of the verdict. You must not disclose your verdict to anyone until it is returned in open court. One form of verdict is submitted to you for finding the defendant Nichole Rice not guilty or guilty of the offense of murder. You will now take this case, try it fairly and impartially between the state of North Dakota and the defendant, and return such verdict as is warranted under all of the evidence and these instructions. Dated the 25th day of March, 2025 by the court, Richard L. Hagar, District Court Judge. Ladies and gentlemen of the jury, I was in charge of your life. Now you are in charge of mine.
Like that.
Can I have the bailiffs come forward, please? Thank you.
There's a flash on the screen.
Hands, please.
It only affected
You solemnly
us.
swear to keep the jury together until they are returned to the court and not permit anyone to communicate with them unless you are directed to do so by the court, so help you God. Thank you very much. You may lead them out now.
As they go out to deliberation, I'm going to start the timer right now. Let's get rid of our justice counter. The judge giving us a whopping 68 hammers of justice during this case, which is great. Thank you, sir. Okay, I cannot. I'm trying to use a mouse from across the screen. It's just not working. Let's see right there. There we go. See what we can do to get this on screen again real quickly. Super source, box source 3 is going to be 4. Accidentally paused there. Oh man, it's one of those days. It feels like a Monday all over again. Let's shrink this one down. Then make it bigger this way. I know the thousandth of a second thing drives people nuts, so we'll get that cropped off here at the appropriate time. Give it a minute. We'll crop this down. All right. Are they going to deliberate already? They are gone deliberating. Yes, they are. Madeline Love, thank you very much. I appreciate that. I like to look at this setup as well. So we have a jury verdict clock, which I'm going to try to build a little better. Let's see. That's going to be 2. Box size 2 is going to grow just a wee bit, like so. And then we'll crop it down so you don't get all the portions of a second. Why is that not working? We have a poll up right now that, there we go. It says, how long will the jury deliberate? And so far the winning option is 3 to 10 hours, which would put it on a Wednesday verdict, today being Tuesday. This is a tough one, Mary. Here, this is all circumstantial evidence, and I've been cool with circumstantial evidence in the past. The state has proven pretty solidly that she is a great suspect, and they have said that she's their only suspect. I do have a hard time thinking that that she's Dexter level professional on this. That at 18 years old, she was able to commit the perfect crime and leave no evidence. And then her whole downfall was that she talked about it. I do think that if she is convicted, she only has herself to blame. Brandy's doing a live stream with Aunt Bever tonight. There's no way Judge Cannoni is going on a show with somebody. There's no way. Judges don't do that, especially during a case. Is she going to be Aunt Bev? Is she going to dress up? I think there's a joke in there somewhere. Brandy's amazing, by the way. If she does get anybody, it would be Brandy that does it. Oh, Auntie Deb. Why did I say Judge? Did it say Judge Bev? With Aunt Bev. Okay, Aunt Bev is different. It's another creator. All right, that's different. I was thinking the judge. Judge Canoni would not do that. But that's awesome. I'm happy for her. That's going to be, she's going to do great. She's done a great job with this trial. Judge Bev only works till 4 p.m. That's another reason why she wouldn't. This one won't go fast. I say too much doubt. I haven't seen anything that removes Nichole from the suspect list for me. There's nothing in here that would cross her off. In fact, there are a few things that would highlight her on the list, but it hasn't been proven, right? It's just the fact that nobody else could have done it. So the girl who also said she wasn't there must have done it is a bit of a stretch for me. I'm not cool with that. So I'm gonna lean on the not guilty on this one. Although in saying that, I do think it is close. Let's see, box 2 left. All right, that is our deliberation timer. Still has Hagar's justice counter on there, but it works. I can see how someone could find her guilty, though, in this situation. They would have to find a couple key witnesses as very reliable. One of them would be her aunt, her uncle, the two friends, her ex-boyfriend, Jesse Pinkman's lookalike, and the other lady that she drove in the car with for a while. They have to be very believable. To me, they were not very believable, partially because just the sheer amount of facts and the delivery for the aunt and the uncle, how their stories matched up perfectly, how they had all the details. And wanted to be there for the trial and things like that. I think they might think they remember it right, but I think they remember things from the show or some things they've heard and read. And I don't think the drunk boyfriend saying that she was at a party and he heard her say "I did it" is. I mean, what if it was out of context? What if he missed half the sentence? It's like somebody said "I did it," and he heard the "I did it" part. I can't hang my hat on that for some reason. I'm just not there. Auntie Reed, did they arrest already? Not only have they arrested, the jury is deliberating. Oh my goodness, you missed spicy closing arguments. Here's what I predict. We have a verdict or a hung jury. Doesn't matter. Whichever one it happens. Afterwards, the prosecution and defense are going to rumble in the parking lot. They hate each other. They absolutely hate each other. I just knocked over my equipment. These are transmitters, 4K video transmitters like the kinds they were using in court. It was sticking down from the TV like this. I was just holding it up when you weren't looking to see if it was the same model that I had. And it was. It was a good closing. I think the state did a good job on the closing. I don't think defense did. What's the saying? When the facts are on the table, you hammer the facts. When the facts are on your side, you hammer the facts. If the facts aren't on your side, you bang the table and scream like, yeah. I think we saw in the defense that he was doing a lot of yelling, but not a lot of talking about facts. He got a lot of passion in there. He got loud. He got obnoxious. He made a couple of rude statements about some of the witnesses and their appearance. He teased the issue with Minot Police Department and the investigation they've had into some of their finest and what may or may not have happened there. He got into that, but he didn't raise reasonable doubt very effectively. And the points that he did raise, the state came right back and said, nope, look a little closer. Here's what we've got. This is why. Not a fan of the defense closing. I wish you could have taken the snark out of it. I wish you could have delivered it a little more professionally, instead of a little. What was her opening comment? He says he's not attacking Minot Police Department. Well, sure seems like that to me. Yeah, that's a bad foot to get started on. Amanda Florentine says, Ari, I haven't been able to follow this one in depth, but what do you think? Do you think she did it? Love your show. From Detroit. Amanda, thank you very much. Amanda, I love cold cases, but they present challenges. And unfortunately, they're the sorts of challenges that oftentimes leave us frustrated at the end because it was cold for a reason. The case, went cold and we didn't get anywhere. I think all they did was stir everything up and then try to move forward with a case. I didn't see really anything major that, as far as evidence goes, other than this one person says that we told you this a long time ago and you didn't say it. And so there's our smoking gun. She admitted at a drunk party, an ex-boyfriend says that she said she did it and her ride. That's the new evidence. That's what's going to take us from a 18-year-old cold case to a jury trial right now. I mean, there is more smoking gun in the Minot police report that came out right before trial started than we saw in this trial. That, to me, puts more doubt into the investigation than their new evidence puts into, a solid case. Thank you for the super chat. I have to say, in my mind, the state has proven that she is a suspect and that she's a suspect for a good reason. But I don't think they've gone that extra length to prove that she did it. That she, in fact, killed her. A lot of speculation, innuendo, smoke and mirrors. Cold cases with DNA advances are good. This was a cold case with... I've never seen a prosecutor just disregard or just, ignore the DNA under the fingernails because there's no timestamp on DNA. Why did she say that over and over? There's no timestamp on DNA. Ignore that. Why do you test for it? Why do you swab? You all know there's no timestamp on DNA. Why do the police swab on their fingernails? Because when a victim is brutally murdered, oftentimes there is DNA under the fingernails of their attacker. That's why you do it. And when you got the result and it came back and the gender didn't match your suspect, you're like, never. Pay no attention. Pay no attention. I can promise you if that DNA had been inconclusive, but enough to say it was female, they'd be like, and here it is. Yeah, we know it's not her DNA, it's somebody else's under her fingernails. You can guess whose that is, right? It's that part bugged me a little bit. Purple Coconut says, I'm on the screen. You are. You're on the screen. As we continue deliberations here. Let's see. Oh, let's go like this. Box source 3, box source 2. There we go. We are waiting for everything to happen. Let me move the counter so you can see it a little better. There we go. 13 seconds. Woman 406 says, recovery addict, my town just closed a 26-year-old cold case. Unfortunately, I know the one who did it. He's appealing, and there's a 4 to 5 page letter to the judge. Whoa. That's a long time. 26 years. That's how old I am. Just kidding. I'm past that a little bit. Defense didn't hammer on DNA either. I think they did. They said, you're going to see the report. Look at the report. Look at who wasn't tested. Look at what suspects were not tested. We're looking forward to the fan of doom soon. You're talking about Karen Reed. If I were on the jury, guilty, how can we just disregard her admissions? That says it all to me, Stacy. I don't blame you for that. If you weigh that evidence and it's solid for you, 100%, I'd support you in making that decision. I wouldn't try to talk you out of it. Was Devon Hall known to the victim? I don't think he was. Looking at the poll as far as how long the jury would deliberate, we're going to end that here now. You've all had a chance to vote. If you haven't, it's your own dang fault. Let's see. If you have voted, just click the like button so I know that we've got everyone's vote in. That would be great. I'm showing about 750 votes, 768 votes on how long the jury will deliberate. The three options were less than an hour, 1 hour to 3 hours, which would be a verdict today, roughly, not knowing exactly how late they're going to go tonight. Then 3 hours to 10 hours, which would put us on Wednesday with 48%, and a whole 14% coming in saying there's a hung jury, which might happen, probably Wednesday at the soonest. But we'll end that poll with just shy of 780 votes in. And if you look in chat, you'll see the poll results there. And I'll post them again. There we go. Okay. DNA means nothing to me considering it was one singular fingernail. There's 9 others. I wish they'd asked the question about this. I wish that they had said as they collected the evidence, did you swab each finger individually, or was that one swab that was one swab for the left-hand fingernails and one swab for the right-hand fingernails? I wasn't clear on that. I didn't hear that evidence. They said it was under one fingernail. One time they said it was one hand. But we also saw there was no sign of a struggle and that she died, that she could have lost consciousness nearly immediately after this attack. I mean, the position she was in, is indicative of losing consciousness nearly immediately. She was kneeling on the bed and lying face down. It's not a position you end up in after a struggle, right? Let's see. I have to play a little soundbite here really quickly because I'm trying to get this fixed. Let's see if this will work.
I don't like podiums, Your Honor.
Yep, got it. Nailed it. Okay, export as audio only.
It's bigger than you. It's bigger than me. It's bigger
than all of us.
I don't like podiums, Your Honor.
That's it. Export as audio only as podium. We'll make a new sound effect for that.
Thank you, sir. You're my new best friend.
All right. Podium it is.
I'm the one who gets to say that.
Yes, you get to say that. Hang on 1 second.
Happy birthday. You look good.
That was yesterday. All right. I vote for soundbite, Don't Call Me Bud. Where's that from? Did that happen in this court? I know I missed one of the soundbites, but...
Because he's the guy.
Somebody just sent me a video of roaches fighting. I don't know who won.
This one's going to be called Podium.
The zombie apocalypse may be upon us.
You guys are doing everything.
If they didn't, I would lose my mind.
I think I'm about to catch a whooping.
And now let Murdoch stole it.
How does he do that?
you guys are going nuts here. Hang on.
I'm not a camel.
I'm gonna take back control in just a minute.
I'm not a
test
cat.
audio.
I don't like podiums, Your Honor.
There we go.
I object.
Apply. Refresh. Done. Podium is
In
now
front of the Walmart.
Don't miss the forest for the trees.
Happy birthday. You look good.
I don't like podiums, Your Honor.
There you go. Greetings. It worked. All right. With that said, let's go back to talking about the case. This was the first trial that no Walmart was mentioned in, says Sinbad. Oh my goodness. Angelique, somebody needs to send me the COG soundbite. I cannot find it. I don't remember where it was. You'll have to send me a clean, clear clip. I remember that it was a little hearing of the guy just saying I was a cog or something like that, and cog in the machine. The Walmart, but Tesla showed up. Tesla showed up. Not just Tesla. Who was the other one that came right before then? Another weird reference. Perry Mason was brought in on this one. What is camel? I'm not a camel. That one. It was not a trial we followed. It's just it's a meme in the law world. Amtrak was in quite a few times.
I'm not a cat.
Cielo says, missed your birthday. So happy birthday, Scott. Cielo, thank you very much. Very generous super chat. It says 20 in the top corner, which means this is your 20th super chat, I think. That is just awesome. I'm going to like that one. That's the 20th time you sent a super chat on a live stream. No murder aisle special on this one, probably because the case was so old. Where was Walmart 20 years ago, right? That's the question. Where was Walmart 20 years ago? It wasn't as prevalent in our lives as it is right now, right? Oh yeah, we had the C word 2 times yesterday, 2 times today. Are all the cakes gone? They were gone yesterday. Yeah, they were delicious. What was for birthday dinner? I thought it was going to be hamburger stroganoff because that's what I asked for. It turned out that my kids, instead, knowing that one of my favorite foods is San Francisco's finest rice-a-roni, chicken flavor, made that for me. So I had rice-a-roni and chicken instead. They mentioned a gas station instead of Walmart. They mentioned a truck stop was mentioned as well. Probably where the cheap knife came from. Can we do another guilty, not guilty poll? We've already done our guilty, not guilty poll. We do it at the end of close of evidence, traditionally through every trial. Rice-a-roni, what? I know. It's the San Francisco treat. You can't tell me it's not your favorite. The secret to making good rice-a-roni is cooking the vermicelli to perfection. That's the secret. Other than that, you can get the water amounts wrong, the butter amounts wrong. You can spill half the seasoning packet. You're still okay. It's the browning, the vermicelli, and it has to be with butter, not margarine. I'm sorry. If you cook with margarine, you're a heathen. But other than that, it's perfect. See Mama Larity's comment. Let's see. Sorry, they're going fast. Please do a sound for Judge Hagar's. Wrong. That will stick with me for a long time. Oh, where was that? What day was that? I've got all that recorded, so I can save that. Did they ever recover a pink iPod? No. I wonder why. I'm Irish. What the heck is rice-a-roni? It's you have to Google it. It's a not an instant, but it's a packaged meal served with dry rice, and you cook it with seasoning, a seasoning packet, and it becomes a tasty treat that will treat you right.
I don't like podiums, Your Honor.
Similar to Ben's rice in the UK.
bigger than you.
It's
It's bigger than me. It's bigger.
It's bigger than all of us. It's like rice. What do you say? It's like ramen, but rice. No, it's not that. It's so much better than ramen. Is that all you had for your birthday dinner, Rice-A-Roni? No, Maureen. I ate like 4 bundt cakes as well. Plus, I had another homemade double stack yellow cake with milk chocolate frosting upside down in the bowl with milk.
In front of the Walmart.
I just Googled Rice-A-Roni, and you don't like it. Mama Larity. No. Oh, it was a staple growing up. So what did Mrs. R.A. get you? A paid life insurance premium? She did pay my life insurance yesterday. We paid that on my birthday. But she bought me a bike seat. And I think it's outside on the front step right now. Had a really good birthday. I enjoyed watching court with y'all yesterday. It was fun. What's with the cake and milk? Pause and campfires. All I can say is try. Get yourself some birthday cake. Flip it in a bowl. Eat it like cereal with milk, like drowned in milk. It's messy. It's not pretty to look at, but it's delicious, and you can't go wrong. Audrey Henry says 4 cheese Rice-A-Roni is the best, and it came with a super chat, so it's that's basically like laying down the law. Must be true. A bike seat and anti-wedgie underpants, I hope. I've never had the problem with I just had the problem with the bike seat. I didn't realize the other part was an issue. I've got plenty of like biker shorts I can wear, right? Those spandex beauties. So she bought you something that may benefit her. It's only fair misconduct. Previously, when she would give birth to one of our children, I would go out and buy myself a new firearm. And so this is just like, it's coming full circle now. I figured she got a baby, I got a baby. I thought it was fair. But I've learned since then. But did you play Pop-Tarts while eating the Rice-A-Roni? No, but I did play Pop-Tarts over the weekend and had a lot of fun. Friday, we played Pop-Tarts. Does Mrs. Ari use something in place of mushrooms in her hamburger stroganoff? I don't like mushrooms either. Maureen, I think you asked this yesterday. I apologize for not answering that. No, we just, if you were to use like Campbell's cream of mushroom soup in the hamburger stroganoff, we would just use Campbell's cream of chicken soup instead. But you still use beef in the stroganoff. So there's no substitute put in. You just use cream of chicken instead. It's delicious. So you rode your bike without a seat before? No. It's just before, the seat was not as uncomfortable as it is for me now. All right. Have you tried lemon curd with yogurt? I have not. What is hamburger stroganoff? All right, here's how you make it. Take a pound of hamburger and you brown it in a frying pan. Preferably, I would say don't start with frozen hamburger because it's never good to cook frozen hamburger. You just don't get the flavor right. So I'd say like 80-20 lean hamburger. Can do salt and pepper, but you don't want to do too much seasoning beyond that as you're browning the hamburger. Once the hamburger is all browned, I would strain off any of the grease. So it's pretty much ready to just burn to the bottom of the pan because it's fairly dry. Then you add a small packet of sour cream. You add 2 or 3 cans of Campbell's cream of soup, either mushroom or chicken, depending on your liking. And you mix those in and it becomes like a gravy with a meat. What do you call that? A mixture. The secret, though, is add in a little paprika at that point. So that's going to give you their flavoring. While you're doing that, you're also cooking noodles, and it has to be egg noodles. It can't be spaghetti noodles, can't be elbow macaroni, can't be lasagna noodles. You have to do egg noodles, and you cook them. Don't overcook them so they're just like falling apart, but just make them perfect so they're not, al dente, and then you serve it with a bed of noodles topped with this hamburger stroganoff on top. And it's delicious. And then of course you can do like some just about any sides you want. Everything from asparagus to whatever. Yes, ground beef is hamburger. Can we read the new dog in read, please? The new doc? What's the new document in read? Is it a spicy one? Who is al dente? They shouldn't be crunchy. Noodles should not be crunchy. We call that homemade hamburger helper in my house. Hamburger helper wishes they could be our hamburger stroganoff. Jury selection next week in Karen Reed. Amber, that is crazy that we're already to the new trial. Apparently it just dropped. Let me check Mod Chat to see if it's dropped in Mod Chat. Oh, somebody just sent me a text. Got it. I don't know who sent this to me, but thank you. Let's send this to send a copy via airdrop to. That's where my timer is. Can't make the timer go away. Give me a second. We can see if we can pull it up here. This is an order on the motion to dismiss. Is that the one you want us to read? It's the motion to dismiss response. Okay, I can't get this to go where I need to. I'm going to read it from right here. I'm sorry, I can't put it on the screen while I still have the timer going. I want the timer to stay on the screen. Memorandum of Decision and Order on Defendant's Motion to Dismiss for Extraordinary Governmental Misconduct. Who is this from? This is the Superior Court Criminal Action, Commonwealth of Massachusetts. Signed by who? Who signs this one? This is... those are conclusions. Yeah, there's a ton. Beverly Cannoni. Looks like it's signed by the judge. Here we go. On June 9th, 2022, a Norfolk County grand jury indicted defendant Karen Reed on charges of murder in the second degree, manslaughter while operating under the influence of alcohol, and leaving the scene of personal injury and death following the death of her boyfriend, John O'Keefe, on January 29th, 2022. The Commonwealth's theory of the case is that the defendant, while intoxicated, struck and killed O'Keefe while operating her vehicle in reverse and left the scene. Trial on the matter began in April 2024 and concluded on July 1st, 2024 with a mistrial. The matter was set for retrial in April 2025. Ahead of the retrial, the defendant has filed a motion to dismiss for extraordinary government misconduct. Such a drastic sanction is justified only in response to the most egregious and truly harmful conduct. In all but the worst cases, the appropriate remedy is at best a new trial, such as the one that is scheduled to begin soon. Because the claimed violations here did not rise to the level that would justify the most draconian sanction of dismissal, and because the defendant's constitutional rights can be fully protected for the incoming trial, her motion to dismiss is denied. Is this the one we wanted to read? Stacy says, got paid today. Happy birthday, R. I love it here. Wish I could give more. You're the best. Stacy, thank you so much. Appreciate that. Discussion. Dismissal of charges with a prejudice is the most severe sanction that this court can impose on a criminal case to remedy misconduct on the part of the Commonwealth. The dismissal of a criminal case is a remedy of last resort because it precludes a public trial and terminates criminal proceedings. Absent egregious misconduct, or at least a serious threat of prejudice, the remedy of dismissal infringes too severely on the public interest in bringing guilty persons to justice. A dismissal, they've got some case law where a dismissal with prejudice for government misconduct is very strong medicine and should only be prescribed when the government misconduct is so intentional and so egregious that the new trial is not an adequate remedy. Two parallel legal principles govern the resolution of cases involving prosecutorial misconduct where dismissal is contemplated. First, where the prosecutor fails to disclose evidence the defendant is entitled to receive and the defendant is prejudiced by the failure to disclose, a motion to dismiss should not be allowed absent a showing of irredeemable harm to the defendant's opportunity to obtain a fair trial. Alternatively, in rare circumstances, a prosecutorial misconduct that is egregious, deliberate, and intentional, or that results in a violation of constitutional rights may give rise to a preemptive prejudice, and the drastic remedy of dismissal of charges may become an appropriate remedy. More case law. The defendant here argues that the Commonwealth committed egregious discovery violations by destroying and or withholding exculpatory evidence that the Massachusetts State Trooper interfered with the jury during the first trial warranting dismissal of the charges. As discussed below, the defendant has not demonstrated that she suffered any prejudice as a result of discovery violations that cannot be cured by her new trial, and has not substantiated her claims regarding interference with the jury, which, as discussed in detail below, are baseless. Commonwealth's discovery violations. A. Discovery obligations. The due process clauses of the Federal Constitution and the Massachusetts Declaration of Rights require the Commonwealth disclose to a defendant material exculpatory evidence in its possession or control. Evidence is exculpatory if it provides some significant aid to the defendant's case, whether it furnishes corroboration of the defendant's story, calls into question the material, although not indispensable, element of the prosecution's version of the events, or challenges the credibility of a key prosecution witness. Exculpatory material is subject to automatic disclosure. The Commonwealth's duty to disclose exculpatory evidence to criminal defendants is further reflected in Massachusetts Rules of Criminal Procedure and the Rules of Professional Conduct. The duty to disclose derives from the core responsibility of a prosecutor to administer justice fairly. Rule 14 of the Massachusetts Rules of Criminal Procedure pertains to the prosecutor's discovery obligations and the materials subject to automatic discovery. The rule in effect at the time of the discovery issues here provides that the prosecution shall automatically disclose to the defense certain evidence relevant to the case in the possession, custody, or control of the prosecutor, persons under the prosecutor's direction and control, or persons who have participated in investigating or evaluating the case. This includes any facts of an exculpatory nature and material relevant police reports, photographs, tangible objects, all intended exhibits, reports of physical examinations of any person or scientific tests or experiments, and statements of persons to party intends to call as witnesses. Rule 14 further provides that when a party has provided all the discovery required by Rule 14 or a court order, it shall file with the court a certificate of compliance, stating to the best of its knowledge and after reasonable inquiry the party has disclosed and made available all items subject to discovery. This is from the Superior Court, people. Am I too loud? Part B, Canton Police Department surveillance footage. Factual background. On January 29th, 2022, after O'Keefe was found dead in the snow outside the Albert residence in Canton, Canton, Massachusetts. I just moved states really quickly. Police towed the defendant's vehicle to the Canton Police Department. There were multiple surveillance cameras in use at the CPD that captured the defendant's vehicle on a flatbed tow truck as it entered the Sallyport at approximately 5:30 p.m. There were also cameras inside the garage where the vehicle thereafter remained. According to the Commonwealth, surveillance footage from those cameras is automatically overwritten on a regular basis. Footage from the night in question was not lost, however, because CPD Sergeant Giampietro, that's a name, followed his customary practice of downloading the recording to a hard drive in 6-hour segments. On February 2nd, the defendant was charged with manslaughter, motor vehicle homicide, and leaving the scene of personal injury and death of Stoughton District Court. That day, the defendant filed the emergency motion for preservation of evidence pertaining to certain specific evidence in connection with the charges, which was granted. The preservation order sought to preserve, inter alia, all physical evidence, including any present or near the decedent at the time his body was discovered, anything found at the alleged crime scene. The lead investigator in the matter, Massachusetts State Trooper Michael Proctor, took possession of the requested CPD video of the Sallyport in February 2022, but did not turn it over to the prosecutors. Instead, for reasons unclear on the record, he kept the material in his case file. On June 9th, 2022, Norfolk County, does that seem suspicious to anybody? That is crazy. On June 9th, 2022, a Norfolk County grand jury indicted the defendant on charges of murder in the second degree, manslaughter while operating under the influence of alcohol, and leaving the scene of a personal injury and death. On October 5th, 2022, this court issued an order directing the Commonwealth to provide the witness with, inter alia, all crime scene photographs or videos taken in connection with this case, including but not limited to photographs documenting the purported recovery of pieces of white and red plastic outside the residence located at 34 Fairview Road on January 29th, 2022, and February 4th, 2022, including the metadata associated with these photographs and videos. Wow. My internet just crashed. Not internet, but my chat just crashed. That's crazy. I'll bring it back. YouTube doing YouTube-y things. YouTube doing YouTube-y things. There I am. And chat's coming back. Pop out chat. Okay. It's back. All right. The metadata associated with the photographs and videos. Several months later, Amber's sending me attachments. I might be reading the wrong thing. Use the buffer if I'm reading the wrong thing, Amber. I can hear you. Several months later, in June 2023, Proctor asked CPD whether it had in its possession any exterior Sallyport video showing the defendant's vehicle on the flatbed of the tow truck in January 29th, 2022. In response, so Proctor is asking that because he already had it. In response, CPD gave the state police the video from the main driveway side exterior Sallyport camera. Proctor took possession of this video, but again, for reasons unexplained, did not turn it over to the prosecutors. Instead, he placed it in his case file. This footage shows the exterior of the Sallyport when the defendant's vehicle was brought into the CPD garage. The recording is dark, blurry, and grainy, and the condition of the passenger side taillight, a significant issue and dispute in this case, cannot be discerned. On February 1st, 2024, Proctor testified before a federal grand jury investigating the investigation into O'Keefe's death. Redacted. 3 months later, on April 4th, 2024, ADA Adam Lally received Proctor's federal grand jury testimony. After reading Proctor's testimony, Lally asked if the trooper if he was in possession of the video footage referenced therein. Apparently, he referenced the video footage. In response, Proctor gave Lally the Sallyport front wall camera footage provided to Proctor in February 2022, but not the main driveway side exterior Sallyport footage provided to Proctor in June 2023. Lally immediately turned over the Sallyport front wall camera footage to the defense, along with the footage from CPD main driveway showing the SUV on the flatbed. None of this footage contained a view of the back of the defendant's SUV. On April 10th, 2024, Lally filed a certificate of compliance indicating that to the best of the Commonwealth's knowledge and after a reasonable inquiry, it had disclosed and made available all items subject to discovery pursuant to Massachusetts criminal proceedings rules or court order. When defense counsel reviewed the Sallyport front wall camera footage, they saw that 42 minutes of footage was missing. The defense raised the issue to the court at a hearing on April 12, 2024, days before the trial was set to begin, arguing that the missing footage was critical to the defense's theory. The Commonwealth explained that the footage was intermittent because the camera was motion activated. So it surprisingly didn't catch the part where there was motion. Trial began on April 16th, 2024, with the first day of evidence on April 29th, 2024. On April 17th, Lally received footage from the Sallyport interior back wall camera from the CPD, which had been looking for continuous camera footage of the Sallyport on the relevant date. On April 4th, 2023, on April 23rd, 2024, Lally provided the Sallyport interior back wall footage to the defense. The images contained in this footage were inverted. State Police Sergeant Buchanan testified on June 5th and 6th, 2024. During his direct examination, Lally showed the inverted Sallyport interior back wall footage in open court. Because the video was inverted, what appeared on screen was right side of the vehicle was in fact the left side and vice versa. The direct testimony did not alert the jury that the video was inverted. On cross-examination, however, the defense counsel questioned Buchanan extensively about the inverted image. The CPD began to review a review of other video surveillance footage in an attempt to explain the inverted image and to respond to allegations that it had deliberately manipulated the recording. As part of this process, CPD Chief Rafferty reviewed surveillance footage from cameras in the hallways and the parking lot at CPD in the early morning hours of January 29th, 2022, prior to O'Keefe being discovered in the snow. Stop. In 2024, the CPD started reviewing video from January 29th, 2022, which had been written over after 30 days, but it was still there. The rear lock cruiser side camera had recorded ATF agent Brian Higgins, a witness called by the Commonwealth at trial, walking across the parking lot at 1:34 a.m. holding a phone near his face, probably for comfort, because that's not a butt dial. In September 2024, Special Prosecutor Brennan joined the prosecution team. On October 10th, 2024, he provided the rear lock cruiser footage along with other surveillance videos, the CPD interior hallway, the church side exterior Sallyport, and rear lot main side to the defense. On November 8th, 2024, the defense emailed a Special Prosecutor Brennan requesting all raw video footage from the CPD, which shall include, but is not limited to, all cameras capturing the interior of the CPD and or exterior of the CPD, including all parking areas, entrances, and exits, and garages between January 29th, 2022 at 12 a.m. and January 29th, 2022 at 11:59 p.m. Special Prosecutor Brennan responded that he would request that the CPD collect and produce all footage responsive to the request. Thereafter, Brennan asked all associated law enforcement to go through all files and databases to facilitate a review of any footage. During this process, Brennan came into possession of the main driveway side exterior Sallyport footage originally obtained by Proctor in June of 2023 and not previously turned over to the defense. On January 28th, 2025, the Commonwealth turned over the main driveway side exterior Sallyport video to the defense. As noted above, the footage shows the exterior of the Sallyport when the defendant's vehicle was brought into the CPD garage, but the quality of the recording is noted as poor. Defendant's arguments. The defendant argues that the Commonwealth provided an untimely disclosure, withheld or destroyed certain CPD surveillance video in violation of Rule 14, Brady, and the court's preservation order on October 5th, 2022, order on motion to compel discovery. She further contends that the timing and quality of the video footage that has been produced demonstrates that the Commonwealth sought so intentionally to deprive the defendant of exculpatory evidence, according to the defendant. According to the defendant, somebody mowing my lawn? Someone's mowing my lawn. They do this occasionally. According to the defendant, the Commonwealth's conduct was so egregious that dismissal is warranted. This argument is flawed in several respects. First, contrary to the defendant's argument, there was no court order requiring the Commonwealth to preserve or produce the CPD surveillance video in the first trial, before the first trial. The February 2nd preservation order required the Commonwealth to preserve all physical evidence, including anything present on or near the decedent at the time the body was discovered, anything found at the alleged crime scene. This order did not extend to the surveillance footage from the CPD. Massachusetts case law reflects a clear distinction between physical evidence and video surveillance footage. Wow. Moreover, where the physical evidence described in the preservation order was further defined as including anything present on or near the decedent at the time his body was discovered and anything found at the alleged crime scene, the order cannot reasonably be interpreted as including surveillance footage from the police station. On October 5th, 2022, order on the motion to compel discovery also did not require the Commonwealth to produce any CPD surveillance video into the defense. That order required the prosecution to produce evidence of all crime scene photographs and or videos taken in connection with this case. The CPD was not part of the crime scene, and therefore the order did not compel production of the CPD videos. All crime scene photographs and or videos, so it's crime scene videos taken in this case, or all crime scene photos and all videos taken in the case. This is not the end of the inquiry, however. The absence of a court order requiring production of the CPD surveillance does not foreclose the possibility that production may still have been required under Brady and or Rule 14. The defendant contends that the prosecution should have inquired of the CPD if any footage existed and then produced all the footage because she maintains that it contains exculpatory evidence. Specifically, the defendant argues that the footage shows Proctor approaching the taillight in a manner that she says supports an argument that he tampered with the evidence. Assuming, without deciding, that the footage is actually useful to the defense, dismissal is not warranted because defense counsel actually used this evidence to advance the tampering theory at the first trial and can do so again at the retrial. In addition, while the current Rule 14 makes clear that the Commonwealth is required to disclose to the defense as investigative materials, video and audio recordings in the possession, custody, or control of any member of the prosecuting team, that includes the police, the Rule 14 in effect at the relevant time had no such requirement, nor did Rule 14 in effect at the time clearly state the prosecutor's duty to inquire whether such evidence exists. Because the defendant made no specific request for the Commonwealth to produce such evidence until after the first trial, it is not clear on the record how or when the Commonwealth should have known that the surveillance video was germane to the defense. Until the Commonwealth knew, for example, that defense theory included that law enforcement tampered with the taillight while it was at the Sally Port, or that Higgins was a proposed third-party culprit, it had no reason to inquire as to whether any relevant video footage existed. This is not to say that the Commonwealth had any duty to turn over the Sally Port interior back wall footage before the first trial. The production during trial was undoubtedly late. However, the defendant received the video more than a month before it was submitted into evidence, and because she has advanced no argument as to what, if anything, her counsel would have done differently if the disclosure had come earlier, the defendant has not shown she was prejudiced as a result of the late disclosure. The defendant also argues that the Commonwealth has violated Rule 14 by failing to preserve all the footage with the metadata. There is no merit to this argument. The defendant did not make any specific request for the original footage with metadata before the first trial or before it was overwritten. There is nothing in the version of Rule 14 then in effect, or the current version, that entitles the defendant to the metadata or log files underpinning surveillance footage in the possession of the Commonwealth, and the defendant has not directed this court to any authority suggesting preservation of such evidence is required, nor has the defendant demonstrated that the metadata would have been exculpatory evidence. She offers no evidentiary support for her argument that the metadata would confirm her theory that the members of the CPD or state police doctored the footage to prevent jurors from seeing the condition of the defendant's taillight before it was within the custody of law enforcement and from seeing Proctor damage the taillight. A defendant who seeks relief from the loss or destruction of potentially exculpatory evidence has the initial burden to establish a reasonable possibility based on concrete evidence rather than a fertile imagination that access to the evidence would have produced evidence favorable to his cause. Well, lastly, as to this claim, the extent that the defendant claims to have rights based upon the Commonwealth's handling of metadata, she will have the opportunity to seek redress in the context of a retrial. Part C, withholding of exculpatory statement of Jennifer McCabe. Factual background. On May 7th, 2024, during the first trial, the defense produced reciprocal discovery to the Commonwealth regarding the location information of witness Jennifer McCabe's cell phone. The location data showed that on January 30th, 2022, McCabe went to the home of Canton Police Sergeant Michael Lank, who was one of the first police officers to arrive at the scene on the morning of January 29th, 2029. In anticipation of her trial testimony, the Commonwealth met with McCabe, Lally, ADA McLaughlin, and Massachusetts State Police Lieutenant Brian Tully were present. Lolly asked McCabe why her cell phone would have been in the area of Lank's house on January 30th, 2024. McCabe says she was with Carrie Roberts, who was picking up her daughter at the residence, and she did not speak with Lank while there. The Commonwealth did not turn over the substance of this conversation to the defense prior to McCabe taking the witness stand. Tully wrote a brief report on the meeting, but it was not produced to the defense until May 29th, 2024. On May 21st, 2024, Attorney Jackson cross-examined McCabe on behalf of the defense. He asked McCabe if anything significant happened on January 30th, 2022. She explained that she went to Lank's house with Roberts to drop off Roberts' daughter, and Lank's wife came out of the house to talk to them. Jackson questioned McCabe as to why she did not report the fact that she had met with one of the first responding officers on the case working for the Canton PD, which is conflicted off the case. He further questioned her on the length of the conversation, who else she talked to at the house, and where she was during the conversation, and if she went in the house. During cross-examination, Jackson also questioned McCabe about the details of her discussions with Lowley, McLaughlin, and Tully about her trip to Link's house. She testified that when Tully asked her if she went to Link's house on January 30th, 2022, at first I said, no, I've never been to his house. Then I thought about it and I said, oh my gosh, yes, I did go there, and that was the extent of the conversation. On June 18, 2024, after the defense had received Tully's report of his meeting with McCabe, Jackson raised the issue of the Commonwealth's failure to disclose McCabe's statements during the meeting prior to her testimony. During trial, the Commonwealth interviewed Jen McCabe, apparently had a full interview with her. Lieutenant Tully took a report, dated the report, and then the Commonwealth held onto the report until after she testified. The interview, the report, and the completion of the report were all done before her testimony. The court offered to allow Jackson to call McCabe back to the witness stand, and Jackson declined, stating, no, Your Honor, I think the court understands. That's not my point. My point is not that I need to call Jennifer McCabe back. I've done the damage that needs to be done on Jennifer McCabe. When the court asked, you what? Jackson repeated, I've done the damage that needs to be done on Jennifer McCabe, and he stated, I don't need to call her back. The defendant's argument is, the defendant argues that the violation of Brady and Rule 14, the Commonwealth withheld the May 10th, 2024 false statement given to McCabe to Tully regarding her visit to Lank's house, which the defendant claims she could have used to impeach McCabe. The version of Rule 14 then, in effect, required that the statements of person the party intends to call as the witness are subject to automatic discovery. The Commonwealth, therefore, should have provided McCabe's statement to the defendant after meeting with her and certainly before her testimony. However, the defendant cannot reasonably claim that she suffered any prejudice as a result of not having McCabe's statement. On cross-examination, Jackson questioned McCabe extensively about how she had told Tully about her visit to Lank's house, why she had not disclosed such events before, and the details of her visit to the house. Moreover, Jackson expressed satisfaction with the damage he believed he had inflicted on McCabe's credibility. When he declined the court's invitation to recall McCabe to the witness stand in this manner, Jackson undermined the newly found claim of prejudice based on the late disclosure. And once again, the remedy for violation for such as this is not dismissal, especially where, as here, the defendant's right can be fully protected as to the retrial. Remedy for discovery violations. We're approaching the 1 hour mark on deliberations, by the way. As noted repeatedly herein, the defendant has not demonstrated that she suffered any actual prejudice based on the Commonwealth's late disclosure or failure to disclose evidence before the first trial. However, even if the defendant were able to show prejudice, the appropriate remedy would not be dismissal of the charges. Dismissal with prejudice is a remedy of last resort. Under the circumstances of this case, where there is a mistrial and the defendant now has the evidence at issue prior to the second trial, she cannot show that she suffered irremediable harm to her opportunity to obtain a fair trial. I'm not reading all the case law. Nor has the defendant shown that the Commonwealth's conduct was so egregious, deliberate, and intentional that prejudice should be presumed. Such a theory should be narrowly applied and confined to situations where the misconduct has cast such doubt as to poison the entire investigation, and a stronger deterrent is warranted to prevent repetition of such misconduct. The facts before the court do not depict a concerted and intentional attempt by the prosecution team to deprive the defendant of discovery, which would have aided her case. Even if the defendant were able to show that the conduct at issue here on the part of members of the prosecution team was intentional, the remedy would be a new trial with a timely disclosure of the evidence, not dismissal. In this case, the defendant's rights to disclosure of evidence pursuant to Brady and the rules of criminal procedure are fully protected because no verdict was returned at the conclusion of the first trial and the retrial was about to start. She had suffered no irremediable loss of constitutional right, and her motion for dismissal on these grounds must be denied. Section 2, Massachusetts State Police interference with the jury. factual background. What will be East Coast time if they deliberate today? Well, right now it is 5 o'clock, so they would go till 7 if they deliberate and did 3 hours today. I'm not sure what the judge will allow. You guys want more of this? I'm getting a no from Barb. Yes from Melissa. 50-50 split. I'm making you hungry. We're getting lots of no's. That's a lot of reading. I've only read like 20 pages. And I got burner phone text. No more. No more. Let's see. A couple other messages. Got the message about the PCZ camera. You say you use an OBS or ATEM. Can you send me a picture of what your current setup is? Like the components? The switcher and all? All right. Who signed it? That was... it was signed by... Judge Beverly Canoni. For the foregoing reasons, the defendant's motion to dismiss for extraordinary government misconduct is denied. The defendant's alternative request for evidentiary hearing on the motion matter to show is denied. Is also denied. So denied. Surprised? No. It is 4 p.m. Central right now, 5 p.m. Eastern. Here's what we can do. We'll get a verdict if I say we're done for the day. That always works. I like story time with RA. I can tell you a story. My first time I ever took a swimming test in the scout program.
I don't like podiums, Your Honor.
In the scouting program. I was a Cub Scout, and I had gone to a scout camp up in, I think it was Mill Creek Canyon, which is a pretty canyon in the Wasatch Mountains. And we had to pass the swimming test so that we could go out in the canoes. You had to pass the swimming test.
Correct?
The swimming test involved jumping in feet first into a swimming pool with lifeguards present and swimming to the other side of the pool and back. Now, I was on the swim team. I love to swim. I'm like a fish. I can hold my breath for over a minute
This is not Burger
while
King.
swimming.
People do not get to have it their way.
I love the water. I'm thinking I can outswim every other boy here on this test. But they're like, oh, jump in feet first. I'm like, I know how to do shallow dives into water because I've started, it's
bigger than you. It's bigger than me.
It's bigger than all of us. I've started on blocks on a diving board. You dive in shallow. You don't dive to the bottom head first. I've started races from the shallow end of a pool. You can do that. And but I'll jump in feet first because that's the requirement. So we all stood there and they're like, all right, everybody on your marks, get set, go. Well, the water was cold and everyone knew the water was freezing cold. But a lot of people were chicken and weren't ready to go immediately. So they hesitated. I did not. I'm like, cold water, whatever, I'll swim in it. So I jump in and, I do a little pencil dive down to the bottom and the feet hit the bottom and I push myself to launch back up. When another boy has thought, I'm going to wait for a minute and then I'll go because I don't want to be the first. So he then jumps and he jumps in right where I jumped in, right as I'm coming up, and he comes down feet first and hits me on the head like that. It sounded like that too. And I'm like, I'm holding my breath. I'm fine. I'm a little bit confused as why he jumped on top of me. But I'm like, turn over, and I'm looking up, like, why is he, holding me down type thing. Lifeguards see this happen, drag me out of the pool immediately. They're like, you failed. He failed to jump in. I'm like, I failed. He landed on my head. I did not get to go that year in the canoes. And it was the last year we went to that camp. I never got to go out in the canoes, which sucked because I had brought my fishing gear so I could fish in that little lake, which was stocked full of trout. And instead, I had to stand on the bank and fish in the river, where everyone else, all the other non-swimmer plebes, had been relegated to. Ask me how I feel about that. It was terrible. It was a Judge Cannoni moment. Did the kid who jumped on you pass? He did. He launched off me and got a head start and passed the test. Bitter much? Did the boy survive? Yes, everyone survived. Nobody drowned. That was story time. I don't know why that story jumped in my head, but I haven't told that in years. Let's see. We put canoes in our high school pool for part of the swimming unit and gym class. That's cool. Did you say dweebs or bleebs? I said plebes. I'm not sure if that's a word, but I had other words for it. I said the word thinking about those poor folk who are lower than me, who don't know how to swim. Plebeians. Isn't that a word? Red Pen, did I use the word correctly? Plebs? I said it wrong. All right, we've passed the 1 hour mark. We're 1 hour and 5 minutes, 1 hour and 6 minutes roughly into deliberation, and the clock is now crooked because that's what happens. I pay big money for this clock. It's the free Google stopwatch. Yes, Greeners, it is a close. There's another word that's very similar. I did not say that.
For the record, I don't consent to that name.
Okay. There we go. Don't we need the seconds up, but it's up to you. If I take the seconds off, people are going to say, why is the clock stopped? Because it hasn't changed for like 40 seconds. All right. Barb Russell says, I used to be a lifeguard. I never was. That sort of burned me a little bit. Like, lifeguards were bad in my book. Danny says, now I'm mad at the kid that jumped me. I don't know who it is. He's out there somewhere, and he's like, I remember that time, but some kid was like drowning, and if I hadn't landed on him in the pool, the lifeguards never would have seen him drowning there under the water, and they saved him and pulled him out of the pool. But I still passed the test. I'm sure his version of the story is very different than mine, but I know the truth. I was just fine. Emily D. Baker was a lifeguard? No way. Like a summer high school job type thing? The boy is a lifeguard now. Yes. It's gone full circle, and now he's pulling people out and failing them for their tests. Amber says, Ari, do you think guilty or not guilty for Nichole Rice? I think, personally, I'd have to go with not guilty. Like, not proven. We've got somebody's kicking the, ouch, my desk as well. The camera in court. Let's see what's up here. There's that one. No action yet. Lifeguard is at fault for not protecting you in a dangerous situation. Yeah, why would they have everyone jump in on top of other people? Oh, EDB played water polo. Okay, this is a serious sport. Water polo is it's like the rugby of the seas. It is a vicious sport. A lot of fun though. We may be going up to Michigan. A couple options. I think there's a case with a wife who poisoned her husband, lit the house on fire. He was able to crawl out and she ran him over a couple times. I think we might be doing that one. There's a couple options. I'll look and see. We've got a couple things going on. You have to be tough for water polo. That's because you can't touch the bottom. You have to tread water so much. Dude, it was probably Michael Phelps. He got his start in life by launching off my shoulders. That's what happened. Yes, I believe it was murder in that case, but we'll let you know. She played water polo in college. I did not do any sports in college. Although I filmed a lot of them. I filmed track. I filmed, don't think I filmed any, didn't film any swimming, but football, track. I think we did some softball once. From now on, when I tell the story, it should be Michael Phelps. This little runt of a kid named Michael Phelps landed on my shoulders. I think Michael Phelps would sue me for that. See, I didn't film any beer pong or strip poker. I did film the Nearly Naked Mile, which was a foot race. It started at 11 p.m. on November 11th, which is winter time. You show up in a whole bunch of gear to stay warm. You shed all the gear, taking you down to just the bare minimum that would make it legal to be visible in public. And then you run a mile, and all the clothing is donated to homeless shelters. Yeah, so it's a skivvies race. And I have a shirt still from it that says Nearly Naked Mile. It's got the outline of somebody running with the finish line banner conveniently covering areas of their body. Should do a fun run. It was my job to film that, and that was interesting. Have a great photo for Cover It looking fashionable, holding a soccer ball. I saw that for the first time today, John. I saw that. You will not be sharing that. No verdict yet. Hour and 12 minutes in. I think we're going to wrap up for tonight. If anything happens, if there is movement tonight, we'll relaunch, which means you'll want to be subscribed. You'll want to have the bell rung to be notified when we go live, and you'll definitely want to be in the group that says, yeah, I liked the original live stream. That way YouTube will tell you about the next one. All right, ever wear a crop top? I don't think so. Nearly Naked Mile while paying taxes if it needs to be more unfun. It was cold. It was cold. I mean, you keep your shoes on, but at the end they give everyone a T-shirt, and the larges went first. Like the big shirts went first. So the slower people who were sort of bigger build ended up just having to drive home in their skivvies because the shirt wouldn't fit over them. It was a poorly planned event that way. I did just say skivvies, yes. All right. Anything else to go over today before we wrap up? Amber, that's a hard no. That's like a that's a wrench losing a felony.
I don't like podiums, Your Honor.
There's a threat.
I think I'm about to catch a whooping.
Josh sent me something. My burner phone's going nuts. I apologize, guys. It'll take a minute to catch up.
How does he do that?
1 hour 38 seconds. Watch this defendant is spicy.
Happy birthday. You look good.
Hey, Judge Fleischer, thank you. Oh, this is a fun one. Okay, let's, where's my remote? I need to talk into my remote. We're going to do 7 instead. Okay, Josh has found one for us that he says we need to watch. 3:56. This one just happened today. And it is at 1 hour 38 seconds. So you get a palate cleanser before we go. That'll give them an opportunity. Okay, can you guys see this? That's 7, right? You guys see that all right? I'm not hearing it. It's because I did it wrong. I can hear it, but you can't. Here we go.
And we'll pass it. Ms. Gutierrez, you want to speak to your lawyer in the interim?
I guess that's the only person I can talk to, so that's fine.
Well, go ahead, talk. If you want to talk, what do you want to say?
We're going to back up just a little bit. Hang on.
As part of the negotiation process, I indicated to Mr. Bowman that the officer told her that this case, he would not give her a ticket for it. And as part of the negotiations, he said, well, drop no insurance. He never filled insurance. It was contingent upon my statement.
Get the officer back in here, Mr. Bowman.
Officer Harris?
I don't know where he went.
I'll call him.
All right, I'm going to give you a few minutes to get him back in here. All right?
Judge Corporal Croxton, if you don't mind, Officer Harris is in court in person. He has several courtrooms. He advised us.
Yeah, but he didn't advise me, Corporal Croxton. I give everybody an opportunity. He's got to let somebody know. He's usually here, so let's try to get him back right quick, Mr. Bowman, and then we'll pass it. Ms. Gutierrez, you want to speak to your lawyer in the interim?
I guess that's the only person I can talk to, so that's fine.
Well, go ahead, talk.
I did
if you
wrong.
want to talk, what do you want to say?
The thing is that I keep talking to all these third parties. For starters, my lawyer just told you that that man.
The Detroit Police Department's 5th Precinct.
Stop. I skipped. I cut 38 minutes into where I should be. I need to start before she starts. So this is backup. I gave you a preview. I did 1 hour 38 minutes instead of 1 hour 38 seconds. So we're going to try this one more time, get the very beginning, because there's some spice happening here that I didn't have the foundation for. One more try.
Please.
Sheriff Harris, on behalf of Ms. Odom, please state your name for the record. Shaylin Odom.
Morning to you. Today is the date and time set for a trial. Is there an Officer Bell? Is there an Officer Bell here? Steve, I think so. Officer Bell, good morning to you. Can you put your appearance on the record, please?
I'm Officer Jemiah Bell from the Detroit Police Department's 5th Precinct.
Very good. Good morning to you. Miss Harris, I'm going to put your client in a breakout room. Get your client an updated offer. Keep in mind, Miss Odom, if you don't like the offer today, it's the day conversation. Go ahead.
We don't need a breakout room, Your Honor. I actually requested discovery on February 25th, 2025. To date, I have not received that discovery. I did have this discussion with Mr. Bowman. Defense is moving for a dismissal.
Mr. Bowman, are you there? All right, let me allow him to respond. And we'll see. I do have the final mark discovery, February 25th, 2025. I'll pass the matter momentarily. Mr. Watsky, good morning. Are you ready?
Judge, Mr. Anthony Gray does not appear to have checked in this morning.
He does not.
No.
He doesn't seem to have checked. All right, what about Gardner? Did you ever speak to Randy Gardner?
That's not mine. That's the father of my client from yesterday.
Yeah, I thought somebody was coming in on him though.
According to Ms. Carter yesterday, she was going to appoint somebody.
Yeah, somebody. I think that's attorney. All right. If there's nothing, let's see who this is. Maybe this is your client. Good morning to you on the telephone at 313-610-0994. Good morning to you. What is your name, please?
Why? 8675309.
Just let you in the room on the telephone at 313-610-0994.
They hung up.
My name is Courtney Glover.
Your name is who?
They got the wrong number.
Courtney Glover.
Oh, Courtney Glover, right. Courtney Glover, that's Mr. Oval Street's client. All right, good morning to you, Mr. Glover.
Grand Rising.
All right, let's see who this is. John Hudson. I'm afraid to let this person in the room because of the way the name is, but let me make sure.
Your Honor, I'm sorry. Corporal Baker here.
Yeah, good morning, Corporal Baker.
Yeah, Your Honor. I was here on Grant, and I don't know what time you KPS. I had another courtroom. I was here on Alexa Grant, and she hasn't showed up, to my knowledge.
All right, Mr. Hudson, good morning to you. Put some clothes on, sir. Who is that? Grant?
Latham.
Who is that on John Hudson?
Christopher Ronald Latham.
Christopher Ronald Latham.
Yeah.
Put some clothes on, sir.
Good morning to you.
Good morning, sir.
I didn't see
you. You were here yesterday, weren't you?
No, I wasn't.
Were you supposed to be here yesterday?
All
right. Is Grant here? Is Grant here? Who is that? That would be Alexis Simone Grant. All right, no show. So Corporal Baker, Corporal Evasion, and Trooper Bukowski. You're free to leave.
All right, thank you, Your Honor. You have a blessed day.
I'm safe,
All right, thank you.
All right.
She gone.
All right. Who do we have next? Are we ready on Ms. Harris? Do you have someone?
Judge. Judge.
Yes.
Ready on Tiana Gunn.
Everything's blurry. Let's fix now.
Judge, this is Watsky. Anthony Gray didn't check in, and he did not pick up his telephone this morning. So I.
Okay. This is the City of Detroit versus Tiana Gunn. Case numbers SP 11251771 and SP 13838001. Appearance for the record, please.
Good morning, Melita Baird on behalf of Tiana Gunn. Judge, I don't have discovery on this, but I did talk to the city attorney, and just to expedite some of this, they said it for trial. As to Officer Hadput, I think you spell it Haupt.
Officer Haupt, good morning to you. Can you put your appearance on the record, please?
Yes, good morning, Your Honor. Nicholas Haupt, Detroit Police Officer, badge 1789.
Officer Allison, good morning to you. Can you put your appearance on the record, please?
Officer Kevin Allison, Detroit Police Department, badge 4443.
What's going on is a allowing and I'm driving while unlicensed.
Judge, as to that Officer Halpert case, the city attorney had indicated to me that I don't know, he didn't have the recollection or remember on that, and it would be a dismissal.
That's correct. As to Officer Haupt's tickets, we're talking about Tiana Gunn?
Yes.
Okay. But as it relates to Officer Haupt, the city is recommending dismissal of that ticket.
All right, next time, Officer Haupt, if you don't have a recollection, you don't have to just let me know, either in the chat or something like that. Just give me a heads up. You don't have to wait.
Thank you, Your Honor.
Okay. What about the other ticket, Miss?
Well, as to the other ticket, I would like to get the discovery on that one.
Today is the trial date, Your Honor. I have an objection to that, such that there had been no previously requests. The Officer Allison is present, and I'm prepared to give Ms. Barrett a gracious going away gift the offer for driving while unlicensed would be allowing
$240 fine. Will dismiss upon payment. Today is the date and time set for a trial. I don't. It's a 2022 driver's license case. I don't know what more discovery is going to be necessary. I think you're fully capable of. I think capable of taking care of it. I have on the comment section of this ticket that the allegation is that this gun ran disregarded a red light at Connor and Forest Street, and she wasn't. It doesn't appear that she was written for the. Well, wait a minute before I speak.
Well, he's trying to figure out what's up with this ticket. Let me just explain. This is a little court hopper we're doing. This happened today in Judge Sean Perkins' personal courtroom. We're watching this. It's something that Josh, one of our great mods, found, and I have no idea beyond that what happened. We're just trusting Josh implicitly, and he says it's spicy and it lasts about an hour. We're on verdict watch, so verdict clock in the bottom corner is continuing. I'm keeping an eye on that. If the jury comes back with a question or a verdict, we'll jump to that instead. Otherwise, we're going to just see what happens here, what Josh found for us. Hope that helps.
Yeah, she never did pay it in disregard of the red signal, so she was written for that. So go ahead and speak with your client. See if she wants to take the deal. Not if people have an obligation to prove her guilty beyond a reasonable doubt.
Okay, go back into the room, Miss Gunn. 7.
All right.
Ready as Mr. Leonard, Your Honor.
Judge, could I have co-host abilities again, please?
Let's go back on the record with Mr. Nicholas Leonard, giving you an opportunity, sir, to speak to counsel. And counsel, what does your client want to do?
Your Honor, the officer for this trial has no recollection, as reported by the prosecutor, and so we seek dismissal.
Sounds fair.
All right, and the officer is Officer Johnson. Good morning to you. Can you put your appearance on the record, please?
Good night, Amber. Thank you so much.
I'm here, Your Honor.
Name, badge number.
Officer Johnson J, badge number 3093.
All right, good morning to you. All right, case dismissed, no recollection. Best of luck to you, sir. I will hope you get continue. I hope your health gets better, okay?
No recollection.
Is that Mr. Nicholas Leonard?
I think this is Detroit, right?
Mr. Nicholas Leonard.
Yeah, your case is going to be dismissed. No recollection, sir. I hope your health gets better, okay?
Yes, thank you so much.
Have a very good rest of your day.
Hey, you too, sir.
This is Billy Jurek.
Oh, good morning, Your Honor.
Good morning. Did I get the pronunciation right?
Garrick.
Jarrett?
Yes.
City of Detroit versus Billy Marie Jarrett, case number SP1219423. Appearance for the record, please.
Billy Garrick.
Elwood S. Berry Jr. on behalf of the defendant, Your Honor.
All right. Today is the date and time set for an arraignment on the bench warrant. Go ahead, Counselor.
Bench warrant.
Yes, Your Honor. Mike, we would waive the reading of the information and stand mute.
You are not guilty plea on your client's behalf and give your client a $0 bond. At this time, I'm going to dismiss the case. Your client has paid 2 related civil infractions. I'll waive the warrant fee. If it's nothing further, Ms. Jarrett, have a very good rest of your day. And,
thank you, Your Honor.
Well, all right. Randy Gardner is. What about Jamon? What about Jamon?
We're looking for Angel Gutierrez.
I'm ready on all of them because Mr. Bowman is present.
Okay. Joshua Galvin.
Yes.
All right. City of Detroit versus Joshua Galvin. Case number SP1672417. Appearance for the record, please.
Elwood S. Berry Jr. on behalf of the defendant. State your full name, Mr. Galvin.
Joshua Galvin.
We've seen him before.
Today's the date and time set for a pre-trial. Mr. Galvin has paid a improper draw on right half of road ticket violation for left of center. I'm going to dismiss the case with paid related civil infraction. There's nothing further, Mr. Galvin. Best of luck to you. Have a very good rest of your day.
Thank you. Have a good day.
Ms. Lewis, let me get the first name again.
Niasha.
Niasha, I'm sorry.
Yes.
All right. Where is Ms. Niasha Lewis on the docket? I see.
8:30, Your Honor.
Not sure what this guy's doing, but it's all blurred out.
City of Detroit versus Niasha Camille Lewis, case number, and the state of Michigan. The fact that this is the state of Michigan versus Niasha Camille Lewis, case number SX3604110, counts 1, 2, and 3. Appearance for the record, please.
Elwood S. Berry Jr. on behalf of the defendant. State your full name, Ms. Lewis.
Niasha Lewis.
Your Honor, for purposes of arraignment, we would waive the reading of the information and stand mute.
They're not guilty of the client's behalf to give your client $0 bond. Ms. Lewis, I'm going to put you in a breakout room with Mr. Berry. He's going to get you an updated offer. Keep in mind, you know, you have an absolute right to a trial. Okay?
She's driving by a Hobby Lobby right now.
Join the room, please. All right, let's pass the matter. Let's go back on the record with Ms. Oldham. Mr. Bowman, can you put your appearance on the record, please?
May it please the court, Your Honor. Victor Bowman, P 33764 for the people.
For the people.
All right. Today is the date and time set for a trial in the matter. There's been a motion to dismiss based on the discovery violation. What's your response on that? Oh, Shayla, the discovery was requested on February 25th, 2025.
Anybody?
Your Honor, if the discovery has not been provided pursuant to the court rule, then the people will recommend dismissal of the disorderly conduct charge.
All right. Case dismissed.
Things are getting dismissed all over the place.
Officer
Bill,
be safe out there. Have a very good day. Miss Odom, best of luck to you. All right.
Period. Thank you. Have a great day.
She's happy.
Dismissed.
All right. Antonio Oliver.
Whoa.
Is Antonio Oliver here?
Yes. Hi. Yes, I'm.
Good morning. What is your Antonio Maurice Oliver?
Yes.
City of Detroit versus Antonio Maurice Oliver, case number SP 161530. Two counts, one and counts two. Here for the record, please.
Sherika Harris, on behalf of Mr. Oliver, please state your name.
Antonio Oliver.
Purpose of arraignment, Counselor?
For purposes of arraignment, my client stands mute.
Enter not guilty plea on your client's behalf. Give your client a $0 bond. Mr. Oliver, I'm going to get you in a breakout room with Ms. Harris. Ms. Harris is going to get you an updated offer. Keep in mind, if you don't like the offer, you have an absolute right to a trial.
Okay.
All right. Join the room, please. Mr. DiMaggio. Mr. DiMaggio, are you there? Attorney Waski is left. DeMario Alexander, good morning to you.
Good morning.
Miss Nash, can we, Mr. Alexander, and
bless you,
Judge, are you junior? DeMario?
Yes, sir.
What is your date of birth?
04.
We don't need that. We're not sending him anything.
Can we see if we can arraign Mr. Alexander, call down to Judge Holmes' courtroom and see if we can arraign Mr. Alexander and give him get the warrants off and give him a pre-trial date down there, please?
Pre-trial.
All right. So DiMaggio, are you ready, Mr. Barry?
No, Your Honor. I'm going to see Mr. Bowman.
Mr. Bowman, room 4, please. He's in there.
This judge is directing traffic like a madman.
We're ready on Glover, Your Honor.
You're ready on Glover?
Yeah.
You, Barry.
That's Demetrius Brown, Tiana Gunn right there. This is Michael Golden. Just
City of Detroit versus Courtney Glover, case number U38126517 and SP 164-29941.
We are in the bathroom with somebody.
Please.
They keep flushing the toilet.
Aaron Oldtree and Bob with Miss Courtney Glover, P number 69167. Miss Glover, can you state your name?
Courtney Glover.
All right, where are you, Miss Glover? Oh, you're on the phone. Mr. Ogletree, today is the date and time set for a pretrial. What do you want to do? What's your client want to do?
The prosecution's offered a 3-month delayed sentence. She wants to plead no contest.
And what's the purpose of the no contest plea?
Potential civil liability.
And on what case is this?
This is the disorderly conduct.
And then she has a violation of school ordinance case as well.
That's from years back, like years ago.
Both of them are set for trial, I believe, on the 15th of April.
But let me speak back to Mr. Bowman so I can just make sure of everything. So I think he was just aware of just the one.
This trial is a.
All right, let me see which one. What's the 15th of April at 9 a.m. School ordinance is a trial, and disorderly conduct is that's set for a trial date as well on that date. All right, I'll pass the matter.
For Alexander.
All right, thank you, Ron.
He's here now.
I know that, but do you want him to go back to Judge Holder's date?
It doesn't matter what they do. If they want us to keep him, we can keep him. But he showed up here inadvertently.
This happened a little earlier today, so we're a couple hours behind. Who's that voice we're hearing in the background? That one.
All right, anybody ready? Let's go past the matter. Let's go back on the record.
Tiana Gunn is ready.
Let's go back on the record.
I've been ready.
I'm ready.
I was born ready.
I know everybody else is ready, but I'm talking about attorneys. Go ahead, Ms. Harris.
Okay.
Oh, I thought you. I said Tiana Gunn. That was Miss Barrett. I don't know if she said anything.
So we don't need a future trial date if you're going to keep
I didn't, but we're ready on Mr. Oliver. We're just requesting a trial date.
All right.
Oh, okay.
All right, back on the record with Oliver. We'll put the trial date on for June the 3rd, 2025 at 9 a.m. There's nothing further, Mr. Oliver. Best of luck to you. Have a very good rest of your day.
You too. I'm sorry, can I get that date again?
June the 3rd. June the 3rd at 9 a.m.
Okay, thank you.
Best of luck to you. This is the city of Detroit versus Dion Brian Griffin, case number SP 163-1392, counts 1 and counts 2. SP 164-3649, counts 1 and counts 2. SP 16557-931, SP 16558-8601, SP 167007131, SP 169-14961. Appearance for the record, please, Ms. Harris.
We read most of it
Sure.
just minutes ago.
Harris, on behalf of Mr. Griffin, please state your name for the record.
He's not, he's just, Dion Brian Griffin, good morning to you, sir. State your name for the record, please. Dion Brian Griffin, state your name for the record, please.
Dion.
Full name.
Dion Brian Griffin.
All right. Today is the date and time set for a pre-trial. He's got some other cases. You were here the other day. Were you here yesterday?
Yeah.
Well, these consolidate all these matters, Miss Harris. I have I call into the record the two equipment violation cases. He's got a third equipment violation case. He's got a minor in possession of alcohol. He's got a no seatbelt case.
Whoa.
He's got a no proof insurance, no proof case. He's got a failure to use a turn signal, and he's got another improper equipment.
He just needs to not drive right now, I think.
I don't know why these are up to date again, but see if and we can check in the system and make sure that nothing has been adjudicated on there. Hold on.
And I'll also ask if an attorney was requested.
I don't know if this is necessary for it. These are mostly civil infractions. Though I put a minor in possession, I can understand that. Let's see, for that.
We already talked about that last time.
I have not seen that. That's scheduled for trial on 4/11. Did you ever get a contact? The attorney ever contact you?
Yeah, I think.
He doesn't know what's going on. All right, Ms. Harris, come talk to him.
Somebody helping him. Maybe she can come back and answer those questions, but we can go into a breakout room. Thank you.
Come on, please. Pass the matter.
This is a mess. Holy cow.
All right.
Who's ready? Who's ready? Who's up?
Miss Baird, let's go back on the record with Gunn. I've given you an opportunity to speak to counsel. What's your client want to do?
Judge, she wants to accept that plea on there.
Ms. Gunn, is that what you want to do?
She's muted. Oh. She got to unmute, Miss Gunn.
Miss Gunn. Got to unmute.
Oh. Miss Gunn, you got to unmute yourself.
Is she there? Ms. Gunn, you have to unmute yourself. I sent you the prompt.
Miss Gunn has stepped away from her phone. She thought this is not my circus, not my monkeys.
Anybody else ready? All right, let's, Ms. Gunn, your attorney says you take the deal.
Yes.
All right, can you raise your right hand, please? You swear or affirm to tell the truth, whole truth, nothing but the truth?
Yes.
Or you can put your hand down. Do you understand the maximum possible penalty for this offense is 93 days in jail and or $500 in fines?
Yes.
You understand that you have an absolute right to a trial?
Yes.
Miss Barrett went over your other advice rights to break our room, did she not?
She did.
You understood those rights?
Yes.
Any questions about those rights?
No, sir.
You know, by taking the deal, you're going to give those rights up?
Yes.
Has anybody offered you anything other than what's been stated in the record?
No.
Let me draw your attention back to September 11, 2022 at around 10:17 a.m. in the city of Detroit in the area of Connor and Forest. Did you have an occasion on that day to come encounter with Detroit Police Department?
Yes.
You were operating a motor vehicle?
Yes.
Officer asked you to produce a valid driver's license?
Yes.
You couldn't do so, could you?
No.
And why is that?
I had a valid license. It was just canceled, but it wasn't suspended.
How's a license valid and it's canceled? I don't understand.
Yeah, that doesn't.
It was canceled. If you look at my driver's record, you can see that it wasn't suspended.
How are you today?
Good.
I'm the order. I got the proof.
Mr. Bruin, you're interrupting me again, sir. You're saying two different things. You're saying that the license is valid, but it was canceled. So that means it's not valid, right?
Okay, it wasn't valid.
Canceled is worse than
Am I missing something?
No.
All right. Find your client guilty of the amended count of allowing a $240 fine off the lease upon payment. When can you pay it?
Within the next 30 days.
Come back April 25th, 2025. I'll mark the file about payment plan. Do one of two things. Pay it, we'll dismiss the case, or get into a payment plan before April 25th. Pay it. Then he did that kiosk in the city of Detroit. We told you none of those did that after your phone, or you can come on down to the courthouse and pay it first. Those are the two best ways I can tell you to pay it, Ms. Gunn. If you don't have anything further, April 25th, next court date at 8:25. That's up to you, man.
Okay. One more question. I can pay it online. I'm sorry.
You can, but it takes a long time online.
The process.
The DAT, it goes through instantly, and the other ones go through, and being in person goes through.
We need the money now. We need the money now. Bring it down to
Okay.
cash.
Okay.
To the
Thank
judge.
you.
Great day.
All right, bye-bye.
Barrett. Officer Allison, Barrett, be safe out there. Miss Barrett's gone. All right.
Thank you, Judge. You too.
All right, Mr. DiMaggio, who's your client? He's still, you go back in the 4, I guess, Mr. Bloom. I don't know what he's doing.
All right, I'll see if I can find him.
He's in the 4.
Okay.
4 more likes.
They
We
say
hit
about
1,000.
And we can keep him and, I guess because he's not doing his report back to judge. Pre-trial date.
So it's going back.
No.
So we'll keep.
Yeah, we'll keep.
Okay.
Demario Alexander Jr. on screen now.
Mr. Barry, are we ready on Ms. Lewis?
Ready, Your Honor.
Let's go back on the record with Ms. Lewis. Ms. Lewis, I've given you an opportunity to speak to counsel. Counsel, what's your client want to do?
Your Honor, we seek a bench trial date to return with documents.
Is that what you want to do, Ms. Lewis?
Yes.
All right, I'm going to give you a trial date of June the 3rd, 2025 at 9 a.m. There's nothing further. I wish you the best of luck and have a very good rest of your day.
Thank you.
Okay. This is the city of Detroit versus Linton Lewis. Give me the correct pronunciation, so I apologize.
Lente.
Lente. You need to turn your video on, sir. Good morning to Lente Lewis. Where is he on the docket?
9 o'clock, Your Honor.
All right, let's go with case number SP1259675. One appearance for the record, please.
Elwood S. Berry Jr. on behalf of the defendant. State your full name, Mr. Lewis.
Lente Lewis.
All right. Today is the date and time set for a trial. Officer Borsch, is he here? Did he show up?
I'm sorry, Your Honor. Although it is listed at 9 o'clock.
It's set for a pre-trial.
It's a pre-trial. Yes, it's a pre-trial.
Today is the date and time set for pre-trial, Mr. Harrison. I'm going to put you in a breakout room with Mr. Barry. He's going to get you an updated offer, Mr. Lewis. Keep in mind, if you don't like the offer, you have an absolute right to a trial. And I'll let your client know he, along with this ticket, he got some civil infractions that he never paid. So he already owes the court at least $454. All right, join the breakout room, Mr. Lewis, and speak to Mr. Barry. Pass the matter. All right, Mr. DiMaggio, are you ready?
Ready, Judge.
All right, this is Gutierrez, Najee Gutierrez.
What about the guy with the court right now?
Somebody's got someone mute their phone, please.
Mute your phones, please, everybody.
Desktop with me. My personal one.
Latham, you have to mute yourself.
See you later.
Hey, he's talking to me.
He's talking to me.
You have to mute yourself. City of Detroit versus Najee Alexis Latham. Case numbers SP 1121114, counts 1 and counts 2 and counts 3. SP 1647067, counts 1, 2, and 3. SP 1679780, SP 1679925. Appearance for the record, please.
Oh, sorry. Okay.
Judge, what was the last name of the case you called?
Latham.
What is the last name?
Yeah, it might not be my case. I had Gutierrez.
Gutierrez, Najee Alexis Gutierrez.
Okay. Yeah. Andrew DiMaggio, P45619.
All right. Officer Fitzgerald Harris, good morning to you. Can you put your appearance on the record, please?
What's he doing there? 444?
Is Officer Harris here? He was.
He was.
Officer Harris, if you don't show up, we're going to dismiss this
What
whole
about
thing.
the other officers? Officer Davis here, Margot Davis. I have not seen that officer. Is there any other officer here on Anaje Gutierrez? All right. How do you want to proceed, Mr. How does your client want to proceed, Mr. DiMaggio?
We received an offer from Mr. Bowman that my client, Ms. Gutierrez, wishes to accept.
Is it allowing?
What is that?
She's going to plead to expired plates.
Oh, that's not.
The rest would be dismissed.
Is the excuse me, is the officer here though? Like, I actually
One officer did appear. One officer did appear. So if you want to have a trial, we can get that officer back in here. The other officer did not appear. So essentially, the cases that the officer did not appear, SP 167-7067 counts 1, 2, and 3 will be dismissed. No officer.
And Mr. DiMaggio, did you in fact confirm that Ms. Gutierrez now has proper insurance?
Well, this is expired. Okay, go ahead.
Right. I think that case was dismissed, so she pled to expired plates.
Well, I need to know through you as an officer of court, has she shown you evidence of proper insurance as of today?
I did not see that, but I'm not saying she didn't have it though.
Well, no, then that is not.
I told my lawyer that.
Be quiet, Ms. Gutierrez.
Like,
I'm gonna give you a chance to. You're gonna get a chance to speak. Let them just listen first.
Your Honor, based upon that statement, there's not been accurate evidence that she has good insurance now. We know she did not have good insurance then. So
I don't know she didn't have good insurance then, but here's the deal. Was that expired plate contingent on the fact that she had insurance now? That's the court's question.
That is correct.
Okay, Judge.
So I'm gonna allow Mr. DiMaggio and Ms. Gutierrez to go back in the breakout room and have a conversation. Ms. Gutierrez, direct your questions to Mr. DiMaggio, okay?
Yeah, can I just say something,
Ricky
Judge?
C, thank you so much.
You may.
As part of the negotiation process, I indicated to Mr. Bowman that the officer told her that this case, he would not give her a ticket for it. And as part of the negotiations, he said, well, dropped no insurance. He never insurance.
Contingent get the officer back in here, then, Mr. Get the officer back in here, Mr. Bowman.
Officer Harris?
I don't know where he went.
I'll call him.
All right, I'm going to give you a few minutes to get him back in here. All right.
Judge Corporal Croxton, if you don't mind, Officer Harris is in court in person. He has several courtrooms. He advised us.
Yeah, but he didn't advise me, Corporal Croxton. I give everybody an opportunity. He's got to let somebody know. He's usually here, so let's try to get him back right quick, Mr. Bowman, and then we'll pass it. Ms. Gutierrez, you want to speak to your lawyer in the interim?
I guess that's the only person I can talk to, so that's fine.
Well, go ahead, talk. If you want to talk, what do you want to say?
The thing is that I keep talking to all these third parties. For starters, my lawyer just told you that I said he did not give me no ticket that day. He told me that he saw that I was from East Point. So he did not give me no ticket that day. I did not get no physical ticket. I didn't get nothing. He told me he was going to let me go. I said, okay, and let that be that. Now, a couple days later, I got a ticket in the mail, and they combined it with this other case. Y'all dismissed the other case, and that's cool. But I still don't understand, why do I have to pay anything when I did not get a ticket that day? My lawyer is trying to tell me that maybe they gave me a ticket a couple days later. Come on now. Like, that don't even make no sense. I did not get a physical. I've been asking for the dash cam footage, body cam footage. because it was 2 officers. I did not get a ticket. He went to go run my stuff. He said, you know what? I'm gonna let you go ahead and go about your day. I'm not saying that was right or wrong, but that day I was not supposed to get a ticket. So I don't even understand why they would drop the no insurance, but they wouldn't just drop this as a whole, because I was not supposed to get a ticket that day. Like I said, if DPD was looking out for me, cool. Where I'm at with it is, I told my lawyer, this is what I was trying to tell you earlier. I don't even have that car anymore to even show you proper insurance on it. So if I do have to pay a ticket, because this has been going on for so long and I am so tired of dealing with 36th District, please just tell me how much I got to pay for these expired plates so I can be on my way. Because this is like hindering me. I told you this last court date. Like, I'm not trying to be rude. I'm not trying to be disrespectful. I just really want to get this out the way. I don't feel like I should have to pay anything at all because I did not get a ticket that day. I did not get a ticket that day. I did not get a ticket that day from neither one of them officers. I can tell you how that whole situation went down. I did not get a ticket. But if I have to pay something, my lawyer literally just told me that I'll have to pay for the expired plates. Please, I have been on this Zoom call since 8:30 this morning. Please.
Mr. Fitzgerald Harris, put your appearance on the record, please. Officer Fitzgerald Harris.
Yeah, Officer Fitzgerald Harris, Detroit Police Department, badge 1442.
All right, you heard most of what Ms. Gutierrez said. She indicated to the court that she said that someone out there, I don't know if it was you, she said it was 2 officers, that she wasn't gonna get a ticket. I don't know where, and she's upset about.
And now I'm about to.
Let me talk. I let you talk. No.
Listen.
No.
I'm not being rude because I want you to
talk.
He's an officer from another case.
Don't overtalk me. All right, I'm about to put you out the room, ma'am.
I was just telling you he is an officer.
No,
from
don't
a different
tell me
case.
anything. When I ask you, when I run this show, when I let you speak, you can speak. I let you say everything. You said it about 3 or 4 times over and over again.
That's not him, but okay.
Mr. Fitzgerald Harris, what do you have to say about this?
Your Honor, I caught the tail end of it about working with a partner. I don't work with a partner. I work by myself.
You do.
This last incident, I stopped her for on East State Fair in John R. And
right.
She didn't have any insurance, and the plates were expired.
Right. I'm not being rude, Judge. This is a different case. The case that I'm referring to with DPD was by a school. You are a whole different case.
Mr. Fitzgerald Harris, I ask you, don't say anything, ma'am. When I want you to talk, I'll let you talk. Do not say another word until I let you talk, okay? Mr. Fitzgerald, Officer Fitzgerald Harris, I have a ticket here. Wow. I have a ticket SP 167-9925, count 1. That is a no insurance misdemeanor, and count in SP 167-97801 is an expired plate civil infraction. I also have SP 1121114, counts 1, 2, and 3, a no insurance misdemeanor, a failure to report an accident, and leaving the scene of a property damage accident.
Yes, Your Honor.
Those are so Miss Gutierrez has mentioned something to the effect that she got stopped and maybe she's recollecting one stop and not something that is something that the other. She mentioned that she got a ticket some days later. She didn't get a ticket that day. What is your recollection of it?
Yeah, that's correct, Your Honor. In 2020, for the leaving the scene of the accident, that's under an accident review where I mailed out the tickets after reviewing the accident report for a hit and run accident. The other one, I did physically stop her and issue her the citation for the expired plates, which was February 11th of 2025.
Nurse for God, thank you. 5 gifted
So
members.
now what I'm going to do is I'm going to put Mr. DiMaggio is here representing Ms. Gutierrez. Since now we have an understanding of what tickets you stopped her on, or you wrote her on 2 occasions. You stopped her on 1 occasion, if the court is correct. And in the other occasion, during your accident investigation, you came to the conclusion at some point that it was Mrs. Gutierrez that failed to report an accident and left the scene of a property damage accident in 2020. Those are the allegations. Is that correct?
That's correct, Your Honor.
And that there was no insurance on the vehicle at that time. So what I'm going to do is I'm going to order Mr. DiMaggio and Ms. Gutierrez to go back in the breakout room and have a conversation as it relates to those allegations. And then Ms. Gutierrez, if you have something to say as far as how things went down or what that Officer Harris said to you, then you need to speak to Mr. DiMaggio about that, okay? I don't know where she went. Rejoin the breakout room, please.
Power.
All right, let's pass the matter.
Could I see Mr. Bowman in 4?
All right, Mr. Bowman, 4, please. Let's go back on the record with Mr. Griffin. Mr. Griffin, I'm giving you an opportunity to speak to counsel. Counsel, what's your client want to do?
Your Honor, we actually have some questions for the court. And one of the first ones is, statement is, yesterday, Mr. Waski was representing Mr. Griffin. We're just trying to figure out, is he representing him for all of his matters?
Well, he should be. I don't know. We can get Mr. Waski back in here. He needs to put an appearance on the record. Is there a trial date on this matter? We don't have Deanna Griffin's file. Yesterday.
I believe Mr. Griffin was indicating that there is a court date coming up in April. Is that right, Mr. Griffin?
Let me see if I can put them on here by mistake.
It was yesterday.
Yes.
And that was a trial date?
It's so many.
Let's see if we can get Mr. Waski back in here and make sure that we get Mr. Griffin has an understanding of a good understanding of what's going on.
We've passed 2 hours of deliberation time in the North Dakota case.
He was one of them.
Oh, he wasn't.
Your Honor, at the same time, can we make sure, is it possible to make sure that this is everything? Because he entered a responsible plea yesterday, I believe.
Well, I don't have anything on the docket that he does. Let's see if Mr. Griffin's file is here with me.
There's for God, thank you. They're so good.
I have Mr. Boyaje. I have Deon Griffin. I need Deon Griffin. You see it? No, I have Randy Gardner and Anthony Gray. So let's pass it. And Mr. Griffin, what I'm going to do is we're going to get an understanding of what's exactly going on today and who's representing you. If Mr. Waski is representing you on the one case, he's going to represent you on all of them, right? And if you have that trial date, then we will put that. We'll put the other civil infractions on that date as well. Ms. Nash is going to try to locate the file from yesterday. All right. All right. Let's pass the matter. Brian Graham. Am I being heard?
Yes, I'm here. Yes, we hear you.
That's Bryant.
All right, good morning to you, Mr. Graham. This is the city of Detroit versus Bryant Christine Graham. Case numbers SP 1138398, counts 1, 2, and 3.
Ricky, thank you so much.
1152979,
10 gifted memberships.
Counts 2.
It's huge.
SP 1612630. If there's no objection, I'll include SP 161240062. And SP 1671066, counts 1 and counts 2. SP 1671362. Appearance for the record, please.
Sheriff Harris, on behalf of Mr. Graham, please state your name for the record.
Brian Garcine Graham.
All right. Today is the date and time set for arraignment on the bench. Warrant. Other matters are in warrant status. Was Harris.
For purposes of arraignment, my client stands.
I will enter a not guilty plea on your client's behalf to give your client a $0 bond. So for the record, Ms. Harris, if you have your pen out, I see he's only marked for one improper plate. That's 1138391. Along with that ticket, he got an unregistered, untitled, a no insurance misdemeanor, 3 misdemeanors. He has also another unregistered, untitled, no insurance misdemeanor. He has a defective mirror. He has a driving while license suspended, a 21 to 25 over the speed limit, a no registration, and a driving while license suspended. Oh, that's
a small stack of offenses right there.
I asked Will Brown there to give you some.
Can you put that in?
Yeah, absolutely. Okay.
That's a total of 10, Your Honor.
I count. Can you have that? That's great. All right. That's a total of 1, 2, 3, 4, 5, 6, 7, 8, 9, 10. You got it. Enter not guilty pleas. We have give a $0 bond. Mr. Graham, I'm going to put you in a breakout room. Wait on Ms. Harris to come in and speak to you. She's going to get you an updated offer. Keep in mind, if you don't like the offer, you have an absolute right to a trial. Join the room, please. Hold on, Ms. Harris.
Okay.
All right, let's go back on the record with Mr. Dion Graham. Mr. Graham is correct. Those cases were all dismissed. He owes $175. We're putting that in Dion Graham. Dion Griffin, I'm sorry. My apologies. Dion Brian Griffin. Let's go back on the record with Dion Brian Griffin. He is correct. Those cases were adjudicated yesterday, and he owes $175 on the blocking traffic. We're going to get that in the system right now, Mr. Griffin, all right? And you had a pay-by date on May the 24th, 2025. We apologize for the inconvenience. May the 24th, strike that, April the 24th, 2025. All right, sir?
All right.
Best of luck to you.
Good luck, Mr. Griffin.
Appreciate it.
All right. All right, Ms. Harris, go ahead and speak to Mr. Brown. Are we ready on anyone?
Judge, I'm ready on both of my cases.
Lee, what do you have, Mr. Both of them you're ready on?
Right.
City of Detroit versus Tyrese Lamont Lee. Case numbers Case number SP162085502. Appearance for the record, please.
Frank Masseria, P87848 on behalf of Mr. Lee. Mr. Lee, please unmute yourself and state your full name for the record.
Tyrese Lee.
Am I good to go?
You're good to go.
All right.
Is that Mr. Griffin? You're good to go, right?
Yes.
All right. Mr. Lee, today is the date and time set for a trial. What's your client want to do?
Judge, we will be accepting the offer as to pleading to open alcohol as a passenger in the motor vehicle.
Is that what you want to do, Mr. Lee?
Yes.
All right, can you raise your right hand, please? Do you swear or affirm to tell the truth, whole truth, nothing but the truth?
Yes.
All right, put your hand down. Do you understand the maximum possible penalty for this offense is 93 days in jail and or $500 in fines?
Yes.
Do you understand that you have an absolute right to a trial?
Yes.
Mr. Masseria went over your other advice or rights in the breakout room, did he not?
Yes.
Excuse me?
Did your counsel go over your other advice or rights in the breakout room?
Yes.
You understood those rights?
Yes.
Any questions about those rights?
No.
You know, by taking the deal, you're gonna give those rights up?
Yes.
Has anybody offered you anything other than what's been stated in the record?
No.
All right, Officer Crawford, good morning to you. Can you put your appearance on the record, please?
How you doing, sir? Officer Crawford, Detroit Police Department.
All right, badge number and as you said, Detroit Police.
Badge 904.
Okay, good morning to you. So let me draw your attention, Mr. Griffin, back to September the 7th, 2024, around 2:01 a.m. in the city of Detroit, in the area of 7 Mile and Wentworth. Did you have an occasion on that day to come in contact with the Detroit Police Department?
Say that one more time so I can hear you. The end of it?
No, Mr. Griffin, Mr. Lee, I'm sorry. Unmute yourself, Mr. Lee.
Oh.
Mr. Lee, did you hear me?
No, I didn't. Can you repeat that?
All right, on September the 7th, 2024, around 2:01 a.m. in the city of Detroit, in the area of 7 Mile and Wentworth, where did you have contact with the Detroit Police Department on that day?
Yes.
Were you in a motor vehicle?
Yes.
Did the officer, did you have some alcohol in that motor vehicle?
I don't recall, but I believe so.
Either you did or you didn't. The client, did you talk about this with your client?
Yes, I had alcohol.
So what do you mean you don't recall?
I had alcohol, Your Honor.
What kind of alcohol did you have, sir?
How much?
Probably with some tequila.
Probably. It doesn't sound like he's has a good recollection of having the alcohol.
Judge, we can review the video again in the breakout room if you would like.
Go ahead. Go back in the breakout room.
Can do. And did you want to call Gardner before I go back in there?
Well, is it ready?
It is ready.
And Gardner is set for what? That's Randy Gardner? Yeah.
Randy Gardner Sr.
All right, let's go back. Let's call the city of Detroit versus Randy Lavelle Gardner Sr. Case number SP 11079338, counts 1, 2, and 3. SP 11083351. SP 11281521. SP 162888981. Appearance for the record, please.
That's a lot of cases.
Frank Masseria, P 87848, on behalf of Mr. Gardner Sr. Please unmute yourself and say your full name for the record.
Randy Cortez Gardner II.
Hey, Randy. How you doing?
Second. So this, now let me get this straight. Is this gun violation his? Let's see.
Detroit gun violation.
Date of birth, Mr. Gardner?
Say that again. Date of birth?
Yes, please.
11.
Yeah, the firearms ordinance is his, so if he pleads to a firearms ordinance, then I'll fine him $500, and he will, I do have a trial date set already for April the 11th, Council.
Judge, we were appointed on this case yesterday and requested discovery yesterday, so I'd be asking for a trial date at least 21 days out.
All right, we're gonna redo the trial date for June the 3rd. June 3rd, 2025 at 9 a.m. I'm gonna mark the file requested discovery.
We're waiting for our girl to come back from the breakout room.
3/24/2025. All right. If there's nothing further, have a very good rest of your day and best of luck to you.
Mr. Masseria, can you please text me the ticket number for this gun case?
I don't have your number, Mr. Bowman. I can meet you in the breakout room, though.
Oh, okay, great.
All right. If there's nothing further, best of luck to you. You can go back in the breakout room, Mr. Lee, and see if you can refresh his recollection.
So what do you need from me, Judge? Am I done?
Just need you to show up. You need to keep in contact with your lawyer. June 3rd. That's all.
Okay, so June 3rd. So I can leave out there?
Yep.
Yes, best of luck to you.
Thank you.
All right. Who's ready?
Ready on Mr. Lewis, Your Honor.
let's go back on the record with Mr. Lewis. Mr. Lewis, I've given you an opportunity to speak to counsel. Counsel, what does your client want to do?
Your Honor, my client would avail himself of the people's latest offer, most current offer, to enter a plea to allowing for the driving while license suspended.
Is that what you want to do, sir?
Yes.
All right, can you raise your right hand, please? Do you swear or affirm to tell the truth, whole truth, and nothing but the truth?
Yes.
You can put your hand down. Do you understand the maximum possible penalty for this offense is 93 days in jail and or $500 in fines?
Yeah.
Yeah.
You understand that you have an absolute right to a trial?
Yep.
Say yes or no, sir, please.
Yes.
Do you understand, Mr. Berry went over your other advice or rights in the breakout room, did he not?
Yes.
You understood those rights?
Yes.
Any questions about those rights?
No.
You know by taking the deal, you're going to give those rights
Yes.
up? Has anybody offered you anything other than what's been stated in the record?
No.
And let me draw your attention back to October the 6th, 2021, at around 9:30 a.m. in the city of Detroit, in the area of Gratiot and Otter Drive. Did you have an occasion on that day to come in encounter with the Detroit Police Department?
Yes.
Are you operating a motor vehicle?
Yes.
Officer asked you to produce a valid driver's license.
Yes.
You couldn't do so, could you, sir?
Yes. No.
And why is that?
Don't have one. I ain't never had one.
All right, very good. All right, find your client guilty of admitted count of allowing $240 of dismissal on payment. When can you pay it?
I don't know. I'm in the middle of looking for a job right now.
I'm gonna give you 30 days to get it figured out. 30 days, mark April the 25th is your next court date. I'm gonna mark the file allow payment plan. Come back on April 25th, either have it paid or get into that payment plan. At 8:25 in the morning, if you're gonna get it to the payment plan, you're gonna need to come down to the courthouse and get
They're
it to
still
the payment
deliberating.
plan. If you're gonna pay it at any DivDat kiosk in the city of Detroit. I'm told you can upload to DivDat app to your phone, or you can come on down to the courthouse and pay it. If there's nothing further, I wish you the best of luck on the job, sir, and have a very good rest of your day, all right?
Yeah.
Yes.
City of Detroit versus Michael Henry Gruen, case number SP 1641973, counts 1 and 2. Appearance for the record, please.
Elwood S. Berry Jr., on behalf of the defendant. State your full name, Mr. Gruen. Gruen?
Michael Henry Guerin.
Guerin, I'm sorry. Mr. Guerin, today is the date and time set for a trial. Officer Andrews, good morning to you. Can you put your appearance on the record, please?
Good morning, Your Honor. Officer Andrews from the 3rd Precinct, Detroit Police Department, badge 111.
I read it. I could see it on his shirt.
Okay. Today is the date and time set for a trial. Get Mr. Guerin an updated offer. Keep in mind, Mr. Guerin, if you don't like the offer, you have an absolute right to a trial.
Yes, Your Honor.
And Your Honor, we're referring to Michael Henry Guerin?
Yes, we are.
Thank you.
All right, let me put you in a breakout room, Mr. Guerin, and speak to Mr. Barrett. Just pass the matter. All right, let's go back on the record with Mr. Brian Graham. Mr. Graham, I've given you an opportunity to speak to counsel. Counsel, what's your client want to do?
Yeah, we're respectfully requesting a trial date.
Jury trial.
All right, trial date is going to be June the 3rd. That's what you want to do, Mr. Graham?
Yes.
Trial date is going to be June the 3rd, 2025 at 9 a.m., okay?
Yeah.
All right, any further questions?
No, sir.
Best of luck to you. All right, call Monty Lamb is right there. I don't see it.
Right here.
Do an ROA, but I don't have time.
All right, I don't do an ROA. I just put it on.
Our girl should be done with her breakout room soon, so she should be back up soon. The one who says
All
she
right,
wasn't supposed to get a ticket.
This is the city of Detroit versus Armani King Lamb. Case numbers SH10009053, SP128-65551, SP157-14151, SP157-69721. There's a speeding ticket. I think it went into default. I don't have any objection for him to be heard if the city doesn't. SP16350-771. Appearance for the record, please.
No objection, Your Honor.
Sherika Harris, on behalf of Mr. Lamb, please state your name for the record.
Armani Lamb.
What's that on the ceiling?
You're just asking, was an attorney requested on this file?
Yes, it was. It has Spanish. Is your number 586-588-6428?
8675309. Sorry.
And you haven't received a call from any city attorney? I mean, an attorney yet? Has an attorney got any contact with you, sir? Mr. Lamb? What happened to him? All right.
He gone.
See Mr. Bowman in 4?
Mr. Bowman in 4, please. Mr. Dupree.
Good morning.
Armani Lamb. Is Armani Lamb there?
Oh, no, this is Larry.
All right. Who's on the iPhone that I just let in the room?
Sorry, Judge, that was me.
Who's your client, Mr. Dupree?
Judge, I was appointed last night for a Jonathan Goljanage.
Yeah, he hasn't. Well, I'll tell you what. I'm going to give you his telephone number.
Ooh.
I believe I have it here. His mom has his surgery. He hasn't checked in. He said he was going to call this morning. Where is that?
I had a Post-it note with his number on here somewhere.
Yeah, if I could get the number, if we could just adjourn. I don't want to make him call in if he's at the hospital for his mom. If the court's okay with that.
I don't see. Where did I do with that? Yeah. Oh no, I didn't get his number. Did I didn't. Well, yes, it's a number here. No, I didn't get his number.
Does the court have an address for him? Because if we adjourned, I could just send him a letter.
Yes, the court does have an address, and the address is.
The address is 123 Sesame Street, Anywhere, USA.
Zo Court, Judge.
Say that again.
What was this? What was the street name?
It was Sesame Street.
RENZCT 1026 or 808.
Judge, with the court.
Let's call City of Detroit versus Jonathan Goljanage, case number SP164-64991. Counts that's counts 1, 2, and 3. In the state of Michigan versus Goljanage, case number SX4257396. Counts 1 and counts 2. Appear for the record, please.
Matthew Prepaid 0132 for the defendant. Judge, I would ask the court to waive his appearance. He had informed the court yesterday that he had a family emergency that required his attention.
We will waive his presence today. Unfortunately, I don't know how I missed not getting a phone. But what we'll do is we'll give him a intro date of 5/29/2025 at 8:30.
May 29th.
Thank you, Judge.
Time. Right, Mr.
Anything
Dupree?
else?
No, Your Honor. Thank you, Your Honor.
That's Golden.
Good day, Judge.
May the 29th, 2025 at 8:30. All right. Best of luck to you, Mr. Dupree.
He's already gone.
All right. On the iPhone, sorry, I just let you in the room. What's your name?
Tavon Lawrence, Your Honor.
Say that again, Lawrence.
Yes, sir, Your Honor.
Good morning to you. All right.
Approaching
You
2.5
ready on
hours.
anyone?
2.5 hours of deliberation.
What about Michael Galvin? We took care of him a long time ago.
Long time.
Okay. What about Michael? What about Michael? Is that Gordon?
Golden, Michael Golden.
Golden?
Yes.
It says set for trial.
I'm not sure. This is my first time logging on.
And we're going to get you right quick, sir. Hold on, give me a second. Any of the attorneys ready?
Judge, I'm ready on the lead.
Mr. Lamb is back.
And Mr. Maria is ready.
All right, who are you ready on, Ms. Harris? Ms. Harris?
We were discussing Mr. Lamb. He fell off. I think you said an attorney was requested.
Can we get an attorney for Lamb, Armani Lamb?
And he's in the waiting room here.
All right, so let's do this. Let's call the city of Detroit, Ms. Harris.
Just
versus Michael Golden, case number V130242223, V130243323.
Somebody just flushed.
237556101, SP1474844 counts 1, 2, and 3, SP1539842 counts 1 and counts 2, SP1551126 counts 1 and counts 2. SP1613564 counts 1, 2, and 3. SP1685721 counts 1, 2, and 3. And SP1685799 appearing for the record, please.
That's a lot of cases.
Sherika Harris, on behalf of Mr. Golden, please state your name for the record.
Michael Edward Golden.
For purposes of arraignment, my client stands mute.
He's got a lot of cases.
I'm going to enter not guilty plea on your client's behalf. Give your client $0 bond. So the last 4 cases are a driving while license suspended, Ms. Harris, a no insurance misdemeanor, open alcohol in a motor vehicle driver, and an improper plate. Get Mr. Golden an updated offer. Keep in mind you have an absolute right to a trial if you don't like the offer, Mr. Golden. I'm going to put you in a breakout room with Ms. Harris, have a conversation with her, and let us know what you want to do when you come out, all right?
Thank you.
Your Honor, I do understand that it's show cause. I'm just wondering, was an attorney ever requested?
I don't have the file in front of me, so I don't know that. But I doubt it. If it's show cause, he missed the date, he probably went. It probably, if it wasn't attorney requested, then it probably is long gone now. So we'll check the file when we get it. All right, Mr. Massera, are you ready on your client, Mr. Lee?
Yes, we are, Judge.
All right, let's go back on the record with Mr. Lee. Mr. Lee, I've given you an opportunity to refresh your recollection. What does your client want to do? Is his recollection reflected?
Judge, yes, I'd like to apologize. I didn't adequately review the discovery with my client. I believe he can go forward with the factual basis now.
All right. So Mr. Lee, I don't have it, but, oh, here it is. I lost him. I'll take it up. Oh. No, I printed it out. Okay. All right, I might have it. I have it. So, okay. All right, Mr. Lee, do you understand now? Did you have some alcohol in this vehicle at the time?
Yes, sir.
Yes,
What kind of alcohol did you have?
Tequila.
And was it open?
Tequila. Yes.
And it was some in the container?
It was like a cup.
All right, I'm going to find your client guilty of the amended count of open alcohol in a motor vehicle passenger. $240 is going to be the fine. I'll waive any warrant fee. And when can you pay it?
I will need a little time, Judge. Can I get like 60 days? I want to make sure
I'm gonna give you 30 days. Pay it, and I'm gonna mark the file allow payment plan. So either do one of two things: pay it within 30 days, or get into a payment plan. You're gonna have to come down to the courthouse and get into a payment plan. I mark the file allow payment plan. All right.
All right.
Anything further, sir?
Yes, I wanted to ask one question. The officer that y'all had on there, I don't think that was the officer that pulled me out the car.
Did you talk to that about? Did you talk to that about that with Mr. Masserati?
No, it just came. I had forgot to ask him that, but I wanted to ask him that. I don't think that was the officer that pulled me out.
I can go into a breakout room and talk to Mr. Leo a bit further. Are we free to go after that, Judge?
Go back in the breakout room. You're free to go.
To the breakout room.
If he's okay, you're free to go.
Understood.
All right, go back in the breakout room.
Okay, where's our girl? Is she back?
All right, let's see where are we now? Let's go back on the record.
Bless you.
Breakout room, Mr. Lee. All right, let's we're back on the record. What's going to be if there's any resolution here?
Is it faster?
Mr. Berry?
Ready, and Mr. Guerin, Your Honor. And there is
is there any resolution, Mr. Berry?
Yes, Your Honor. My client is prepared to enter a plea to allowing, as provided by the prosecutor.
Is it faster to work 17 cases at once?
Yes, Your Honor.
Can you raise your right hand, please? Yep. Do you swear to affirm to tell the truth, whole truth, nothing but the truth?
Yes, sir.
All right, you can put your hand down, sir. Do you understand the maximum possible penalty for this offense is 93 days in jail and or $500 in fines?
Yes, sir.
All right, you understand that you have an absolute right to a trial?
Yes, sir.
Mr. Berry went over your other advisor rights in the breakout room, did he not?
Yes, Your Honor.
You understood those rights?
Yes, I did, Your Honor.
You have any questions about those rights?
No, Your Honor.
You know, by taking this deal, you're going to give those rights up?
Yes, I'm aware of that, Your Honor.
Has anybody offered you anything other than what's been stated in the record?
No, Your Honor.
Someone just flushed again?
Let me draw your attention back to November the 7th, 2024, around 3:20 p.m. in the city of Detroit, in the area of Woodward and Cat Street. Did you have an occasion on that day to come in encounter with the Detroit Police Department?
Yes, Your Honor.
Were you operating a motor vehicle?
Yes, Your Honor.
Did the officer ask you to produce a valid driver's license?
Yes, he did, Your Honor.
And you couldn't do so, could you, sir?
No, Your Honor.
And why is that?
It was suspended out of Pennsylvania.
Very well. I'm going to find your client guilty of the amended count of allowing, stipulates the proper cause and dismiss the other matter.
So stipulated, Your Honor.
All right, $240 will dismiss upon payment. When can you pay it?
I can pay it today.
All right. I'm going to have you back on Friday just to make sure that payment is here. We'll review it. What is Friday? The 28th?
Can I do it? Can I do it over the phone, Your Honor?
Because I got a credit card right
here. It would be
here.
best if you did it. I'm sure you can do it over the phone. I'm just going to tell you that the best way to do it is div that kiosk or coming down to the court. To div that kiosk, you can upload to your phone. It goes through instantly. I'll review it on March the 28th, 2025 at 8:25. If it's paid, sir, you come in that morning, we'll dismiss the case, all right? But there's many ways you can pay. I just give the best two ways, okay?
March the 28th?
March the 28th, 8:25. We'll get you out first thing in the morning if you paid it.
Thank you, sir.
By first thing, you mean by 11.
You have a very good rest of your day.
You too. Thank you.
All right. Let's call it City of Detroit versus Dominique Griffin, case number SP 1318261. Appearance for the record, please.
Elwood F. Berry Jr. on behalf of the defendant.
He's been here all
State your
afternoon.
full name, Ms. Griffin.
Make sure you vote in the
He's
poll.
on the phone. Is he unmuted? Did he leave? All right, looks like he left. This is Ruth's iPhone.
Y'all talking about Latner?
Nope.
No, Dominique Griffin.
Still not you, sir.
You got a David Griffin.
No, I know. I got you, Mr. Griffin. All right, let's see who is this. Dominique Griffin. Sterling Griffin. All right, let's pass Dominique Griffin's matter. That matter, I was gonna, Mr. Sterling Griffin, you have to turn your camera on.
Okay, hold on a second. I'm trying to now.
All right, so that matter, I was gonna dismiss Mr. Bowman. He paid a related civil infraction, and he owes another related civil infraction. So he paid a no insurance, and he still owes an expired plate. He was here today.
He was here, but then he left.
Mr. Bowman.
Yes.
Any objection to that?
No.
All right. So he paid one related civil infraction and he owes another one. So we'll just dismiss paid related civil infraction.
Media reviewer voted wrong in the poll, so we're going to end it and solidify it
325
in history.
End it.
It was an incorrect ballot.
Was
not guilty 40,
here.
guilty 34, hung 24.
No. Wow.
Your Honor,
Yes.
can we check, this is on the 9 o'clock trial docket. Can we check the status of Alexis Simone Grant, Grant, officer?
I told them a long time ago, Grant was not here.
Okay, good enough.
Yeah, we talked about that. Let's get Rube's iPhone. Who is Rube's iPhone?
Money Lamb, sorry, my phone had died. I'm sorry.
Armani Lamb. So Armani Lamb, that was you. No, that's not Armani Lamb. Let's go.
Who is you?
What were we doing with Armani Lamb? We were getting an attorney for. So we're still trying to find that attorney for you. All right.
Okay.
All right. Let's go with Gregory Gorey or Gorey.
Hello?
Is that Gregory Gorey?
Yes.
Did I pronounce it correctly?
Yes.
All right. What's your date of birth?
2/20/94.
Sorry about that.
Gorey, case number SP 167-30141 and SP 167-30231.
Someone just flushed again.
Elwood S. Berry Jr. on behalf of the defendant. State your full name, Mr. Gorey.
Gregory Anthony Gorey.
Gorey. Today is the date and time set for a pretrial. Mr. Berry, get that button.
Okay, let me.
Mr. Berry, give Mr. Gorey an updated offer. Keep in mind, if he doesn't like the offer, you have an absolute right to a trial. I'm going to put you in a breakout room, Mr. Gorey, with Mr. Berry. Have a conversation with him, all right?
Okay.
All right, let's pass the matter. Mr. DiMaggio, are you ready?
Oh, yes, Judge.
Is this our girl?
I see. Yes.
I don't think the court shreds very much.
All right, let's pass the matter. Let's go back on the record with Ms. Gutierrez. All right, Ms. Gutierrez, where are you? Where's your client, Mr.
She should be on there.
I'm here.
Here we go.
All right, Ms. Gutierrez, now, do you understand what's going on now, ma'am?
No, I don't.
All right, you didn't, Mr. DiMaggio, you and your client didn't get an understanding?
You know, Judge, it might be best to appoint another attorney on this case.
Well, what's going on?
It was a simple matter of I was just trying to tell you that the last ticket and the last officer that just got on the screen, that wasn't the same ticket that I've been on a docket for. That's all I was trying to tell you. That is a separate matter.
Ms. Gutierrez, I see why you have a problem.
How do I have a problem? Because I'm just telling you that that's not the right ticket.
Because you're not listening. You're telling me what you're on the docket for. I tell you what you're on the docket for.
Okay, so I was confused because I'm obviously on the docket for something new. I haven't been coming to court. I just got that ticket like 2 weeks ago. I didn't schedule a court date for that with Mr. Fitzgerald. He just pulled me over. I know what's going on. It's 3 different tickets going on and it's a lot of charges, but that last one, that's what I have not been coming to you for that. Like, that's something totally separate. That's all I'm literally trying to tell you. I know the ticket that I got from Mr. Fitzgerald, but that is not what I've been coming to you for. I just got that 2 weeks ago.
The SP 6797801, you got that ticket 2 weeks ago, February 11, 2025. Okay. So
right. That's all.
We're back on the record with Ms. Gutierrez. Yeah, okay. So that's not even the most important ticket. The most important ticket you do know about, don't you?
Yes, I do. The two.
So what's going on? Why can't you come to a resolution with this individual?
No, I did.
Stop talking. Mr. DiMaggio, I can kind of see why you can't come to a resolution. Or are you driving, ma'am?
No.
I can see why you can't come to a resolution. But what is, without disclosing your client's confidential information, why can't you work this out for her?
Could I see Mr. Bowman? I've been trying to get in with Mr. Bowman. Yes.
All right, let's pass it again.
It's never going to end.
All right, who are we ready on? Ms. Harris? Mr. Berry?
Ready on Mr. Golden,
We're ready on Glover, Your Honor.
Glover, you're ready on Glover? All right.
We're ready on Golden.
Let's go back on the record with Ms. Glover. Ms. Glover, I've given you an opportunity to speak to counsel. Counsel, what's your client want to do?
Yes, the prosecution gave the offer, if she pleads no contest to the school orders violation, 6-month delayed sentence. She's pleading no contest due to lack of memory. And the other charge will be dismissed. Disorderly conduct one.
Generally, that means you're intoxicated and don't remember.
All right. Is that what you want to do, Ms. Golden?
Yes, sir.
All right. If I enter a no contest plea, it's going to be treated like a guilty plea for sentencing. Courtney Glover. I'm sorry. Ms. Glover. It's going to be treated as a guilty plea for sentencing. You understand that?
This was just earlier today.
Yeah.
Can I get a 6-month date?
Fries are done.
All right. Well, raise your right hand, Ms. Glover. Do you swear or affirm to tell the truth, whole truth, and nothing but the truth?
Yeah.
You can put your hand down. Mr. Ogletree, will you stipulate to the face of the ticket as an accurate factual basis for this no contest plea?
Yes, Your Honor.
And what is the purpose of the no contest plea? What is the legal basis for it?
Lack of memory.
Okay. And will you stipulate the probable cause for the dismissal of the other matter?
We stipulate the probable cause.
All right. For that, I'm going to find your client. I'm going to enter a no contest plea on your client's behalf and dismiss SP 164299941. Ms. Glover, if you pay this matter and before September 22nd, that's going to be your next court date, September 22nd. If you pay this matter and don't get any further trouble as it relates to this, then we will dismiss the case, okay?
Okay.
All right, so come back on September 22nd and pay it at any DID kiosk in the city of Detroit. I'm told you can upload the DID app to your phone or come on down to the courthouse and pay it in person. Those are the two best ways I can tell you to pay it, all right?
Okay.
All right. Well, best of luck to you, man. Have a very good rest of your day.
Thank you, you too.
All right. All right.
Golden.
Let's go with back on the record with Golden. Mr. Golden.
We're gonna hit 3 hours of deliberation here in another 10
All right,
minutes.
let's go back on the record with Golden. Mr. Golden, I'm giving you an opportunity to speak to counsel. Counsel, what's your client want to do?
Oops, Your Honor, I respectfully requesting that counsel be appointed, and hopefully that counsel can do a review and see if possibly Mr. Golden is eligible for community court. Sorry.
Community court?
I think most of these may have occurred in Southwest.
Well, put it this way. I mean, he can do some community service. It doesn't have to be in Southwest, but we'll allow them to do some community service. I need a good phone number. I do see the phone number here. I want to put the phone number on the file, sir. You want an appointed attorney, is that correct?
Good.
And you want a trial date as well, Ms. Harris?
Yes, Your Honor.
I'm going to give you a pretrial date of May the 29th, 2025. I'm also going to put this on a track for trial on June the 5th, 2025. That June to the 5th date may change. What I need you to do, sir, is answer the calls you don't recognize. One of the calls should be that appointed attorney. If you don't hear from that appointed attorney by June the 5th, then we'll get you an attorney appointed on the spot, okay?
Okay, so if I don't hear from an attorney before the June 5th,
Hopefully, you'll hear from an attorney hopefully before May 29th. If you don't hear from that attorney on May 29th, we'll get you one appointed on the spot, okay?
Yes.
All right, any further questions, sir? Come back May 29th and we'll see where it goes from there, okay?
If you don't hear from an attorney, the case is going to be dismissed here soon. Because you asked for
all the same Zoom information.
Okay.
All right. If there's nothing further, sir, best of luck to you. Have a very good rest of your day.
We'll be done long before 6 hours. We're just wrapping up here.
Is this Aisha Grisham? City of Detroit versus Aisha Marie Grisham, case number SP1211109.
Somebody's sitting in the bathroom.
Appearance for the record, please.
Sharon Harris, on behalf of Ms. Gresham, please state your name for the record.
Aisha Gresham.
Good morning, Ms. Gresham. Today is the date and time except for arraignment on the bench warrant. Go ahead, counsel.
For purposes of arraignment, my client stands mute.
Well, enter a not guilty plea on your client's behalf. We'll give your client a $0 bond. Ms. Gresham, I'm going to put you in a breakout room with Ms. Harris. She's going to get you an updated offer. Keep in mind, if you don't like the offer, you have an absolute right to a trial, all right?
Okay, thank you, Your Honor.
Join the room, please. All right, who else is not ready? Mr. Berry is not ready. Mr. Reed, let's call the city of Detroit versus DeMarco Alexander Jr.
Yes, sir.
Good morning to you, sir.
Good morning.
I hear some kids in the background.
Case numbers SP1077. He's not on the docket. We're taking this case from Judge Holmes. SP10771777 counts 1, 2, and 3. SP1220943 counts 1, 2, and 3. S1470806 1. SP1492960 counts 1 and counts 2. SP1592329 1. SP164024 counts 1 and counts 2.
A lot of charges as well.
SP164084 counts 1. counts 2, 21715792, counts 1 and counts 2. Mr. Berry, can you put your appearance on the record for Mr. Alexander, please? He's not here. I'm going to enter a not guilty plea on your behalf, so I'm going to give you a $0 bond. You owe, for insurance no proof, $288. You need to write this down.
Okay.
2, 3 times.
Okay.
Insurance no proof. You owe $288 3 times. You need to pay those. If you pay those 3 times, you'll potentially set yourself up to be eligible for a driver's license. At least you'll have clearances here at the 36th District Court. I'm going to give you a pretrial date of May the 29th, 2025 at 8:30. Pay those ahead of you coming back to court. Go to the Secretary of State, ask for a printout. If the Secretary of State gives you a license, then you bring that license back on May 29th. Secretary of State does not give you a license, and you need to come on down and you need to ask them for a printout. They should give you a printout to everything that's affecting your license. So these insurance no proofs are $288. Now you owe the court a lot more money, but those 3 tickets will give you clearances here, okay?
Okay. Could you repeat that pre-trial date in May for me, please?
May 29th, 2025 at 8:30.
Okay, thank you very much.
And let's go to the state of Michigan versus Demario Antoine Alexander. Case number SX382365051. All right. Not guilty plea. And then you got a lot of other stuff going on here, sir. That's also class P1356837, 1 into the record. All right, that's it. All right, so I'll pay those. It's $388 times 3. You owe a lot of other civil infractions, but
it's over $1,000.
If you take care of those, then you should be able to. You'll at least have clearances here at the 36th District Court. All right.
Okay, thank you.
All right, come back on the 29th, and we'll see where you're at.
All righty, thank you.
Once our girl's case is over, we're gonna bail on this and probably call it a night. I don't know, they're approaching 3 hours of deliberation.
Right. Anybody ready?
They might break here soon.
Okay, for the officers, let's see if is Damon Gardner here or Omar Gladson?
This court's in Detroit,
Alexis
Michigan.
Simone Grant, Taiwan Gray.
Judge is stacking the docket
I do
here.
have David Griffin.
Filling the squares in the Zoom court.
And Stephen Lydell. And Stephen Lydell here. Get Dupree back in here. That's his client.
Good, Taiwan Gray here.
All right, Taiwan Gray is here. So the officers are for Grant. I think I excused them.
Episode 17 and 18 or 18 and 19, something like that.
I don't see a David Gardner. I don't see a Damon Gardner. Corporal Croxton, you be safe out there. Reno, that's Gladson's not here, and that's set for pre-trial. And then Lydell should be here, and that's Dupree's client. So we need Matthew Dupree back in the court.
He got a number on that.
Yeah, I'm sure he does. All right, who are we ready on? Let's go back on the record with Grisham. I've given you an opportunity to speak to counsel. Counsel, what's your client want to do?
Your Honor, we're respectfully requesting a pretrial date, but we're also asking if the court could possibly look over her case file to see if there's anything that would prevent her from getting a valid license.
I don't see anything. It's only these 3 cases.
Go get a license then.
All right, I'm going to give you a pretrial, ma'am, of May the 29th, 2025 If you don't have any further questions, best of luck to you. Have a very good rest of your day, okay?
You too. Thank you, Your Honor.
You're welcome. All right.
Where's our girl?
313-264-3549. Is that person here? Okay, not hearing that.
That's a ticket number, I'm sure.
Girl, Glenn is not. Yes.
This is Martino. I'm currently at work. I work at McDonald's, not DoorDash. My manager would like to know, like, am I going to report
You're
today?
after Gray. You're going to be after Gray. Just give me a few minutes.
Okay.
I got somebody's lunch here, and it's getting cold.
City of Detroit versus Taiwan Devon Gray. Case number SP1647702, counts 1, 2, and 3. SP1647731. Appearance for the record, please.
Taiwan Devon Gray.
Sherika Harris on behalf of Mr. Gray.
Officer Thomas Peterson, badge 5145.
All right, good morning, Officer Peterson. Good morning to you. Day is date and time set for trial. He has 2 state tickets that are due tomorrow, and those case numbers are SX449731A counts 1 and counts 2. That is a no insurance proof and a disregard and a red signal. So I don't, if he wants to resolve those with this, try to get a global offer. I have no objection to that, all right?
Your Honor, was discovery requested or possibly an attorney?
Where's the file? Great. I want it, great. All right, let's pass it. Let's see if we can see if that's happening.
Your Honor, Officer Peterson. And I'm in regards to a different ticket, I believe, for Mr. Gray.
Yeah, you're on here for the open alcohol and motor vehicle driver, unregistered, untitled, no insurance misdemeanor, and improper plates.
Okay, my apologies.
Officer's in a hoodie? Is that what he's wearing? Or is that his coat?
All right, let's see. There was a request for an appointed attorney that did not ever get to the file, I guess. What is your telephone number, sir?
313-926-867-5309.
Let's pass it. Let's pass it and see what's going on with these attorneys. Anita Lamb. We need to get in contact. Let's pass the matter.
Let's go to the McDonald's guy. He's got food to deliver. He's trying to do his hustle. Let him kick him out of court so he can earn some money.
Latner, are you Marcino Latner?
Yes, I'm here. I'm currently at work. I told you I work at McDonald's. My managers want to know, like, how long was this going to take for me to come back to work?
City of Detroit versus Marcino Cartier Latner, case number SP16684-101. Appearance for the record, please.
Sherika Harris on behalf of Mr. Latner. Please state your name for the record.
Marcino Latner.
All right. Day is date and time.
Same thing, Your Honor. Was an attorney
get the file.
Was an attorney requested?
I don't know yet. Let me see. In this case, an attorney was requested. All right, let's pass the matter. Let me get a judge. Let me get Judge Carter on here right now. Give me a few more minutes, Mr. Ladner.
It's like my boss isn't that patient. I've been here for an hour and a half. Detective Vids, congratulations on 13 months. We are in verdict watch, so we're sticking around a little bit later tonight. Over 3 hours of deliberation time while the judge makes a quick phone call. I'm expecting the judge to probably try to either kick him out for the day and try again tomorrow. I think that's the usual thing. Most courthouses do that because they're not open late. We're actually seeing some vibrations, some shaking on the camera. So we might have some action in court in just a moment.
All right, let me pass it. I just emailed me. Is this your phone number, Mr. Ladner?
313-844-9175.
Sorry about that. 8675309.
All right, you can go ahead and hang up, and I'll call you back. 9175-844.
Man,
is it any way I can request a speedy trial?
You're gonna get a speedy trial. Let me get you an attorney first.
All right.
I'd like this to
All
be
right, just
a
go
quick
ahead
version.
and go. Answer the phone when I call, please.
Is it gonna be from like a specific number, or is it gonna be from this number right here?
965-2402. So it's a 965 number, 313.
All right.
All right.
Can I get a speedy trial? Because I've been sitting here a long time. It's going pretty slow.
Is David Griffin still here?
Better be.
Yes, I'm here.
All right. Good morning, David Griffin, City of Detroit. You have a middle name, sir?
Tromel.
My baloney has a first name. I don't know where that came from. Sorry, guys. It's late.
City of Detroit versus David Tromel Griffin, case number SP1637471, counts 1 and counts 2. Appearance for the record, please.
Chair Harris, on behalf of Mr. Griffin, please state your name for the record, sir.
David Tromel Griffin.
Same question.
Here, and I'm going to make the same inquiry. What's the point? Attorney of requested and discovery requested?
Attorney was not requested. So Villanueva, can you state your name for the record? Put your appearance on the record, please.
Hi, good afternoon. Officer Villanueva, badge 3939.
Can you turn your camera on?
I need to turn your camera on, please.
There you go.
Good morning to you.
Okay.
This was early this morning. Before lunch.
All right. Good morning to you. Today is the date and time set for a trial. Ms. Harris, speak to Mr. Griffin in the breakout room. See if you can work it out for him. And keep in mind, you don't like the offer that she's going to present. You have an absolute right to a trial. It has multiple open bottles of alcohol and vehicle. That's what the notes say, Ms. Harris.
Multiple.
Pass the matter.
We'll need to know what every bottle was.
Judge.
All right, Mr. Dupree, you're on Lydell. I haven't seen Lydell.
Josh, she does come back, right?
Stephen Lydell, Your Honor?
Stephen Lydell.
I'm sorry, Judge. I thought that was up on Thursday, but as long as I'm here, I also texted Judge Carter, and she said that I can take anything you want me to take this morning, so that you can have, if you need. I think you were trying to get somebody appointed on cases. Since I'm here, I can handle them.
All right, I need. I have Armani Lamb. Let's take care of Armani Lamb first. Let's go back on the record with Armani Lamb. Are you there, Mr. Lamb?
Yes, sir, I am.
All right. The case is entering without permission, open alcohol in motor vehicle passenger, 16 to 20 miles per hour over the speed limit, no insurance misdemeanor ×2. Appearance for the record, Mr. Dupree.
How can you get
Matthew Dupree, P@0132 for the defendant.
How do you get a speeding ticket and open
Right.
alcohol as a
Mr. Lamb,
passenger?
state your name again for the record, please.
Armani Lamb.
All right. I'm going to put you in a breakout with Mr. Lamb and Mr. Dupree so you can get acquainted with them. Mr. Dupree, I'm going to give you permission to move around. And if you get an offer today, you have an absolute right to a trial if you don't like the offer, okay?
Okay.
Okay.
Mr. Lamb, I'm going to put you in breakout room 5. Mr. Dupree, Mr. Lamb will be in breakout room 5.
Thank you, Your Honor.
Your Honor, what time is Mr. Lamb docketed for?
Mr. Lamb is docketed for.
Who does the prosecutor remind you of? Somebody on Saturday Night Live?
8:35, pre-trial.
Thank you.
Let's pass that matter. Mr. Last time, this is the last time on this case, Mr. DiMaggio.
Yes. Yes.
Yeah. Why can't we have we come to this some sort of meeting of the minds or anything about this?
No, I've gone graciously to Mr. Bowman, and he's explaining the offer again. I've explained it to her. She just won't accept the offer. She just says she wants a new attorney, so there's nothing more I can do for her.
Ms. Gutierrez, you just don't understand how this works. I don't know how to explain it to you any better. You don't have the right to come in here and pick and choose which attorney that you get. The only way that you get that right is if you hire one yourself, or you go to this is a case where you requested an appointed attorney and we got you an appointed attorney. And I don't understand what's blocking the movement of this case. I can kind of see it's you.
Yeah.
So why can't you speak with Mr. DiMaggio and get some kind of understanding about what's going on?
I tried to, and everybody is getting upset with me because I'm asking questions. Like, I keep just being told to do stuff, and I'm not. This last time I just came back into the breakout room with him, the deal has completely changed, and it's something completely different. Everything keeps changing. I don't understand what's going on, and y'all kind of just want me to say okay and just do it. So I guess whatever charges y'all have, just okay, and whatever it is.
No.
It's okay. I'll do it because I don't want to keep arguing and be combative.
Stop. What question do you have?
I don't have any question. Whatever plea is available, I would take.
Mr. DiMaggio, you know something, Ms. Gutierrez, you're a very, I can respect the fact that you're serious about this and you want to defend yourself. That's what you have the opportunity to do today. All right. Now, when you mentioned that the other tickets that you had were tickets that were for 2 weeks ago, a little more than 2 weeks ago now, but I know what you mean by that, a month ago. The way I do it is instead of having you come back and forth to court, I told you on that date, I gave you the case numbers, that those tickets would be subsumed in this court hearing today.
Consolidated.
Now, as it relates to those tickets are an expired plate and a no insurance misdemeanor. Not the most serious charges that we see, and not the most serious charges that you have listed here. I think a more serious charge would be the leaving the scene or failure report or failure report accident, which is a 0-point offense. It doesn't abstract to the Secretary of State. It's just going to be a fine. Well, whatever you plead to will be a fine. But leaving the scene of a property damage accident is the most serious allegation that you have here. And then you have some no insurance charges here. So if you're taking into context the 2 cases that you got last month, those cases are basically going to be subsumed in any offer that you get today.
Okay.
The ones that are the more serious ones that you knew that were going to be on the docket today was the leaving the scene of a property damage accident and the failure to report an accident and the other no insurance charge. And then you had maybe, the other cases are going to be dismissed because the officer wasn't here. Now, what is the final offer that you got for Ms. Gutierrez, Mr. DiMaggio? I've said all that, and now he's gone. Mr. Dupree, I want to give Mr. DiMaggio has indicated that he's not, that he can't work with Mr. Gutierrez. I'm going to give you to Mr. Dupree and let Mr. Dupree talk to you. All right?
Okay.
So she's
one
not
of those
done.
days. All right. Are we ready on Goree?
Ready, Your Honor.
I hear like a water cooler bubbling.
Let's go back on the record with Mr. Goree. Mr. Goree, I'm giving you an opportunity to speak to counsel. Counsel, what does your client want to do?
Your Honor, we seek a bench trial date.
Is that what you want to do, Mr. Goree?
Yes.
Doesn't sound very sure.
He sounds like he's not sure. Are you sure, sir?
Yes.
Give you a trial date, June the 5th, 2025, at 9 a.m. If you don't have any further questions, sir, I wish you the best of luck. Have a very good rest of your day, all right?
Okay. Thank you.
All right. You're welcome. Kathy Lydell.
Yeah, I might just be skipping ahead.
That's me.
Oh.
You missed your day.
Yes.
You can see one eye. I see there.
Kathy Emma Lydell.
Yes.
City of Detroit versus Kathy Emma Lydell. Case number SP 164-89611. Appearance for the record, please, Mr. Berry.
Owen S. Berry Jr. on behalf of the defendant. State your full name, Ms. Lydell.
Kathy Liddell.
All right.
When they say
You're
appearing
not
for
guilty
court,
on our
I
behalf.
thought
Give
more
her
of
a
you had to
$0
appear.
bond. We're going to try this one more time, Ms. Lydell. June the 5th, did you have an attorney that you needed to appoint, that you wanted us to appoint the last time?
Yes. Well, the last time you, I guess, adjourned it because when I was explaining how the situation was, you was like, well, you said no. You said no. We have a discrepancy. She can't plead. I can't plead guilty. I couldn't plead guilty to that. I guess the officer had to be there.
You need an attorney. Hold on. Let's get you an attorney, all right? Before we let you go. Pass that.
Mr. Bowman, could you meet me in room 4, please?
Yes.
Thank you.
Something was disposed of already. It was a sentence.
Where is it?
This is in the Japanese. Minus XX2.
They're disposed. How are they disposed of?
Let me print.
Well, let me look it up.
Okay.
Other stuff open?
Yeah, the other ones were.
All right, we'll just let this dispose of cases go.
Okay.
All right, we might have to call it here. It's getting so
Go back
late.
on the record with Mr. Lamb. Have you had an opportunity to speak with Mr. Lamb?
Yes, Your Honor, I did. I relayed a generous offer from the city, but Mr. Lamb would like a little time for his attorney to be able to get discovery, get up to date on the case. I'm wondering if the court would cancel the currently scheduled trial date and adjourn the pre-trial to give me a little bit of time to get on this.
We'll just give you a new trial date. That'll be June the 5th, 2025 at 9 a.m., okay?
Very good, Your Honor.
All right, Mr. Lamb, you have an attorney now. I hope you got exchanged numbers and information, all right?
Okay. Actually, we did not, Judge. I'm going to move him back in the breakout room so I can get that from
Your
him.
number still 586-5.
867-5309.
Mr. Lamb?
Yes, sir.
586
867-5309.
428, Mr. Dupree.
Got it, Judge. Mr. Lamb, I'll be in touch. You can get out of here.
Okay, thank you.
All right, best of luck. What about the gentleman at work? Okay, take this number down.
Latner.
He's at work. I told him we'll call him, but let's go with David Griffin. Let's go back on the record with David Trammell Griffin.
I've got to bail. I've got to bail. This is so. It's going forever, and it's never going to stop. 3 hours and almost 20 minutes of deliberation time already. That is nuts. This is crazy. A lot of people thought this would be a quicker deliberation than that, but we're stretching into day 2, assuming the jury doesn't stay and work the night. It's rare to find juries that work at night. I'm looking for to see if there's another. Oh, should she come back? Oh, she does. She does. Hang on. Hang on. Wait. We're going to go back just for a minute. Oh, here we go. I'm keeping the timer going. Trust me, I'm watching the clock. It's at 3:20. So.
This failure to report an accident does not abstract to the Secretary of State, does it? Mr. Fitzgerald Harris, Officer Fitzgerald Harris.
This is our girl.
Yeah, I'm not for sure, Your Honor.
Ms. Gutierrez, if you do it again, I'm just getting fed up with you. Leave your camera on. Leave your mic open.
Okay, I just wrote you. Jesus, I didn't know.
Failure to report an accident, I do not believe it abstracts. So I'm not going to fine you for everything. I'll fine you for one of the matters of $240 and $145. I won't fine you for the second misdemeanor. You want to take the deal, ma'am? Neither of the misdemeanors abstract to the Secretary of State. Neither carry points. I'll dismiss the misdemeanors upon payment. You want to take the deal?
So what you said?
Failure to display. That's a misdemeanor. It's a $240 fine. I will dismiss upon payment. That does not abstract to the Secretary of State, and that does not. Go ahead, Mr. Bowman.
Do you mean improper plate? Because failure to display is abstractable.
Yeah, well, I'm sorry. Improper plates. I'm sorry. Improper plates for the no insurance misdemeanor. It's for one of the no insurance misdemeanors. Is the improper plate $240 fine. It will not abstract to the Secretary of State, therefore it won't carry any points, and it'll be dismissed if you pay it. And then a civil infraction of expired plates, $145. That does not abstract to the Secretary of State, nor does that carry any points. And that will be closed out once you pay it. I won't fine you for the failure to report an accident. Now we'll just close that out if you take the plea. You want to do that, ma'am, or no?
That's fine. Yes.
Have Mr. DiMaggio, have you read Ms. Gutierrez, her advice or rights?
I think I could do it right now if you want me to, Judge.
That's
feeling confused today.
Ms. Gutierrez, can you raise your right hand, please?
Judge is going to do it.
Do you solemnly swear or affirm to tell the truth, whole truth, and nothing but the truth?
Yes.
The jury has pizza brought into them.
Do you understand the maximum possible penalty for this offense is 93 days in jail and or $500 in fines?
Yes.
Do you understand that you have an absolute right to a trial?
Yes.
Let me go over the advice of rights. Let me go over the advice of rights. Give me an advice of rights form, please.
The jury had pizza brought in for them. They're still working. 3 hours and 22 minutes on the clock so far. 3:23. We're gonna after our girls done. We're gonna.
Do you understand that if you need a special accommodations, to use to court because of disabilities, or if you require a foreign language interpreter to help you fully participate in court proceedings, please contact the court immediately to make arrangements. You have been brought to court on a misdemeanor charge. You have the following basic rights. You plead guilty or not guilty, or to stand mute. If you stand mute, a plea of not guilty will be entered. You may plead no contest with the permission of the court. To have a trial by jury, to have the assistance of an attorney. Number 3, you have the right to an attorney appointed at public expense if you are indigent, without money to hire an attorney, and if the offense charge requires a minimum jail sentence, or the court determines that it might sentence you to jail. 4, you may have to repay the expense of the court-appointed attorney. In this case, you will not. If you have a trial, you have the following rights: to call witnesses to speak for you at trial. You may get an order signed by the court to require witnesses to come to court, to see, hear, and question all witnesses against you at trial, to be a witness for yourself or to remain silent. If you choose not to be a witness on your own behalf, the prosecuting official may not comment on your refusal to testify. To be presumed innocent unless proven guilty beyond a reasonable doubt. Number 6, if you plead guilty or no contest and your plea is accepted, you will not have a trial of any kind and will give up the rights listed in items 3 through 5 above. 7, you have the right to be released on bond. 8, if you are now on probation or parole and you enter a plea of guilty or no contest, or a finding of guilt is made by a judge or jury, it may result in a violation of your parole, of probation or parole. Number 9, you can be sentenced to jail and fines plus costs. The court will tell you on the record the name of the offense, the mandatory minimum jail sentence, if any, and the maximum possible penalty, including jail fines or both. In this case, the maximum possible penalty is 93 days in jail and or $500 in fines. 10, fines, costs, and other financial obligations imposed by the court must be paid at the time of the assessment, except when the court allows otherwise for good cause shown. If you are not able to pay due to financial hardship, contact the court immediately to request a payment alternative. 11, an appeal to circuit court may be taken within 21 days from the date of sentence as permitted pursuant to MCR 6.625(b). If the sentence includes incarceration with the victim as a spouse, parent, or guardian, or you are or were involved with the victim in another similar relationship. Do you understand those rights, Ms. Gutierrez?
Yes, I do. I just had one more question. That last case that just came up where the officer got on, he told me that I would be able to show, if I show proof of insurance, and the plates weren't expired, I would be able to get that dismissed. That's still not possible to do, because I asked my lawyer that, and he.
Do you have proof of insurance and the plates, ma'am?
Yes.
Show the court proof of insurance and the plates, please.
I don't have it on. I can't bring it up there and show you. How would I show you that right now?
You just hold it up if you have a copy of the insurance.
I don't have it offhand, but could I bring it up to the court by maybe say this week and then?
Nope.
We gotta do this. Possible? Mr. Bowman, any objection for her to bring this proof of insurance and stuff to the court?
I could bring it Thursday if that's possible.
Yes, Your Honor, because I was getting ready to state for the record, while you're reading her advice of rights, she's in whatever car she's in. I'm sitting in the car.
Don't say anything, Miss Gutierrez. Listen, Miss Gutierrez, you gotta let him speak, and then you speak, okay? You're gonna get your tongue.
Okay.
Mr. Bowman. Thank you, Your Honor. While she's been sitting in this car, while you are reading her rights, she has been playing with a phone and unbraiding her hair. So whether or not you spoke those words of it to her rights, based upon the fact that she continued to do all those things, I don't know whether or not she understood or not what you diligently read. That's number one.
Mr. Bowman, I don't care if she's braiding her hair or what she's doing. I read her rights. She indicated she understood those rights. That's the most paramount thing for the court. My question to you is, will you allow her to bring in proper documentation?
I will not allow her to bring it in. All she's done today is show total disrespect for you and the court system. So she gets no breaks.
Mr. DiMaggio.
The judge wants to just get this done. He's got a deal. He's working his way
Where's
through
Mr.
it.
DiMaggio?
And as a matter of fact, Your Honor, if there is another court appearance, I'd like her to be present.
In person. Prosecutor is.
Well, she said there was another court appearance. She said she was going to bring the paperwork down.
Yeah, okay.
So now she gets to bring the paperwork down in person.
The attorney's gone. I don't know what keeps happening. You know,
I'm going to allow you to bring the paperwork in, man.
Over objection.
Officer Harris.
Yes, Your
Officer
Honor.
Harris, I'm going to allow her to bring the paperwork in.
Okay, Your Honor.
Even though I will kind of agree, Ms. Gutierrez, you do kind of exhibit a lack of disrespect. I feel that is not done intentionally because of your passion about the process and things like that. But nevertheless, it's got to be some order here. I think I've given you ample time to speak. But when somebody else is speaking, and when I'm giving somebody else time to speak, it's your time to listen. And I'll give you an opportunity to respond. You can't just jump in and cut people off. You have to take a minute and listen to what they're saying, all right?
Bit of a PETA.
Including me. When
I just want to say I've been dealing with you for months. I was not trying to be disrespectful to you. I literally was just confused and was trying to get the accurate information because what was going on.
There's a way to go about doing that.
I understand, Your Honor. I really do, but I just was confused. That's all. And I'm trying to make sure that my ducks is in a row and that I'm getting the accurate information because to be honest with you still right now, I'm a little bit confused, but everybody is coming down on me because I keep asking questions. So what are we moving forward? I'm just making sure. Hopefully you don't get too upset. You're dismissing the first case. I know. The two with the insurance and the plates. I'm able to, for both of those cases, I am able to bring my plates and bring the insurance in. I know I have to physically come in with that information and I'm good after that.
No, you're still going to plead something because you got a failure report and accident.
I thought that's what you just said you were dismissing. That's why I'm confused.
Yes. I don't know how much I can tell you.
And honestly, I guess this is where me and my lawyer confusion came in at. I said that I would not have a problem with pleading guilty to those charges for the no insurance and the plates. But that hit and run accident, they're saying whatever is going on, I don't know. I told you that I do not know what is going on. They didn't give me a discovery packet. They didn't give me no information. They just want me to plead to this case, and that is not me. That's all. That is the most important. The most important case that you're talking about, I'm trying to tell you that's not me, and I did not do that. I don't know what you're talking about.
So we have to have a trial then. She says that's not.
Fine. That's what I wanted to do initially.
She says that's not her. Listen, I'm going to do this. I'm going to put Mr. DiMaggio, you asked to be off the case. Today. I'm going to let you off the case. We'll put Mr. Dupree on the case.
Okay.
Oh, thanks, sir. All right, Mr. DiMaggio, best of luck to you. I'll see you soon.
Mr. DiMaggio, come get your client.
Judge, if we could throw Ms. Gutierrez in a breakout room so I can talk to her, but can we? I've got two cases ready, I think.
All right, Ms. Gutierrez, I'm going to go just wait in breakout room 5. Now, if you can't get it with Mr. Dupree, then I don't think anybody can help you, okay? All right, so I'm going to put you in breakout room 5, wait on Mr. Dupree, to come in and talk to you, all right?
Sounds good.
Your Honor, if Mr. Dupree needs an assist, I'm more than willing to go in and.
Well, do you want to take the case, Ms. Harris? Do you want to take this case?
I'll yield to Mr. Dupree first.
I mean, if you want it, Ms. Harris.
He's got a whole lot, and Mr. Dupree, he's all the way around the world with cases. And I'm not saying that bothers his handling of them, because I don't think it does, but does it affect his timing sometimes? Maybe a little bit. So what do you want to do?
Take it.
Sure,
I'll defer
you
to Ms.
heard
Harris if you
everything
wanted
that's
to.
gone on, Ms. Harris.
I'll go in and speak with her. I will. I don't have a problem with that.
All right, wait on Mr.
You're on the
I
case.
told her Mr. Dupree is going to be here. Now I'm really going to get it messed up on that because now you. Yeah.
I'll explain it to her.
And Your Honor, just so that I am clear so now that we are having a trial date, all of the cases for Ms. Gutierrez are now in play.
They're
all
pulling the
8
deal.
of them.
They're pulling the
They
deal.
were all in play anyway.
Okay. All right.
All right. So let's pass
All
the matter.
officers appear today, Your Honor?
No. So the other officers didn't appear, so they're not all in play anymore because the officer didn't appear, and we're not going there with that. All right. So let's go with pass the matter. Let's go on the record with Mr. Gray.
Okay.
Mr. Gray, I'll give you an opportunity to speak.
All right, we are done. We're done with that. Oh my goodness, what a deal! Look, we have to wrap things up. We have been, let's see, where are we at? Timer is at 3 hours and 35 seconds. 3 hours, 35 minutes, 30 seconds. We've been deliberating for that long. The jury has pizza brought into them. They may still go all night. I'll keep my ear to the ground. If they come back with a verdict, we'll go live again. But for now, we're going to call it. We're going to call it. I'm pretty sure I'm still married. I'm going to go see if my wife's home and say hi to my kids. So, wow. Someone write the timer down. I'm going to keep the timer going. My time, it looks like Law and Crime has a similar time. They're off by about a minute. So, tonight when you go home, please hug the people you love. Smile at someone, make their day just a little bit better. And please stay safe till we go live again. Possibly tonight with a verdict. If the jury decides to burn the midnight hours, burn the candle at both ends and get some work done while the moon shines. Not with the moonshine, but while the moon shines. So stay tuned. Yes, thank you all. I appreciate everyone who clicked the like button. Once again, we went over 1,000 likes, which I love. Appreciate that. It's a late night, but it's time for bed. But it might not be over yet. I'm calling it tomorrow. I think it's going to be tomorrow. I don't think in 3 hours and a little bit of pizza, the jury can reach a conclusion on this one, especially how the results in the polls that we have done have turned out, where we are split nearly 50-50 on guilt and innocence. So, you guys have a fabulous evening. We'll talk to you tomorrow or maybe sooner. Be good to each other. We'll see you. Bye.